You can hand over your slips. If for inclusion, please hand over your slips. Wait. Yes, hand over the releasing. Hand over the slip.
For upgradation,
Upgradation also, please. All the slips, please hand over.
Release আছে
Upgradation, inclusion, everything, please hand over the slips. Upgradation, right? Upgradation.
Milord, may I be able to mention 18 analogous matter? No,
Yes, please use the microphone.
Milord, 18 analogous matter. It is appearing in the list. Milord, the one my lord coordinator had decided the issue. Milord, I brought the judgment. Milord, if you lost, you can take up the matter. Milord, 900 to onwards 18 matter analogous
What
matter.
is the urgency?
As I since 2021, I am suffering. I am a
No.
poor cultivator. Milord, we took the bank loan. The bank has not deposited the money to the insurance company. That's why I have suffered. Milord. Only one matter.
All 18 are cultivated.
Yes, yes, Milord. Same matter, Milord. It has decided even another. I brought the judgment, Milord.
This will appear on 18th as upgraded matters together. এই 18টা matter অরিত্র
Judgment.
Yes.
May I be permitted to mention a matter?
hand over the slips. Whoever have slips, please hand over.
No, my lord.
Yes,
It may be granted, my lord.
No, I'll come to you. Yes.
Upon notice, I am mentioning the 8 analogous matters denying post-export benefit by the DGFT authority with a retrospective.
You are mentioning for inclusion in the list.
These are appearing at monthly list, my lord, but at much bottom. So
What is the urgency, Mr. Chopra?
my lord knows the post-export benefits. If I can't complete it, the star export house statuses are lost. My lord, I'm waiting for a long time, my lord.
No, there are other more urgent.
No, my lord, I'm not saying anything. My lord, if these matters can be placed together on daily list on any day, if your lordship, whenever your lordship deems fit, any day, my lord.
Very well, 20th. Please just hand over the.
My lord, I'm giving the copy of the notice and the slip with the serial number of monthly.
Yes, you are going to mention something. Yes. Sorry.
My lord, may I be permitted to mention a matter, my lord? Wherein, my lord, a notice.
What are you wanting?
My lord, the order of the district magistrate is enforced by the executive magistrate.
You want to leave to do what?
Yes, my lord.
For it to appear tomorrow?
Yes, my lord.
Hand over. Leave to the other.
May I have your lordship's kindly?
Yes, Mr. Bose, I'll come from that side. Yes. Whoever have slips, hand over. Need not mention. The rest of you, yes?
I have urgent matter, my lord, because my lord, one of the member of our bar, my lord,
Hand over a slip. Yes, Mr. Mujumdar.
seeking leave to move an urgent matter, not 2 matters, in fact, not by 7th, the appeal before the under the RERA will be dismissed.
Very well. 6, these will appear at the top of the list.
Grateful to you. Lord.
Yes.
May I have
You?
I am seeking a leave to urgent matter, my lord. I have filed, my lord, my renewal application for passport.
File in due course.
My lord, 11th is my lord, travel ticket to, my lord, the petitioners are intending to perform, my lord, Hajj. And 11th is the ticket, my lord.
Very well. 7th at the top.
My-
Leave to the other 7th top as well. Yes, Mr. Bose.
May I have your lordship's kind leave to mention item 1134 of the combined list. This is a hearing matter. Your lordship will recall this is the matter regarding the constitution of the Waqf board. Where
the-
it,
I'm
of
sorry.
the Waqf board.
Walk up. Yes.
Now, there was a challenge to the appointment of a person
Yes.
who is required to be an expert in theology. We had said this gentleman has no connection with theology. Now, initially an objection was taken that there was only a mandamus sought, no certiorari amendment application was filed and allowed. Thereafter, matter is appearing before your lordship. My lord, the entire constitution of the board is illegal today. Any
Constitution
day,
of the present
Waqf
Waqf
board.
Hearing matter, it is very difficult to take up, Mr. Bose. The
I know,
vacation more
I
so.
know, my lord, I appreciate your difficulty, but
difficult.
it is any day, your
Let
lordship.
it appear under the upgraded heading on 19th.
Very well,
Upgraded heading.
very well, obliged.
19th.
My
Yes.
lord, my lord, if my lord kindly takes up the contempt applications, my lord, any day.
Right now, not possible.
Not possible.
Not possible. I'm sorry.
My lord, subject
My
to
lord,
my lord's
may I be permitted to mention, my lord, a writ petition of 2020 challenging the
For inclusion.
for inclusion in the list, my lord.
Hand over. Hand over a slip.
Very well.
Maybe
My lord,
mention one matter.
All of you who were not there when the mentioning started, please hand over your slips. Whoever have the slips for
apologize.
inclusion and upgradation, please hand over the
I
slips.
apologize, my lord. The urgency is that, my lord, the fresh notification for sale, auction sale is there for 4th
No,
of
not
January.
immediately then. Not immediately. Sorry.
Very well.
My lord, may I be permitted to mention, my lord, my matter pertains to remission, my lord. He has been serving life imprisonment 19 years here.
Hand over a slip.
My lord, served, my lord, kindly takes it up, my lord.
May
He's an aged man, my lord.
may I be permitted to mention one matter, my lord. Your monthly is 739. The lady herein is a unfortunate widow, and she lost his husband during
What do you want?
the
What is the relief sought in the writ petition?
the relief to disburse the amount, the check, my lord.
We will upgraded matter on 12th upgraded.
Forget also slip, my lord. In respect to item number 106, 103, my lord, the petitioner is a learned advocate of the court below, my lord. He submitted some bill, my lord, that has been kept to his hand, my
No,
lord.
Mr. Ahmed, not right now. Not right now.
My lord, some financial interest is
No,
involved, my lord.
there are much more urgent matters. Call on the list, please.
My lord, may I seek my lord's
Further mentioning. Thank you. Call on the list.
Do we mention item number 1 for non-prosecution?
Yes.
Lordship, I am for the.
I'm for the state.
Lordship, I am for the
Don't want to
CAC.
proceed with the matter?
Yes, your lordship, because should I elaborate?
You may not, whatever, your choice.
Yes, your lordship, in 2005, a writ petition was filed with regard to electricity matter.
Oh, your cause of action has become infructuous. So that,
Yes, your lordship, because the old matter is again active, it was mentioned in the other court.
well, I'll just record it has become infructuous. You're not
But
proceeding.
your lordship, what the opposite party is doing to state the court in a different way, they are going to that court during that matter and stating that we, in order to misguide the court, has filed this matter and kept it alive.
So I'll dismiss it for non-prosecution. You have written instruction for that. You don't have written instruction. Should have always take written instruction from a client in these matters.
Okay, your lordship, then tomorrow.
Yes, yes. Don't come for your own protection. Later on,
It is
there will be a
not
bar
for my
council.
protection, because electricity connection is still.
Your protection as an advocate. Later on, the client will change the advocate, and you'll face a bar council. I did not ask him to non-proceed.
Okay, your lordship.
Come back tomorrow. Do you mention tomorrow?
Much obliged.
Do you mention? Please come back tomorrow. Come back tomorrow. Yes.
Item 2 for correction.
What correction, Mr. Shah?
My lord, probably, my lord, I was not able to express myself. My lord, we have not filed any application under section 14, my lord, paragraph 1, my lord.
Yes.
We have stated in our petition that the loan accounts are still subsisting. We do not have any problem with our borrower presently.
You are the SBI.
I am the SB.
I don't understand.
My lord, that is the
Petitioner number.
property in question.
You have not taken out any application under section?
No. Cholamandalam, the finance company, they are claiming that they are having a mortgage over that property in respect of some other borrower. Property is the same. On 20th November, they wrote a letter to us stating that they have obtained an order.
Then the entire order has to be recalled, Mr.
No, my lord.
Cannot be done like this.
Only this portion, my lord.
No.
Because
The
that will
entire
not-
order changes.
That will not affect, because my prayer was very limited. I wanted a breather because on 20th I came to know that learned CJM has passed an order of under section 14. I wanted to move the learned DRT. My lord given the liberty on the very next day. I have also filed an application before DRT, pursuant to my lord's liberty that I have got. That was my main prayer. That was taken
It has
care of.
been recorded that you submitted that when you were on the verge of obtaining an order under section 14, you did not file any application.
That only, this much only. That will not change the entire nature and character of the order. Because my prayer was that from Cholamandalam, I came to know on 20th that they have obtained an order from the learned CGM under section 14. So I wanted a breather to approach the DRT1. And my lord was pleased to give me that breather. It is still 7th. My lord's protection is still 7th. On the very next date, I filed the essay application before the DRT1. And I served them tomorrow is the date fixed before the DRT1.
So will it suffice if I say that on the verge of, not on the verge of obtaining an order, but on the verge of filing an application under section 14? After that, you filed an application under section 14.
The cause of action for us to file any application under section 14 will not arise because the loans are still good, subsisting. I do not have any.
Then the order has to be.
I do not have any problem with my borrower, my lord. My lord, kindly appreciate.
Even then, the premise of the order goes.
No, my lord, kindly see. Cholamandalam is.
File a proper application, Mr. Shah. Learned counsel for the petitioner submits that
before the DRT, my lord.
Oh.
My lord, kindly cease. That will not change the nature and
My
character.
lord, counsel for the petitioner submits that
My lord,
the petitioner number 1 bank had not filed any application under section 14 of the SABYASACHI Act as recorded in the order dated November 28, 2023. Full stop. However, comma, the said correction as sought for by the petitioner may change the complexion of the order. Full stop. Accordingly, in the event the petitioners seek an order of modification of the order stroke correction, comma, liberty is granted to the petitioners to file a proper application with such prayer. Full stop. Till then, comma, however, comma, the order dated November 28, 2023 remains as it is. I've given you liberty, you can take out an application, but the order remains otherwise. Next.
My lord, review application will be better.
Top item,
probably.
Whatever.
item
Yes.
3.
May it please. My lord, this is that matter, my lord, wherein forged stamp paper issue.
You want to pay the amount.
No, my lord.
My
You
lord,
want to pay the amount.
yes.
Yes, what is your stand?
My lord, last occasion.
Where is the document?
Yes.
My lord, your lordship passed this
My lord-
order earlier, my lord, to produce the.
A copy of the document has been given to them. Give a copy to them
No, my
also.
No, my lord, this is
They are
the
the parties who are required to go through.
this is the draft copy, my lord. This is we
No, no,
do
I
not-
want an actual copy of that.
actual copy is not possible because, my lord, I only have a copy of the IGR.
IGR was not annexed to the writ petition.
My lord, this is not the RGR. It is a, my lord, searching report.
Because kindly comes to page 30.
You have a copy of the IGR, show him.
Yes.
Show your lord friend.
This is the searching slip, my lord. This is not the IGR. My lord, last occasion, your lordship passed this order to produce the original.
Yes, you have to
certificate,
produce
my
that Nirupan Patra.
My lord, may I explain, my lord? My lord, this was a deed on a registered on a forged stamp paper. Therefore, it was confiscated. Now, kindly
You are
comes
required
to
to produce a copy of
kindly
the
comes to
consent.
page 30 of the writ petition, my lord.
Where is a copy? There was a direction on you to produce a
Right.
copy of the settlement date.
My lord, I have a draft copy.
No, draft won't do. You have to give a copy.
My lord, I cannot have an access.
Then relief can be granted to you.
In para 3, my lord, he stated, my lord.
My lord,
Let you argue. We are speaking together. How can all of us speak together? Yes, please
my lord,
continue.
I had applied under Right to Information Act,
Yes.
under which I have been.
Okay, let us come to page 30. We are
page
placing
30,
this
my
one.
lord.
Yes. So you restrict your prayer to this deed.
Yes. And the contents of the deed is what I have in the draft copy. I was a minor. I was 2 years in
You
1990.
stated here in the reply that it is registered in this office on such and such date. Please come to page 30.
Yes.
The first reply. Your query was whether the receipt dated such and such is registered.
Yes.
The answer is registered in the office. It's an already registered document.
Yes.
After registration, where is the
After
scope of-
registration, this false stamp paper was invented. I mean, it was discovered.
So registration is still there.
Registration is still there.
So
But the stamp paper is the revenue to the government. I am
if registration was refused on that ground, the orders passed in the other matters, there the registration was refused by the registrar or the sub-registrar on the ground that the stamp papers were found to be forged. In your case,
identical. Mine is
No,
identical.
it is not identical. Your document has been registered. That is the reply. Already registered. After that, you are facing a
All
police
other
case.
documents, my lord, were also registered. But subsequently, the government found out on investigation that these were registered.
The registration does not automatically go. You are suffering a police case. Please come to page, read out page 30, please.
Yes, my
The
lord.
first reply. Please read out the reply.
The reply is
Reply number 1, please read out.
The serial number such and such, deed number such and such, dated April 30, 1919, is registered in this office on 34/1990 as per office records.
So it has already been registered.
yes,
What is
that
the
is the
scope of
case.
re-registering it?
No, I'm not asking for deregistering. I'm asking, the case with all other, the facts were, after registration, this forgery was discovered. And therefore, it was a loss of state revenue. That's why orders were passed by this honorable court that the petitioners may be allowed to pay revenue afresh
You want to produce the document for re-registration. There is a registration. You don't understand. Even if the stamp is forged,
Uh-huh.
the registration has been completed before that. In those cases, registration cannot automatically go. If there's a forgery, you are suffering a police case, you face there.
That is pending.
The registration is already there. It is a registered document. Where is the question of directing them to register the document again?
But I will not get a volume copy also. That is the difficulty.
Why not? I mean, tell me why.
My lord, would kindly direct the registering authorities to provide me a volume copy.
Provide a
That-
volume copy.
That will.
No, my lord.
Yes.
not?
Suppress the material facts, my lord. In paragraph 3, my lord, earlier I submit before your lordship. Khudiram Bagh is not the owner of the land, my lord.
Registration officer, registering authority is not required to consider that.
My lord, kindly consider, my lord, paragraph 3, my lord.
Yes.
Earlier I submit before this.
So you must have a copy of that document. Show us that
Yes.
copy. How are you ascertaining that it is
Yes.
by some other
My
person?
lord, I got from the authority, my lord, 173. 173, my lord.
The
he
deed
said-
number tallies.
No, my lord. Khudiram
What?
Bagh
No, my lord. He is referring to a particular document
document
with a deed number.
number.
If the deed number, your deed number is some other deed, then there is no nexus between that and this.
My lord, he stated in his application, my lord, serial number 2096, deed number 2094. My lord, my lord, Kajol Rani Bagh is the owner.
That
of
is
the
what
land.
I'm asking you. The deed number is telling with your deed number.
Yes, my lord.
This deed number is
and
telling, but the
yes,
name
yes.
is different.
Yes, my lord. This
And
is the
Kajol Rani Bagh is my mother.
So
I
what?
was minor at
So
that
what?
time. Yes.
No.
He had executed.
my lord,
on
he
my
stated in
behalf.
the application, my lord, Khudiram Bagh is the owner of
This
the
is
land.
the
my
draft copy. My lord,
Both of you cannot argue together.
No, no,
Sir,
sorry.
please take your
I'm-
seat.
I'm sorry.
Take your seat.
lord. This deed, my lord,
It is not the way a case is conducted.
I am
Please
sorry.
take your
I'm
seat.
sorry.
173, my lord. This is the
File your opposition. Learned counsel for the petitioner submits that the petitioner is only armed with a draft copy of the deed in question. Full. However, the petitioner was directed to produce a copy of the document video order dated December 1, 2023. Next para. Learned counsel for the respondent authorities categorically submits that the deed of settlement referred to in paragraph number 4 of the present writ petition carrying serial number 2096 stroke deed number 2094 is not in the name of the petitioner. Next para.
father of the petitioner.
Pardon? Not in the name of the father of the petitioner, Khudiram Bagh.
Yes.
Next para. Hence, it is submitted that the allegations made in the writ petition are denied. Next para. The respondents are accordingly directed to file their affidavit in opposition, disclosing all relevant facts by December 15, 2023. Reply, if any, shall be filed by December 20, 2023. When the matter shall be listed on December 21, 2023 under the upgraded heading for passing orders.
Deeply.
Please come back before the vacation, we'll decide.
Fine.
Disclose all your documents in your opposition so that they can give a reply.
ভলিউম কপিটা দিলেন তাহলেই তো
Next.
আরে, আপনার ক্ষুদিরাম বাগ তো execute করেনি রে ওখানে।
Item 4.
Petition
মাইনার ছিল
Fourth, you are appearing? Yes. What
Yes,
is
my
that? What about service? Good service?
Service, yes.
ওটা দাও ফেরত। ওকে ফেরত দাও। Check up whether there is good service or not.
My lord, state is the party. All state respondent, no private.
What is the matter?
My lord, I am an advocate of my lord Bardhaman Court, Purva Bardhaman. My lord, I have protested against some law clerks who used to supply my lord bidi, mobile phone,
Oh,
gaja.
yes, that matter. Yes.
Yes, my lord, to the remand accused persons. I have, my lord, protested. I have sent letters to my lord district magistrate and my lord that is appearing in page number 13 and Honorable High Court Registrar. My lord, thereafter, suddenly an order was passed against me that is appearing in page number 18, my lord, type copy 18A, by banning me totally from the Bardhaman Court, my lord. The district judge, my lord, passed this order without supplying me the copy. But lord, apparently this order is bad. And this order has been posted, all the posters in my lord, entire premises of the court.
Where is the banning order? I don't find it.
My lord, 18A. Kindly
Please
see.
place the order.
Yes, my lord. In sending herewith a copy of the statement of facts in the matter of the complaint, Archana Roy, wife of such and such, in such and such area, with direction not to give any access to Srimati Archana Roy, wife of such and Sudipto Kumar Roy, here is the petitioner, my lord, both of the resident of such and such place, to their respective departments, and not to allow Sri Sudipto Kumar Roy to handle any records, documents kept in their respective courts and
The
departments.
complaint is referred to. In sending herewith a copy, the district judge Purva Bardhaman
Yes, my lord.
is sending to these persons a copy of that complaint. The complaint for circulation among the members of the staff of the respective courts, to their respectively not to allow so that complaint is circulated among the departments.
Yes, my lord.
No banning order is passed
Yes.
against you.
Now, my lord, I am unable to hold any record. I am unable to enter into the court because of this order. My lord, I am totally banned, my lord. No bar association of that court, my lord, not allowing me.
Can we enforce any order if you pass, even if you pass an order? What sort of an order are you
My lord,
expecting? With police help, can I direct you? Because do you practically
I do-
imagine the bar would allow you to go with the police?
I
and
do not
argue
want that.
matters?
I'm
Won't
just
be possible physically.
I'm just praying, my lord. This administrative order may be, my lord, restrained. My lord,
So by virtue of this, you may not be restrained from entering into
yes,
that.
my lord. I am an advocate, my lord. My
No, you
clients
have a
are
right.
there.
Definitely have a right.
Yes, my lord.
Yes,
That's
what do
it.
you say to this?
My lord, very first thing, my lord, I am submitting this writ petition is full of suppression. My lord, the outcome of this, my lord, memo that my learned friend has shown, my lord, there are interregnum event which has not been pleaded. My lord, the complaint that my learned friend is, my lord, referring, my lord, the complaint was gone into, and my lord, the complainant had specifically, my lord, submitted that out of grudge, she has made this complaint against this my lord tout. My lord, kindly consider the report.
This petitioner is a tout, you are saying?
No, my lord. The complainant had made certain allegation against some my lord Muhuris.
Complainant means him or the
No,
others?
complainant is her mother.
His mother?
Yes, is her mother.
She had made a complaint
she
against
had
some
made
touts? Yes.
touts. And my lord,
His mother is also a practitioner?
no, my lord.
She has no nexus with practice?
Practice. Now,
Then?
his allegation is that, my lord, when the mother had made this complaint, thereafter this memo was issued, barring him to, my lord, enter into the, my lord, court premises. Now, my lord, that complaint was gone into by the learned district judge, and the statement was recorded of the complainant, where the complainant had made a specific statement that, yes, I have made this complaint because I have some personal grudge against this Malota.
Complaint means his mother?
His mother.
Right.
Now, Malota, against this person, Malot, several criminal cases were pending.
Against which person?
Petitioner. Several criminal cases were pending, and Malot, he along with his mother having a tendency to make this kind of frivolous false allegations. Everything was gone into Malot. If Malot will see this report.
But there was some cases, my lord, I got acquittal in every cases, my lord.
Kindly consider,
My lord,
this is
political
very
cases,
important.
all those political
Kindly
cases, my lord.
consider this, my lord.
I got acquitted from all cases.
My lord, the statement of the complainant, kindly consider page 5.
Put this on oath. I'll grant you 1 week's time. Put this on oath. You will get 3 days to give a reply.
Lordship.
Learned counsel for the petitioner submits that the petitioner is a practicing advocate of Purva Bardhaman, full stop, in view of certain complaints having been lodged by the petitioner and his mother, comma, against certain clerks, you said?
Yes, my lord.
Certain clerks of the local district court, comma, the petitioner has been restrained from entering into the court premises and conducting his profession within the premises of the Purva Bardhaman courts. Full stop. Next parallel, and counsel submits that the document annexed at page 18, within bracket 18 capital A bracket closed, is being used against the petitioner for such purpose. Full stop. Next parallel and counsel for the respondent submits that the petitioner and his mother are in a habit of making such frivolous complaints. Full stop. It is submitted that initially the complaint which was circulated by the document annexed at page 18 of the writ petition was made by the petitioner's mother, who subsequently a hearing was given to her, upon which she made a statement that due to grudge against certain touts, she had made the complaint. Next para, it is further submitted that there are several criminal cases pending against the petitioner, and the petitioner and cases pending against the petitioner. Next para, counsel for the petitioner controverts the allegation and submits that the petitioner has been acquitted in all such criminal cases. Even a reading of, even a plain reading of the document annexed at page 18 and 18 capital A shows that the same is a mere circulation of the complaint of the petitioner and does not debar the petitioner in any manner. However, since the respondents seek to rely on certain documents which are relevant to the issue regarding the conduct of the petitioner, the respondents are directed to file their affidavit in opposition within a week from date. Reply, if any, shall be filed within 3 days thereafter. The matter shall be listed on December 14, 2023 under the upgraded heading for hearing. Affidavit of service filed today be given.
Great.
Next.
My lord, can it be 10 days, my lord? 10 days.
7 days is enough. Just annex this bunch of documents, write 1 or 2 pages.
Yes.
Yes.
Upgraded matter.
Yes.
Item 5.
Yes, Mr. Chatterjee, what is the matter?
Madam, I have applied for the to obtain a passport for with the intention that I want to visit the Hajj in the year 2024.
Right.
Madam, it is admitted fact there is a criminal case is pending against me. On that particular ground, it was not been granted. I have been asked for to get a release order. Madam, subject to kind sanction, madam, there is a notification. Madam, may I be permitted to place before your lordship?
Why don't you annex these documents to the...
No, madam, subsequently I got this, my lord. And my lord, there is a clearly said
His
that
copy more valid. Yes.
my lord, there is clearly said that section 2, subsection 2, section 6, subsection 2, clause F of the Passport Act has been, there is some condition where the authority can also be grant the passport for particular purpose for a particular year, and I have to make.
Which clause are you relying on?
My lord, kindly come to the next page, my lord.
I'm on the next page.
Yes, my lord.
Yes.
Small a starts from 1, Roman 1, 2, and 3. And my lord, on this particular ground, one of our coordinate bench also passed the order. If your lordship kindly.
You have to approach the criminal court, concerned criminal court.
No, yes, that is a fact, but there is clearly said, even if I have to made a declaration that for what purpose, on during which period of
Please
time.
read out the relevant portion.
Madam,
Just read out the relevant portion.
In exercise of the power conferred by clause small a of the section 22 of the Passport Act, such and such, and the suppression, supersession of the notification of the Government of India in the Ministry of External Affairs number such and such, central government being opinion that it is necessary in public interest to do so, hereby exempts citizens of India against whom the proceedings in respect of offence alleged to have been committed by them are pending before the criminal court in India, and who produced under from the court orders from the court permit them to depart from India from the operation of the provisions of the clause F of subsection 2 of section 6. Then, my lord, it starts that the person to be issued and every such citation shall be issued for the period of specified in order of the court referred to the above, if the court specifies a period for which the passport has to be issued.
Basically, if it specifies a period, then till that period,
Yes.
otherwise 1 year generally by default.
1 year. That is
Subject to whatever.
Yes.
So what happened in your case? You applied, you got an order from the court?
No, from the order
You
of
have
the
to
court,
obtain an order for this. That is a
Malord,
prerequisite.
may be permitted to place for once my satisfaction.
Yes.
That the, on this, one of our coordinates which passed
Yes.
this order, my lord.
Hmm.
But what is Malord, I have been marked it, my lord.
Yes, place it,
So-
please.
Which,
Marked it, should be there.
my lord, may I hand over to this your lordship? And mark, my lord.
Yes.
একটা copy আছে extra? No, no, sad sides. Lordship, the
Find out
page
your
two-
worst copy and give it to Mr. Chakravarti.
no,
He
my
knows
lord,
already, but
I
give your
should have,
worst,
my lord.
most illegible copy to him.
But WPO 2633 of 2022. But page 2 I am placing.
Page 2, yes.
Section 6(2)(f) of the Passport Act deals with the refusal of the passport
Right.
or travel document provided subject to the provision of the Act. Passport authority shall refuse to issue the passport or travel document to a person for visiting for any foreign country on the ground that the proceedings in respect of the offence are pending in a criminal court of India. The notification dated 25th August 1993, which I have handed over to your lordship, which was preferred by the passport authority, makes it clear the central government decided to exempt citizens against whose proceedings are pending from travel restriction in public interest. The notification makes it clear the pending procedure are those in a criminal court, and the conditions of the in the notification with reference to section 6(2) subsection subclause F of the Act. Clause D of the notification provides that the citizen shall give an undertaking in writing to the passport issuing authority that he shall, if required by the court concerned, appear before it and any time during the continuance of in force of the passport to issue. And clause A makes it clear that passport are to be issued to every citizen on the condition provided in the notification. So, my lord, I'm relying on that particular judgment. And lordship, kindly also have a look the next page, my lord. The page 3, it is also written that the petitioner shall also furnish undertaken in writing to the passport issuing authority that petitioner shall appear before the court concerned at any time.
This question did not fall for consideration before that court whether the court's order is necessary. That is the prerequisite in the first part of that of the notification which you are citing.
Yes, your lordship.
I cannot override the law just like that.
But my lord, here also, my lord,
There is a purpose for doing this
Yes,
because
yes.
your trial is going on before a criminal court.
Lordship.
So that court is the best judge of whether you should be permitted to go abroad or not, whether for a particular period or not. So in the first place, that has to be obtained. And the entirety of the rest of it is on the length of that order. I mean, whatever is the length, depending on that.
on the trial court.
Of the trial court. But that is the plinth of the order. This question did not fall for consideration before her ladyship.
But my lord,
And I'll have
subject
to distinguish on that ground. When
That-
Justice
that-
Bhattacharya was
yes,
considering,
that's true.
undoubtedly you are right. No formality to go to the court has been framed here. But this question did not fall for consideration.
No, this is your lordship's own judgment.
No, but it will be very ridiculous if you rely on my judgment and distinguish somebody else's judgment. On the law, on the notification cited by Mr. Chatterjee, I'll do it. Yes, Mr. Chatterjee. I'll give you leave to immediately go before the criminal court and this to be followed.
Short period of time.
With or without consent, Mr. Chatterjee.
Yes, my lord, may I pray for on indulgence, your lordship? Can it be possible, my lord, that if your lordship kindly restrict some time period so that it can be done?
Definitely. When does the Hajj period end? And
My
when
lord,
do you
I
have to
been
leave last?
instructed, my lord, 29th, the process has been started for verification all these things.
I mean,
29th of
when is
this
the
month.
last date? You have to know
But
that.
that, or December 7.
7th December, you won't get a time.
That is true.
Oh.
December 7.
December 7.
Very well. If you apply on Monday, it will be as a special case. This will be decided by the next day. I'll do that.
As a lordship.
At best, I can do that. Mr. Chakravarti, I'll direct that. The court to hear it out because this person wants to go to Hajj. Why not? Learned counsel for the petition.
I was under impression, my lord, my lord Judge Bhattacharya, please directly given consent. No, but the trial court is also there is a factor.
Your
Yes,
notification
yes,
is
yes, that's true. That's true. I have seen that. I have seen.
Lord, may I just say on?
Acha, thik hai. Yes.
Lord, apart from the fact of section 6(f)
Yes.
and the notification,
Yes.
the Criminal Procedure Code 438(2) also provides that no objection has to be obtained from the criminal.
432.
432.
I'll record that argument of yours.
And my lord, kindly also record, I got the bill from the court bill and charge sheet has also been submitted. That documents I have annexed.
You have got bill.
I got the bill from the trial court and also charge sheet has already been submitted.
I'll record this. Everything.
Lordship.
Learned counsel for the petitioner submits that the petitioner wants to go to Hajj. Full stop. Next para. The process for the same has already started and is due to expire apparently by December 7, 2023. Full stop. It is submitted that although a criminal case is pending against the petitioner, the petitioner has been enlarged on bail and the charge sheet in connection therewith has already been submitted. Full stop. Learned counsel places reliance on a notification dated August 25, 1993, issued by the Ministry of External Affairs, Government of India, coupled with the ratio laid down in an unreported judgment of a coordinate bench in the case of HON'BLE Islam and others versus Union of India and others, to argue that the petitioner under circumstances as indicated in the notification, is entitled to leave for Hajj. Full stop. Next para. Learned additional Solicitor General submits that even apart from section 6 within bracket F of the Passport Act, section 438 within bracket 2 of the Code of Criminal Procedure makes it mandatory for the petitioner and similarly placed accused persons to obtain an order from the jurisdictional court where the trial is going on regarding the criminal case. Push up next para, even the notification, it is argued, makes such permission mandatory. Push up next para. A perusal of the judgment of the coordinate bench cited by learned counsel for the petitioner indicates that the learned single judge was considering a similar issue. Push up while doing so, the notification dated August 25, 1993 was discussed and it was recorded that the same was referred to by the passport officer, and it makes it clear that the central government decided to exempt citizens against whom proceedings are pending from travel restrictions in public interest. Pushed up next para. Although the notification was elaborately dealt with, it is not clear from the said order whether the petitioner therein had actually obtained an order from the concerned criminal court where the trial was going on. First up, the issue which has cropped up in the present case as to whether a person can take resort to the notification without approaching the jurisdictional court at all was also not dealt with therein. First up, hence, I cannot convince myself that anything contrary to the notification was laid down in the cited report. Push up next para. The notification clearly stipulates that in exercise of the powers conferred by clause A of small a of section 22 of the Passports Act 1967 and supersession of the earlier notification of April 14, 1976, the central government being of the opinion that it is necessary in public interest to do so, thereby exempted citizens of India against whom proceedings in respect of an offense alleged to have been committed by them are pending before a criminal court in India and who produce orders from the court concerned permitting them to depart from India, from the operation of the provisions of clause small f of subsection 2 of section 6 of the said act, subject to the conditions as stipulated therein. First up, the conditions pertain primarily to the period for which such persons should be permitted to go abroad. First up, the plinth of the said riders were that if a particular period was specified in the order of the court, the passport has to be issued for such period, and if not, by default a period of 1 year usually is the period for which such passport is issued. Push up next para. Nothing in the said notification, however, dilutes the preliminary requirement of the petitioner to approach the within double inverted court concerned double inverted close for an order permitting him to depart from India as a prerequisite of the grant of passport. First up, since the petitioner has not done so in the present case, it is mandatory for the petitioner to first approach such court for an order. Full stop. Only subsequent to such order can the passport authorities comply with the notifications cited by the petitioner. Full stop. In such view of the matter, comma, keeping in view the fact that the petitioner might miss his opportunity to go to Hajj this year altogether, comma, an extreme case of urgency has been made out. Full stop. WPA 24654 of 2023 is thus disposed of by granting liberty to the petitioner to approach the jurisdictional court where the criminal trial of the petitioner is now going on for leave in terms to obtain leave in terms of section 6 within bracket 2 within bracket small f read small f of the Passports Act, read with the notification dated August 25, 1993, full stop. If such application is made on made by December 4, 2023, comma, the trial court shall positively decide the same latest by December 5, 2023 and pass orders thereupon. Full stop. The petitioner is, comma, for such purpose, comma, granted leave to communicate the gist of this order to the jurisdictional court to ensure compliance. Full stop. Upon such order being passed, comma, if a leave is granted to the petitioner permitting him to depart from India, comma, the petitioner shall accordingly move the passport authorities who will process the application of the petitioner with utmost urgency, keeping in view the outer limit of the Hajj travel, and decide the same latest by 48 hours from presentation of such application. Full stop. No orders as to cost, urgency required.
My lord, I have been requested.
You can do it.
Tomorrow, first morning, we can, because he is the conducting advocate. But
Which court is this?
Badaipur. SCGM Badaipur.
You can do it today by telephonic instructions. Just ask him
Yes,
to
yes, yes.
quote the
My lord,
provisions. Do it today so that it is done.
the copy of the order if I get, so that I can communicate.
এটা তুমি আগে তাহলে করে দেবে। এটা আগে করে রিসেসের মধ্যে পাঠিয়ে দাও। By recess, I'll at least sign it. তারপর immediately upload করে দেবে। As soon as possible, it will be uploaded. But you get the gist. The other side is
Yes,
present.
your
Mr. Theory is there as the learned junior of Mr. Chakraborty. So
48 hours from the date of
48 hours from the date of making the application. From the making the application. If he gets the order previously from the court, he can do it earlier also.
As well.
Item 6 and 7.
Yes.
I am for the petitioner.
I am for the state, my lord.
Right.
My lord, here, petitioner
Yes.
paid 2 lakhs and 1,40,000. Last occasion, my lord, there is a direction to submit brief history. Now,
আপনি বলুন না, আমি বলুন।
You have to file the report. First file the report.
নাহলে কি করব?
Yes. Why build the suspense? Yes, Mr. Haldar, what was the case? Just give me in a nutshell.
My lord, the petitioner wants to make a registration of the deed. And for that, he wants to pay 2 lakhs and 1,40,000. But wrongly, it has been transferred to other department. Now petitioner wants
You
to
are asking for a mutation.
no, for registration of the deed, which
Yes.
subsequently, but wrongly it has been transferred to the another department. I have made them parties. And now we want to refund that amount. For that, my lord directed to file a report. The report,
Here it is recorded that you wanted refund of excess mutation fees.
mutation fees cannot be 2 lakhs.
I don't know that
My
mutation fee
kind
cannot be 2 lakhs. Maybe
consider.
2 lakhs. Why not?
My lord, mutation.
Maybe more than that even.
Mutation, let them show any document that the
We are not deciding that, Mr. Haldar. Definitely not. The quantum of mutation fee. You are wanted mutation refund of the mutation fee. Is there a legal? You deposited it by mistake.
Yes. That I wanted to refund.
Is there a provision in law?
Yes. there is a provision.
Which is the provision, Mr. Haldar?
Sir, বল।
What is the provision?
My lord, if I pay any amount to the wrong forum, I am entitled. That is my allegation. My lord, kindly see the repetition.
Where is your application for refund? Please show me that.
My lord, kindly see. Annexure P2, page 10.
The property has not been registered as yet.
Thereafter, I made another that
You paid the mutation fee before the registration was done.
No, that for registration, I made this payment.
Mutation fee.
No, for registration of the deed. Which
You have stated in your representation that the refund of mutation fees on account of mutation fees. Where is the question of registration?
I am coming. The 2 lakhs cannot be mutation fee of a land of 8 cattle. And
if it cannot be, why did you deposit in the first place?
Wrongly it has been.
That is what I am asking you. Where is the question of registration? Why are you repeatedly saying registration? Where is the question of registration here? You have stated in your representation, I have deposited some amount wrongly. I want refund of that mutation fee. That is what you have stated.
Yes.
But what do you say?
My lord, first of all, this is not maintainable.
Why?
This maintainable section 50. They had applied under section 50 under the West Bengal Land Reforms Act. Under the Tribunal Act, my lord, West Bengal Act, my lord, it comes under the specified act. Any dispute as regards to the West Bengal Land Reforms Act has to be done before that authority. My lord, I have the book, my lord. And there is a grossest suppression of facts. My lord wants me to submit on the facts, I can.
May not be grossest.
Well, I'll
you have
tell
seen
you.
better suppression of facts.
There are
better suppression.
With my little experience,
with your little experience also, there are several suppressions.
My lord would kindly come to page 83 of this.
So let us come to section 50 first. You are citing section 50. Maintenance of record of rights.
Well, that is what record of rights he wanted to mutate. That's why he had applied for it. In the ballot, what happened, my lord?
He is no longer wanting the mutation.
That is wrong. That is the wrong thing. That has been improved upon my filing, giving him the copy of the report. What happened? In the first round, he had applied twice. It was rejected under section 50.
He's going on seeking mutation.
Again, my lord, he had taken a chance. He had participated in the second round, filed its Wakalatnama. Wakalatnama is part of the report. Now he comes.
Second round of what?
For mutation. Again, he applied. It was rejected first time. Again, he applied. Then it was again it was rejected.
He's not asking for mutation. If he asked for mutation,
but that was he had applied for. My report specifically.
Now he doesn't want it. He wants refund. Refund them.
Well, how can it be? I have processed it. He has participated in the proceedings. He has. I have not interrupted. Manoj, kindly appreciate. Manoj. He first applies before the court, before the authority concerned under section 50. That gets rejected. 2 applications. He pays the fees. Now he takes a chance again. He applies again under section 50. That gets rejected. He participates in there. He doesn't say for anything that it was for registration for any purpose. He participates. He says this is a mutation application. The authority says it is already rejected. I cannot revisit the rejected order. It gets dismissed. He again prefers an appeal from the first round, which is pending. Now he for the first time says registration. It was never paid for registration. It was for mutation fees.
And registration, question of registration.
That's why kindly see now, my lord, section 50. Kindly, man.
I don't understand, Mr. Chakravarti. If he applies for mutation, if you refuse mutation, and if he fails up to the appellate forum, and he has taken a second chance, he has put in something, and you reject mutation, your stand remains that rejection.
Yes, my lord.
So if you reject mutation, how can you deduct amounts from that?
My lord, it was for processing fee.
What processing?
My lord, kindly say. But I've annexed those things. He has applied. My lord,
processing fees is equivalent to the mutation fee?
No. It was for processing fee. My lord, kindly see.
What is that?
Processing fee.
The answer. So, my lord, would kindly page 4 of my report.
Page 4, yes.
This is one of in modification department circular dated at the processing fee for mutation. This is once he applies, he has to pay this. My lord, good, bad, he has not challenged this notification. My lord, second page, my lord, there is also a clarification at
Just
page
see,
5.
let me give you some time to read this at least. You're citing a particular page. Processing fee for mutation of land. Yes, place it, page 4.
My lord, in modification to the department's circular number so and so dated at regarding the processing fee for mutation of land, the rates which also includes the application fee as mentioned in the following table will come into force immediately. My lord, agricultural land, rural so and so municipal area KMDA. These are the fees that has been fixed. My lord, would kindly count to page 5.
Yes, this was a commercial or industrial land. What land was this? Which is the classification which applies?
This is Bastu land.
So non-agricultural and non-commercial, or it is used for
Bastu land.
commercial or non-commercial? Please see the classifications here. There is no Bastu classification.
Not commercial.
Not then two must apply. Yes, Mr. Chakravarti,
No,
what
now,
then?
my lord, 5.
Yes.
Page 5, my lord.
Let's see. Processing fees.
My lord, there is certain bars, my lord, when it cannot be applied. Now, my lord, my specific case is this writ petition is not maintainable in the first place. My lord would kindly consider section 50 once. My lord, the section 50. The prescribed authority shall maintain up to date in the prescribed manner the village records of right incorporated therein the changes on account of mutation of names as a result of transfer or inheritance. Well, this gets rejected. There is an appeal provision under section 54. Appeals. Subject to the special provisions for appeal made in this act or in any rules made there under this act, an appeal shall lie in the manner below the collector when the order is made by the revenue officer or the revenue authority below the rank of a collector, the commission of the division when the order is made by the collector of a district within the division. Now, my lord, why I say it is not maintainable? My lord, kindly come to West Bengal Land Reforms and Tenancy Tribunal Act 1997, which is at page 83.
No, this is a specified act.
Yeah, absolutely, my
No
lord.
doubt on that.
My lord, all these issues has to, my lord, the language is, my lord, I wanted to just show the language, my lord.
Non-refund of mutation fee does not come within any of the provisions of land
My
reform.
lord, my lord, once he is applied for mutation, my lord, he has, my lord,
your specific stand from the inception is mutation cannot be allowed. Mutation has to be rejected. You stand by that stand.
my lord,
After that, how can you deduct something?
my lord, I say this particular fees is not for the purpose of actual mutation.
No.
It is for application. The language is processing fee. My lord, it is the processing for the application. Application, my lord, the language, that's why I say.
What is the exact meaning of processing?
My processing fee, my that is the nomenclature.
What do you do by then? In the name of processing, what do you do?
Well, they are charging certain things, but that is not under scrutiny with deepest respect.
Absolutely under scrutiny. Without even with or without your respect. What is the processing you are doing?
My lord, may I just one sentence?
It's a specific query from court.
My lord, I'm trying to answer.
You are deducting 1,40,000 for processing.
My lord, may I try to answer? There are two applications. There is no,
what is being processed?
My lord, may I just try to answer this? My lord, I had the same
try.
My lord, just one thing. My lord, application relating to matters under any provisions of a specified act. But this is under any provisions. Well, that payment is also, according to me, is under any provision. Man, language.
Very well, get your point.
Now, but kindly come to the.
Yes.
Regarding the processing fee for mutation of the land, the rates which also include the application fee as mentioned in the following table. Now, this has been decided that this is a processing fee for application fee. This is
processing fee rates you have annexed.
But
is it a commercial and industrial land?
But that in the first place, I said I wanted to file an affidavit in this matter because my lord, kindly appreciate a person comes before my lord. He doesn't say that I had participated in the second round. I had filed my wakalatnama and that was rejected. Nothing has been disclosed. Nothing has been disclosed in the writ petition. My lord, whether my lord in a court of equity malafide intention will be considered.
How soon can I file an affidavit? Your documents are here.
My lord, I have to take these instructions whether it is a commercial part.
Take it today.
Well, kindly give me 10 days.
How long?
Well, kindly give.
You also want processing fees from the government?
Well, we do not get that. I'm sure
If
about
you
it.
don't get that, don't take the time
My
unnecessary.
10 days, my lord.
File it day after tomorrow.
My lord,
Yes, yes, sir. You're sufficiently efficient.
No, but I am
Not day after tomorrow, by this week you can file. This culture of filing 10 days, 2 weeks, 3 months, why? You people are efficient, state is efficient.
No, I am not
So
efficient.
file it.
Next
Your
month.
efficiency is not doubted by anybody. So both of you are efficient, file it by 10 days, by 7 days.
7 days, my lord.
7
By
days, very
Monday.
good.
Monday, by Monday.
Monday, yes, very good. Monday, very well. Next Monday, very
My
well.
lord,
Learned council.
whatever falls from my legs, not diffuse or counted.
No, you say then the state is not efficient.
So how
You can say that. Why not?
I am not efficient.
You are appearing for
No,
this.
no, it's a vicarious life it is with me.
Vicarious or bonecarious, I don't know. Learned counsel for the petitioner submits that the petitioner applied for mutation of a particular property which is in the nature of Vastu. Full stop. Next para. However, comma subsequently the petitioner sought a refund of the mutation fee which was not given by the respondent authorities for which the present writ petitions have been filed. Full stop. Next para. Learned counsel for the respondents hands over a copy of a bunch of documents, copies of a bunch of documents, including certain circulars, and submits that the petitioner has suppressed vital and relevant facts. Full stop. It is contended that the petitioner twice applied for mutation on full stop. On both occasions, it was rejected by the respondent authorities. Full stop. Undaunted, comma, the petitioner again preferred an appeal. The last such appeal is now pending. Full stop. Next para. The deposits made by the petitioner have accordingly been appropriated by the respondents by way of processing fees as sanctioned by law. Full stop. Next para. However, comma, from the circular dated February 2, 2017, a copy of which has been handed over, comma, it transpires that the processing fee, the maximum processing fee for non-agricultural and non-commercial land is rupees 200 if the property is in a municipal area within the KMDA. Full stop. Next para. In any event, comma, the huge amounts which were deposited by the petitioner equivalent to mutation charges cannot be said to be processing fees. Full stop. Next para. Thus, a prima facie case has been made out by the petitioner for hearing the writ petition on merits as to whether the respondent authorities are justified in deducting the huge amount deposited by the petitioner in lieu of mutation charges, comma, in the name of processing fees and refuse to refund the same. Full stop. The respondents shall file their affidavit in opposition within a week from date. Full stop. Reply, if any, shall be filed within 3 days thereafter. The matter shall be listed under the heading upgraded matters on December 15, 2020.
Only thing 200 per decimal, and it is for mutation fee and conversion. My lord, 200, my lord has only 200 per decimal. My lord,
if it is conversion also,
yes,
then your case gets worse. I mean, because if it's for mutation and conversion, this is the amount, then you are charging that as processing fees. Then it is for more than one head.
My lord, we'll disclose. My lord, we'll disclose all the facts. My lord,
You disclose, I'll close.
my lord,
I'll close. I'll close the matter after you disclose. Either way.
in our
Either
favor.
way, either way. Yes.
Hopefully in
Next.
our favor, my lord.
Next.
Item 8.
Yes, Chatterjee, what is the matter?
I
You
prefer
are for
the
the
respondent.
respondent, right? Yes,
It's a
Chatterjee, what
case,
is
my
the
lord,
matter?
the petitioner herein, my lord.
Use the mic. Use the mic.
Petitioner herein, my lord, has carried his grievance to this court on the ground that the current account of the petitioner's business has been closed abruptly, my lord, by the respondent bank. Now, my lord, the fact which my lord needs to be brought to my lord's notice is, my lord, the petitioner was enjoying a current account with the Punjab National Bank for running his business. My lord, during the course of business, my lord is aware, my lord, with current account, my lord, there is an overdraft facility available with all current account holders. Now, the petitioner availed the overdraft facility. Now, my lord, after availing the overdraft facility against the fixed deposits, my lord, security was the own fixed deposit of the petitioner. Now, my lord, the sum was of 12 lakhs. Now, my lord, petitioner is a, my lord, contractor with respect to, my lord,
the security of the overdraft was your fixed deposit.
Yes. Now, my lord, the petitioner is engaged in, my lord, contracting business with government agencies.
Right.
Now, my lord, a fund of amount 12 lakhs, nearly 12 lakhs, 11 lakhs and odd, my lord,
was made over to the petitioner's account by the PWD authorities. Now, my lord, when the check was remitted to this account, my lord, this check was returned back, my lord, to the, my lord, PWD authorities, my lord, and reasons were not known to me. Now, my lord, when I approached the bank, why the checks of rupees 11 lakhs and odd is returned back, my lord, the bank initially refused, but later on I came to know the current account has been closed. Now, my lord, in the affidavit, my lord, in reply and opposition, my lord, they state, yes, it was closed. My lord, the reason has been cited is, my lord, there were certain irregularities in the overdraft facilities. And, my lord, we were called upon to, my lord, clear the, regularize the irregularities. And, my lord, as it has not been done, the current account was closed. Now, my lord, and the fixed deposit has been adjusted against the, my lord, overdraft facility, and therefore there is no loan as against the overdraft facility. Now, my lord, there are two questions, my lord. First is, my lord, very well, you have adjusted my fixed deposit, my lord, and my lord has cleared the loan off, and I am not an defaulter anymore. My lord, that doesn't prompt to, my lord, close an current account. My lord, current account is my business account, my lord, these checks, my lord, which I could use to make repayment of the loans, my lord, has been closed, and I am not enabled, my lord, to, my lord, deposit.
Why does it furnish a cause of action? You could always open a new current
No,
account.
my lord, I have went there. My lord, they are not allowing us to open this current account. They are not. My lord, they have come up with.
What is the relief you have sought here?
My lord, relief kindly
can be
directs the
granted?
bank to open this current account, because this current account, my lord, is with me for 30 years, and all government agencies is having this current account. My lord, and they are remitting checks to this current account, which are being returned.
Very well. Let me hear them.
And, my lord, only one more point, my lord, I must indicate. My lord, to this, my lord, in this, my lord, they have also referred to, my lord, certain cash credit and term loan account. My lord, those are separate issues, my lord. I am not harping on that. My lord, in opposition, they have brought this into the notice of my lord. And, my lord, one factor, my lord, I must say, my lord, kindly takes up their opposition for once.
Yes.
My lord, kindly turns to page 22 of the opposition. Huh?
Yes, 22.
Yes. My lord, kindly takes up, my lord, this is a, my lord, opening of the overdraft facility, and, my lord, the second paragraph, or the amount due and other charges. My lord has got it. So the amount dues and other charges, if any, be adjusted and
Page 22.
Page 22 of the opposition, my lord.
Of the opposition, yes.
My lord, this is the letter dated 14th of December 2020.
Yes, 14th of December.
My lord, there is a blank after
The amount due and other
yes,
charges.
yes.
Sorry.
The amount due and other charges, if any, be adjusted and appropriated by you from the proceeds of the said overdraft or, my lord, such account at any time before or on its maturity at your discretion, unless the loan is fully adjusted within 2 days on the demand in writing made by you. My lord, this demand in writing, my lord, is never made to me. My lord, this was never made.
In writing made by you, you have to make a demand.
Yes.
The amount due and other charges is
My lord, it's the consent which they are taking with this overdraft facility that, my lord, they can adjust the, my lord, fixed deposit on demand. My lord, such demand has never been made. My lord, they have annexed a letter. My lord, kindly sees, my lord, at page 25.
This demand is by you, not by them. You are confusing the two. At any time before or on its maturity, at your discretion, it may be adjusted and appropriated by you from the proceeds. If you do that, then it has to be by your demand.
Then, my lord,
it is not a question of being adjusted at your demand.
And now, my lord, only page 25 is the letter, my lord, which they say we have irregularities informing us. This letter was never sent. There is no document. Page 25.
You have denied the receipt of this in your reply.
Yes.
Right.
This much.
Take your seat. Yes.
My lord, there were 3 accounts, my lord. One, overdraft facility. My lord, there is no current account, I say. One, they have availed one cash credit facility. They have availed one term loan facility. And they have availed one overdraft facility, which is against the fixed deposit, your lordship. That was an OD against the FD. Now, my lord, irregularities cropped up in the account. Lordship is well aware about the RBI guidelines that if one account
overdraft does not always have to be linked with some account. It does not.
No, your lordship. No, your lordship. It can be a separate account. Lordship is well aware that the Reserve Bank says that if the guideline says that if one account goes into NPA, the other will also go into an NPA. Clause 2.2.2 of the Reserve Bank of India circular, your lordship. Lordship, thereafter, we have intimated the petitioner several times that your account is in the verge of NPA, kindly regularize your overdraft account. There was telephonic conversations made, there was letters which were sent to them, which they are denying, but in their affidavit in reply, my lord, they have annexed that they have received the letter, but they have stated that they have received it afterwards, not at that time. However, your lordship, they have admitted in their their reply that they have received the communication from the bank, either by telephonic conversation that.
Where is that admission in the reply? Show me that.
Lordship. Lordship, I'm so sorry, I should have marked that.
No, I'm helping my friend. my lord. I'm helping. my lord.
Which page?
My lord, kindly text my reply, paragraph 6. My lord, the last portion, page 3. My lord, 7 except one telephonic conversation, page 3, my lord, bottom.
Yes.
7 except one telephonic conversation with your petitioner on notice was served upon your petition, although your petitioner were informed in the office that is the amount of rupees to 11 lakhs and odd will be transferred in account very soon. This is the amount which is coming from PWD. One telephonic
page 3.
Page 3, paragraph 6, page 3.
Yes, got it. Right.
Only one telephonic conversation we have admitted. We have received one telephonic conversation.
Very.
Well, that is what they have stated. Well, thereafter, we have informed, well, since the amount was not deposited, they have given a right of set off, my lord, which is there in page number 22 of my opposition, your lordship. Lordship, the last paragraph, second last paragraph, I/we authorize, has the lordship got
Yes,
that?
got it, got it, got it.
I/we authorize bank to appropriate the interest payable on the said such and such account number from time to time towards the adjustment of dues. This authority will stand notwithstanding any other instruction given by me or us at the time of opening the said account in respect of the payment credited of interest. I/we give the bank the right to set off the balance of my or our savings current account or any other account and adjust the amount from the borrower out of the same. For this, your lordship, no prior demand notice or demand justice notice has to be served upon the petitioner. We have
This appropriation after the NPA, after the declaration of NPA.
no, your lordship, account was not declared as NPA. In order to save that from being downgraded into an NPA, we have liquidated this amount and the rest of the amount, because there was 11 lakhs and odd, my lord, which was due. We have given the rest of the amount to the different other accounts. I have also annexed the statement of
you have adjusted with the other accounts. The
Lordship-
rest of the account?
Lordship, there was a 12 lakh FD.
Yes.
The amount due was 11 lakhs and odd. We have taken that, and the rest of the amount which was there in their fixed deposit, that has been transferred to the other accounts. Your
Other
lordship.
accounts are operational.
Other accounts are now operative. Now, your lordship, in bank, my lord, if one account is closed, we cannot open the same account in the same number because we are restrained by the banking policy. Lordship, now, if they are free and willing to have a new current account, my lord, we can open that. But we cannot open the same account because this has been closed and adjusted by the right of set off, my lord, which
Or
they
if
have
he
given.
produces a new security, he can also take an overdraft.
Lordship. Lordship, this is my submission.
Milord, may I just give a Milord, first of all, Milord, there was no instruction to close
Take
Milord.
your seat, Mr. Raju. Yes.
There was no instruction at my Milord side, Milord, to close my current account and Milord my overdraft facility. Milord, if for the timing, Milord, in my writ petition, I have never said, why have you adjusted the fixed deposit? Milord, I say, Milord, why my current account is closed?
They say there was no current account at all.
There was a current account because page, Milord, kindly takes up their opposition, Milord.
Yes.
Milord, kindly sees. Milord, page 4, A1, annexure A1, page 14.
14 years.
Milord, this is the overdraft of rupees 12 lakhs against a proposal this. Now, Milord, in this, Milord, my lord will find my proposal for 12 lakhs is against, Milord, two securities which my lord will find, two FDs. That my lord will find. Kindly turns to page 18. Milord, these are the two securities offered, Milord, FD amounts. 1 and 2, serial. Now, my lord, this overdraft facility has no separate account number. My lord, it's with the current account, kindly takes up my writ petition, and that is admitted position. That is not denied. My lord, paragraph 4. Paragraph 4 of the writ petition. This is the my lord, current account, which was there. Against this current account, my lord, there was an overdraft facility made by them. As I have approached them, my lord, they have allowed
The
that.
account number does not find place in your overdraft.
No, because overdraft facility is with this current account.
If that be so, it has to be linked to
It
the
has to
account.
be linked. It's linked.
If it is linked, it's always reflected in the overdraft facility itself.
No, my lord, overdraft because
Whatever facility is there, if there's a
Yes.
link with some account, it has to
Yes.
be mentioned there.
My lord, otherwise, my lord, in the opposition, they could not have made this statement.
Yes.
My lord, if
So they admit there was an overdraft.
there was an overdraft and there is a current account, that's also admitted.
Where is that admission?
Lord, kindly seize
No, that is the proposal number probably. Yes, that is the proposal.
proposal number because it has not no separate account, overdraft account was created.
Where do you get this number? I mean,
This
what-
is my bank account number, current account. My lord,
any document to show when you opened or any document regarding that account?
yeah,
Something to
passbook,
substantiate. How have they dealt with para 4 in their
Yes.
opposition? Show me
yes,
that.
yes, yes. My lord, kindly takes up, my lord, paragraph 9. They have dealt with
Yes.
Para
They did
four.
it for, right. Yeah, they have said that it is not a current account, but an overdraft facility
My
account.
lord, this current account is for 30 years.
Why do you say they have admitted? They have
My lord, they have
categorically denied.
admitted because once overdraft facility is made, my lord, this current account is linked to overdraft facility and the same account number, my lord, is used against this overdraft. My lord, there cannot be, my lord, this current account is running for 30 years and this overdraft facility is opened in 2021. My lord, it cannot so happen, my lord, that this current account, my lord, otherwise what my learned friend is saying, my lord, it has to be taken that this current account or the number is initiated in 2021 because overdraft was granted in 2021. Otherwise, this account could not have persisted prior to that. Lord, they have closed the overdraft because they have adjusted the amount.
They have, in every communication of theirs, they referred to it as overdraft account.
Yes, my lord, now because there was an overdraft
If there's
facility.
an overdraft in connection with the current account, character of the account does not change.
No, it doesn't change.
But it has been referred to as overdraft account.
But overdraft account will have the same account number as current account. It cannot have a separate account number. My lord, I cannot have an overdraft facility having no account. I have to open an account that is.
They have a fixed deposit.
Yes, my lord, that is linked. My lord, fixed deposit account numbers are not treated as overdraft facilities. They are being made as securities.
Yes, that's true.
So, my lord, I must have an account, my lord, to open and have an overdraft facility. My lord, and businessman, my lord, has a current account which avails a facility. My lord, it's not an account. My lord, it's a overdraft facility which is linked to an account. My lord, I can continue the overdraft facility or I can choose to close the overdraft facility. My lord, that's why they refer this, my lord, as overdraft facility account number. My lord, kindly seize that checkbook. My lord, have a look. My lord, this is checkbook. But this is the same account which is reflected as current account. And my lord, I'm enjoying this account for 30 years with this bank. And this 30 years of enjoyment is not denied by them.
30 years where it was stated. You have not stated 30 years.
Yes. Well, I'm looking. Paragraph 11. এক মিনিট হ্যাঁ কি বলছিস হ্যাঁ আচ্ছা ওই প্যারাগ্রাফটাই দেখছি আমি একটা জায়গায় পড়েছি
Please take back this checkbook. Yes, yes.
Well, I have seen that current account reflection against the account.
Yes.
My lord, one
Captain is
paragraph
also there.
Yes.
Yes.
And one paragraph, my lord, will find paragraph 11, though not 30 years, but it's since long. The language is not 30 years specifically, but in my supplementary affidavit, I have said 30 years. But supplementary is, my lord, after the opposition has come. Because they now in the opposition, as they have said about the cash credit and term loan, my lord, I used a supplementary affidavit to that extent.
From the overdraft document, can you show me any reference to that current account? Show me something, Mr. Chatterjee.
My lord, give me a moment's time. my lord.
Yes. The memorandum for sanction is at page 14 of their document of their
Yes,
opposition.
yes.
From that, let us find
Yes,
out
yes.
something. Because they have said that that overdraft is a loan against bank's own deposit, which is a
Yes.
fixed deposit.
Yes.
And they have stated that proposal is for sanction of a fresh overdraft.
Yes, fresh overdraft.
No reference to any account.
My lord, there is
Any
one
other
reference. One reference. My lord, not to their account, but
What is this reference? Page 24. Yes, you're saying something. I'm sorry. Yes.
my lord, one reference I may draw
Where?
by page 16 of their opposition.
Yes.
My lord, this is not the first time.
What is that?
Paragraph 16, my lord, numerical 5, previous dealings.
Previous dealings, yes.
The firm has already been enjoying OD limit of 10 lakhs, so 12 lakh was enhancement to 12 lakhs. So, my lord, I have been, my lord, using this overdraft facility since long. My lord, limit was 10, it was enhanced to 12. Now, my lord, this is one reference of me using this account as current account for pretty long time.
Page 24, they're referring to some other account.
Page
What is
20.
this account? Is this either the cash credit or the term loan
Yes,
account?
yes. This is cash credit. These are separate. These are separate numbers. Separate numbers. This has nothing to do, my lord, with my current account. Now, my lord, yes, kindly turns to page 20.
20.
20. My lord, I have marked it, my lord, I should have pointed it earlier.
Yes, 20.
My lord, after the column, on adjustment of your dues from the proceeds of security pledged, the balance amount will be credited to my savings account number. My lord, this is the current account number. 3322. My lord, in handwritten, my lord, an FDR be issued for a period of 12 months. So this is the current account which has been closed. My lord, kindly tallies with the my lord, current account number which is referred to my writ petition. Savings current account number. And this is given by Punjab National Bank itself. What has got that? What has seen that? So therefore, this is a current account which enjoys an overdraft facility. They might have adjusted the overdraft facility. But how can they close my current account and bring my business operation into halt? And they say, you are not able to pay my term loan cash credit account, you are not able to pay term loan account. About as on date, on instruction, the on fact, on record, 11 lakhs was supposed to come from PWD. But now, it's about to 30 lakhs which is to come in. Is all stopped because this all accounts are being given to government agencies. This current account, everything is at halt, and I am being treated as a defaulter. I don't want to be a defaulter. Had this 11 lakhs would have allowed to come in, they wouldn't have required to be adjusted by FDs. FD amount, what they have adjusted is similar to what was coming from the PWD.
They have not demanded that amount previously?
No, not at all.
Is there?
Not at all.
At least on paper.
Or at least on paper, they have used that milord unconsented consent. Milord, for opening milord, whatever their format is, I have to give a sign.
This that format is there.
Yes.
No, that format is there.
Yes, milord,
Automatically they
that's
can
why I say milord, unconsented consent.
No, they're not there. You're a businessman, you
Yes, very good.
knowingly open.
Milord, that's why my
eyes open you into.
milord, my prayers in the writ petitions are not that refund my FD value. Milord, open my current account. I will create a separate FD again.
Yes, what do you say to this? This
Lordship,
account
sorry
being
to
referred.
trouble your lordship. Lordship, page number 32 of my opposition, your lordship. This is a system generated info. Here also, your lordship, this is an overdraft account. Your lordship can see my annexure P5. Well, that which my learned senior friend has shown, well, that is a format, my lord, which is there in page number 20. Well, let them produce, my lord, any sanction of that current account, your lordship. That there is a sanction letter of the current account, or there is some current account which has been opened, my lord, let them produce. Because I have specific
Page 20 of your opposition. How do you deal with that?
Lordship, this is what I am saying. This is a general format that because this is a overdraft facility, my lord, which is used for the business purpose. So that's why it is either named as overdraft account or current account. But your lordship, in general, there is no current account which is lying and existing in the name of the petitioner. I have specific instructions on that.
Yes, yes. The petitioner contends that the petitioner has had a current account with the respondent number 1 bank, that is the Punjab National Bank, which has subsequently been closed by the bank on the ground that the petitioner failed to meet the requirements of the overdraft facilities granted against such account. Which sub next para, it is contended that the said current account is the account where the petitioner receives professional fees for his work as a contractor of several government concerns, and the petitioner is suffering immeasurably due to closure of such account without prior demand of any amount from the petitioner. So sub next para, learned counsel for the bank places reliance on the documents annexed to the opposition affidavit in opposition of the bank and submits that the account in question is not a current account but was an overdraft account pushed up by placing reliance on the format of the overdraft agreement annexed at page 22 of the affidavit in opposition, comma, it is submitted that the petitioner himself authorized the bank to appropriate the interest payable on the said amount from time to time towards the adjustment of dues. Pushed up, the authority will stand as per the said document, comma, notwithstanding any other instruction given by the petitioner at the time of opening the said account in respect of the payment stroke crediting of interest. Pushed up, next para, it is submitted that the petitioner never had any current account with the bank, but the only account of the petitioner in respect of the overdraft was the overdraft account itself, comma, which has been erroneously mentioned as a current account in the writ petition. So that apart, comma, the petitioner also has a cash credit facility and a term loan account with the bank, which are operating as usual. Fusab, it is submitted that the overdraft facility was long overdue, for which the respondent bank has adjusted the due amounts from the fixed deposits which were given as security by the petitioner. Push up, the amount which was left after such adjustment has been duly credited to the other accounts of the petitioner. There is the cash credit facility and or the term loan account. Push up, next para. It transpires from the document evidencing the overdraft facility that no prior demand notice was to be given to the petitioner by the bank. Pushed up, hence, comma, the adjustment of the dues of the petitioner on the overdraft facility from the fixed deposits cannot be called into question, comma, nor has the same been done by the petitioner in specific terms. Pushed up, the dispute which arises is that the petitioner submits that the petitioner had an independent current account over and above the overdraft facility. Push-up. The petitioner has also sought to rely upon the petitioner's letter to the bank for opening the overdraft facility dated December 14, 2021, annexed at page 20 of the affidavit in opposition, where the petitioner has indicated that on adjustment of dues from the proceeds of security pledged, the balance amount be credited to the petitioner's savings stroke current account, comma, the number of which is identical with the account claimed by the bank to be the overdraft account. Push up next para. The learned counsel for the petitioner also places reliance on the relevant annexures of the affidavit in opposition to indicate that the petitioner apostrophes overdraft facility on the present occasion, comma, as admitted by the bank, comma, was a renewal of such facility, push up a previous overdraft facility of rupees 10 lakh was subsisting even as per the communication by the bank, which shows that the current account has been operating from previous to the opening of the present overdraft facility. Push up next para. It is seen from the annexure at page 25 of the affidavit in opposition of the bank that the bank purportedly informed about the irregularity in overdraft account. Push up the account under reference carries the number 14010093, তারপর 4 zeros 3322, comma, which has been referred to by the petitioner consistently as the current account. Push up next para. The learned counsel for the petitioner also hands over a checkbook, comma, which apparently indicates that the same refers to a current account of the same number as indicated above. Push up next para. Upon perusal of the documents and the arguments of the parties, comma, it transpires that although the overdraft facility has been granted apparently with a checkbook indicating the same as a current account, comma, the classification as a current account itself does not indicate there was a pre-existing independent current account apart from the account which has been used for the overdraft. Push up next para. In all the relevant communications from the end of the bank, comma, the account has been referred to as the overdraft facility, as the overdraft account. Pushed up the petitioner, comma, in his overdraft facility opening letter dated December 14, 2021 has merely stated that on adjustment of the dues of the bank from the proceeds of security pledged, the balance amount is to be credited to his account of the number as indicated above. Push up the printed format of such application carried the options savings stroke current, which does not ipso facto lend the same account to be a current account. Push up next para. In any event, comma, the account in question has been referred to persistently as the overdraft account of the petitioner in the correspondence between the bank and the petitioner. Push up next para. Thus, comma, there is no special reason to hold contrary to the bank's version that there was independent existence of a current account apart from the overdraft account so cited. Push up next para. Hence, comma, since the said account was overdue, comma, the bank functioned within its statutory and jurisdictional limits by adjusting the amount due and parking the excess in the other accounts of the petitioner. Push up next para. In any event, comma, upon query of court, comma, learned counsel for the bank has categorically submitted that the bank does not have any objection if the petitioner seeks to have further overdraft facility and stroke or open a fresh current account. Pushed up next para. account comma subject to the petitioner fulfilling the other conditions required to do so. Full stop. Next para. In fact, comma, the petitioner cannot be materially aggrieved if the petitioner is permitted to open a fresh current account where the petitioner's incomes can come in. Full stop. There is no magic reference to the particular number of the account which has now been closed by the bank. Full stop. In fact, comma, if the bank is directed to reopen the same account, comma, a confusion may be created, comma, since the same number of the account was being alternatively used to refer to the overdraft account by the bank and to the purported current account by the petitioner. Full stop. Hence, comma, there is no scope of interference with the action of the bank in closing the account in question, that is account number 14010093403322. Full stop. Next para. In such view of the matter, comma, WPA 13715 of 2023 is disposed of with liberty to the petitioner to approach the bank for opening a fresh current account and stroke or drawing a fresh overdraft facility if the petitioner is otherwise so entitled in law and fulfills the eligibility. Therefore, full stop, if such approach is made, comma, the bank shall process the said request immediately and upon satisfaction of all eligibility criteria by the petitioner, comma, permit the petitioner to open such account stroke have such facility, comma, without being influenced in any manner by the previous closure of the account in question. No address to cause urgency. Yes.
But only one indulgence may I seek, my lord. In this writ petition, my lord, the CPWD is made a party. My lord, their checks of 11 lakhs has been returned by the bank. My lord, if my lord is, my lord, directing closure of this account and permitting me to reopen a fresh account with them only, my lord,
Cite this order and ask for a new check from the CPWD. As easy as that.
my lord, the checks, my lord, has
They've
been
admitted, they've given you a check, that's an admitted due.
admitted.
Ask for a new check, return the check.
Lordship, on page number 25, we have also stated that this amount has been remitted back to the PWD.
No, that they're not disputing also. He started with it actually.
My lord, my cause starts from.
Yes.
I'm grateful to you.
I'll come back for the next matter after that.
Item 9.
Very pleased, I am for the petitioner.
Yes.
Here in this case, petitioner is a government
File the
contractor.
affidavit.
Sir. Who was given my lord, awarded a contract in respect to my lord construction, widening and my lord strengthening of my lord Chaitanyapur and Kukurahati Road and my lord Chaitanyapur to Balughata Road within the district Purva Mendipur. What is happened, my lord? The last date, my lord, here it is directed in the notice, my lord, page 16. But here that the construction work is to be completed by 730 days, which is the second paragraph. It is, my lord, reflecting. My lord, what is happening in this case, my lord? My lord, some unauthorized, my lord, occupier who are occupying the PWD land, my lord, they are, my lord, restraining the petitioner to do the construction work. But in this case, what is happened, my lord? Some authorized, my lord, person moved, my lord, to writ petition before this honorable court, where no such interim orders there, and another writ petition, my lord, before my lord has in the contempt application has filed, that also been my lord dismissed. My lord, kindly see the order, my lord order. This sort of coordinate page, which is page 27.
From the same tender, same process.
Same process, my lord. No, my lord. When, my lord, the petitioner is going to my construction work, they restrain the petitioner and file the writ petition before this honorable court. The stating, my lord, they have been removed, illegally removing the government. The government construction, my contract has been given by the PW authority. I am the only contractor, my lord, is given contract.
What happened in that? Yes.
My lord, here, my second paragraph, my lord, here, my third line. The petitioner in the present proceeding also seeks stay of the notice dated 15th March 2022 issued by the assistant engineer PW Holdia Construction Subdivision 1. Since the petitioner have not able to show any interim order which is subsisting as in today, let evident opposition be filed on 9th January 2023. Reply to be filed within 16th January 2023. Let the matter appear 17th January 2023. Any action taken by the state in the meantime shall abide by the result of the writ petition. Well, again, my lord, that order, my lord, page 29.
You are showing this to show that there is no interim order.
No interim order. And my lord,
what is your grievance now?
Well, I could not complete the work, but it was extended up to my lord 31st October 2023. Now, my lord, it is now, my lord, going on to December. After filing the writ petition, the government was again extended up to my lord December.
So what is the grievance then?
Grievance, but I could not complete the work. But all materials
what can
and
the writ could do?
Yes.
What can the writ could do? Writ court cannot rewrite the contract.
My lord,
whatever is in the contract.
Not that, my lord. My lord, here in this case, section 10(3) of the, my lord, Highways Act, my lord, here, my lord, the executive magistrate Holdia started proceeding. But matter has been stalled because has been, my lord, the writ petition has been filed
What
by
is the
us.
relief you have sought here?
But I can, my lord, just comment. Now here, my lord, kindly see, my lord, here, my lord, there is some proceeding 10 of the Highways Act. No steps has been taken by the authority. I could not complete the work. My work has been stalled and
I don't
materials.
understand the relief you have sought. What is the relief you have
My
sought?
lord, here, my lord, relief I spread for.
You are trying to preempt the claim of damages they may make against you.
Not that, my lord.
When they make it, take a defense. Prayer I have seen. What is the prayer? How can I make a direction on them to take immediate steps? They have not initiated 10(3) proceedings.
Yes, started.
Then
started.
But is your locus standi and what can I direct?
Started, my lord, still now they have not taken
What is the
steps. Government.
My lord, in regard to my learned senior friend's contention, my lord, the assistant engineer, my lord, in regard to the illegal encroaches, my lord, have already filed an FIR, my lord.
FIR?
Yes, my lord, because
You have
they are
initiated a proceeding under section 10(3).
Yes, my lord, everything has been initiated, my lord. My lord,
What is the stage of the 10(3) proceeding?
My lord, it is still pending, my lord.
I'll leave it open for you to take this as a defense if they claim any adverse, they make any adverse claim against you regarding the contract. But even that is not required. You can take that defense.
Only, my lord, 300 meters. Well, I have completed entire work. 7x 300 meters within the Chaitanyapur market area.
What direction should I pass on them? The respondent authorities are already doing whatever they have to do.
My immediate step, to dispose of the matter. immediate steps, my lord, for disposal of the matter.
They cannot do it. They have filed it before they responded, the concerned authorities. Who is the authority? Have you made the authority a party? It's entirely against the superintending engineer, executive engineer, etc.
But executive magistrate, my lord,
My lord, I've not
Holdia,
made a party, my
who has
lord.
started 10-3 of the proceeding, my lord, if your lordship, my lord, direct me to here and now to, my lord, correct the cause date, kindly direct that authority to conclude that proceeding 10-3. Here and now, my lord, I shall.
You don't have a locus standi to do that. No.
My lord, because, my lord, the entire, my lord, work has been stalled.
Your cause of action
Say,
is
only
related to
300
that
meters.
proceeding, but you are not a necessary party in that proceeding. You don't have locus standi. They have initiated against the alleged encroacher. You are nobody. You are a contractor holding a contract with them. You would be incidentally affected. No, this is a bad.
My lord, what I am seeking, my lord,
Premature.
what I am praying, my lord, before your lordship, my lord, kindly give me liberty, my lord, to carry the constitutional party, the executive magistrate, and my lord, to direct him to conclude the proceeding as started 10-3 of the Highways Act.
No. You don't have that liberty. The writ petitioner is a contractor which has
May I be
entered
permitted to
into.
submit one thing in your lordship?
My junior,
As I have learned from my client that they are due to pendings of the earlier two writs and previous writs, the executive magistrate is not proceeding with the matter.
When there is
What
no
can be done?
interim order.
The writ petitioner is a contractor having been awarded a contract by the government of West Bengal. The contract was for completing the work of widening and strengthening of Chaitanyapur-Kukrahati Road and Chaitanyapur-Balughata Road for a certain expense under the Tomluk division of the PWD in the district of Purvo Medinipur within a stipulated period of 730 days. Due to encroachment, the work could not be proceeded with, for which the same was extended several times, lastly till this month. Next para. It is contended by learned counsel for the petitioner that two writ petitions are pending at the behest of encroachers, in which no interim order, however, has been passed. Next para. It is submitted that the respondents be directed to take immediate steps for removal of the encroachment for the work to proceed. Next para. Learned counsel for the respondent authorities submits that the executive engineer has already the assistant engineer has already registered a complaint which has given rise to an FIR, and a proceeding under section 10 within bracket 3 of the West Bengal Highways Act is already going on. Next para. As such, the allegation that the respondents are not doing anything in that regard is incorrect. Para. During arguments, learned counsel for the petitioner seeks liberty to implead the concerned authority under the Highways Act, seeking for a direction of the proceeding under section 10 within bracket 3 to be disposed of expeditiously. However, such leave cannot be granted since the petitioner, although consequentially affected by the pendency of the proceeding, is neither a necessary nor a proper party thereto, and does not have the locus standi to seek early disposal of the proceeding under section 10 within bracket 3 of the Highways Act, since it is for the state, which is the initiator of such proceeding against the alleged encroachers, which is the concerned authority which must seek such a remedy if necessary. In any event, since the proceedings are already going on, the petitioner does not have a cause of action to move the present writ petition only on the strength of the contract between the parties. Insofar as the petitioner being affected for not having completed the work within the contractual period is concerned, the writ petition would be premature on such score as well, since the respondent authorities have not made any adverse claim against the petitioner on the ground of such delay, but have rather extended the period of work from time to time. Hence, there is no scope of interference in the present writ petition. Accordingly, WPA 23376 of 2023 is dismissed without an arrest to cost. Next.
One thing, kindly record. Well, after filing the writ petition,
No,
it
no.
is-
So the matter is over now, Nana. Yes.
Thereafter, I got a copy from the authority.
Item 10.
I beg to appear on behalf of the applicant, my lord. This is a matter, my lord, of sharp, my lord, for the respondent, my lord. Yes. I was the lowest bidder in my lord, in case of my lord, election held on my lord, 2021, my lord. And my lord, I was work, my lord, completed, my lord, your lordship kindly come to.
Electrification?
Yes, my lord. Your lordship has one order, my lord, last week.
Yes.
Similar
That is
order.
what I was anticipating.
Yes, similar date, my lord.
Yes,
Lord,
give a copy to your learned friend also. Yes, what about the funds you have to do? Yes. What is your stand?
My lord, in the bottom paragraph 2, my lord.
Paragraph 2. Oh, same. No money.
No money, my lord.
Who has to disburse that money? The government.
West Bengal, Home and Hill Affairs Department, Government of West Bengal.
Home and Hill is not a party here.
Your lordship kindly party.
Anyway, I'll direct. The petitioner worked as a contractor upon being awarded the work of electrification in connection with the 2021 elections in the state of West Bengal. Full stop. However, subsequently the petitioner raised bills but was not paid by the which respondent was to pay? You did the work for whom? PWD.
PWD.
By
Executive
the-
engineer. Respondent number 5.
By the respondent number 5, that is the executive engineer, PWD. Full stop. Next para. Learned counsel appearing for the PWD hands over a report from the executive engineer where it has been indicated that the said office does not have any resource stroke provision for payment of the contractor bills until and unless requisite fund is sanctioned from the concerned department of the government of West Bengal. Full stop. Next para. Hence, WPA 24142 of 2023 is disposed of by directing the respondent numbers 1 and 2 to ensure that the requisite funds for payment of the petitioner's bills are provided to the respondent number 5, that is the executive engineer of the PWD as expeditiously as possible, positively within 4 weeks from the date of communication of this order to the respondent numbers 1 and 2. Full stop. Immediately after such money being disbursed in favor of the being released in favor of the respondent number 5, the respondent number 5 shall take all necessary steps to disburse the amount due to the petitioner, positively within 3 weeks from the date of such disbursal being made to the respondent number 5. No arrest to cost. Please communicate this immediately to the state.
11.
Yes.
Mindly kindly allow the short passover. Learned senior advocate Mr. Kamlesh Bachchan is engaged of court number 37.
Mr. Kamlesh Bachchan is not a senior advocate. He has not been designated.
Sorry.
He's an advocate, definitely. He's practicing for quite some time. He may be your senior also. Senior advocate has a connotation under the advocate. And you have to move the matter, otherwise it goes down. It will not remain in the upgraded list. That is my policy in all matters.
Kindly, my lord, short passover.
Start the matter.
10 minutes.
I've given you 2 opportunities. If you don't start in the third time, then
প্লেস করো না ইমপ্রিন্ট অর্ডারটা প্লেস করো পেজ 66 দেখো প্লেস করো জজ সাহেব বলছেন
have the brief. You are holding it in your hands tight.
take it
What is the relief sought?
page 66 is the impugned order, my lord.
66. Look, thank you. What is the matter about? Just tell me.
The district magistrate has, my lord, he has prayed for an electric connection, my lord.
Anyway, Mr. Bhattacharya, yes.
Well, at the electricity connection, I am the owner of the land. Admit it. My name has been mutated. KMC tax I am paying. I have purchased it by registered deed. Local club is wanting me that that property should be used for the purpose of puja, Durga Puja, which I do not agree. I applied for electricity connection. Electricity people came and they were registered, so they did not give me supply. Ultimately, the district magistrate is saying the title suit is pending in the civil court. Therefore, you take an order.
Title suit between whom? You and?
My and club authority.
Who filed the suit?
I filed the suit.
And what is the relief sought there?
No, my lord.
That is a declaration suit. Declaratory suit.
Two suits pending, my lord. First suit is filed by the
It has nothing
petition.
to do with the matter. Electricity supply does not require to be.
Mr. Bhattacharya, you have to add anything else? I'll go. Yes.
Yes.
So on that ground, they're refusing electricity.
That is the only ground. That is the only ground. The DM is saying that is a vacant land with a structured manner without electricity. I cannot stay there. Since you are not staying, therefore you are not entitled to electricity.
There is no structure. How can you? Where will you get the electricity?
There is a structure. Since there is no electricity is there, I cannot make any modification in the structure for staying. Electricity is there.
Well, that is the sole difficulty, my lord.
Achha, let me hear you first on the suits. Yes. What do you say? You are appearing for whom?
I appear for the district magistrate, my lord.
Oh, sir.
My lord, this has a checker history. Initially, with the similar prayers, the petitioner has approached your lordship courts. Your lordship has been pleased to dismiss the writ petition, observing that suits are pending, and your lordship has given leave to the petitioner to approach the suit court, civil court. My lord, thereafter an appeal was preferred. My lord, page 61 is the order of the division bench. My lord, in the concluding paragraph, my lord will kindly come to para 60, page 64. My lord, before the division bench, they took a plea that the district magistrate is the authority who can adjudicate to some extent under the Work and License Act 2006.
Yes.
My lord, the division bench took note of the fact that Honorable First Court, my lord, has taken note of the fact that the district magistrate is the authority, but did not grant any relief to the petitioner. And the matter was reverted back to the district magistrate. Well, the district magistrate, what he did is, he directed inspection. Page 65, my lord will find the division bench notes that what is relevant is who is in possession of the property. Well, district magistrate directs the authorities for field inspection. On field inspection, it is discovered that the petitioner is not in occupation of the plot in question. Secondly, my lord, it is discovered that the premises in question is already electrified. There is an electric meter in the name of Niva Park Housing Complex Association.
Got a copy of that report?
Yes, my lord, it is there.
It is annexed here.
My lord will kindly find the report of the electricity company. My lord will kindly come to page 3. There the electricity company takes notes of the difficulties. My lord will first is Roman 1, the premises is already electrified. My lord, occupier is second, Roman 2 is, my lord, occupier of the said room is Niva Park Housing Complex. My lord will thereafter turn page 2 suits, my lord, 2 more things, my lord. Two more things, my lord.
What are the suits?
My lord, page 4 is by them, my lord. Title suit number 766 of 2020.
Whose suit?
Their petitioner suit for a declaration for a permanent injunction not to interfere with the possession of the petitioner. My lord will kindly come to page 7 thereafter. Page 6. I'm sorry, my lord, page 7. My lord, this is a suit by which a declaration has been made that the declaration for cancellation of the title deed of the petitioner is in question, my lord. Page 17 of the writ petition, my lord will find the sale deed of the petitioner, by which the petitioner derives the title. The validity of this deed is in question, is in another title suit, my lord. Last but not the least, my lord, any order passed under this act is an appealable order, my lord. A writ petition normally will not be entertained.
Appealable under which provision? Under works of licensing rules?
Absolutely, my lord.
This
My
was the
lord,
district magistrate's order.
district magistrate's order, my lord. My lord will find that at page 63, where the division bench has noted the entire act. Rule 3, sub-rule 3.
What is the provision of appeal?
My lord, rule 3, sub-rule 3, at page 63 of the writ petition, the division bench has noted the entire act, my lord. 63, my lord, sub-rule 3. Page 63, my lord.
Yes.
Page 63, sub-rule 3, my lord. Every order made by a district magistrate or a commissioner of police or an authorized officer under sub-rule 1 shall be subject to revision by the appropriate commission. That is the regulatory,
Commission is the regulatory.
regulatory commission. That is my submission.
Let me hear the electricity company, then I'll come.
Sir.
Yes.
The order is, my lord, will consider the grievance of the petitioner. It is specifically noted that in the order passed by the learned district magistrate at page 69, an electrical meter box was found erected was fixed by the WBACDCL, which is lying in the plot number.
That is standing in the name of whom, Mr.
That is standing in the name of the Niva Park Association.
Not a party before my lords.
And my lord, your lord
is a club.
Is the club is not made a party.
Adjacent to my
It is a housing association. This part that subject plot is within that association, within the area of that complex, my lord. Now your lordship find at bottom of the page, actual finding, it has been arrived that the premises identified by the appellant Ramesh Kumar Jha is physically possessed by Niva Park Association, which is already electrified by meter number so and so. Though it is evident from the record of right submitted by the Ramesh Kumar Jha that a portion of plot 584 is recorded in the name of Ramesh Jha, but such recording will not be itself hold good title in favor of the Ramesh Jha, as the issue of title in favor of Ramesh Kumar Jha in respect of the sued land is sub judice before the competent civil court having jurisdiction. This is the reason the first writ application your lordship did not send it the district magistrate, asked the petitioner to go the civil court and obtain the order. Then, my lord, moreover, there is a discrepancy regarding the identification of the property which is related to the title of the disputed property. The adjudication of that dispute will be appropriate if decided by the competent civil court. Under such circumstances, the appellant Ramesh Kumar Jha is not entitled to any relief unless appropriate order are passed by the competent civil court, where the title suit is pending for establishing his title over the property or an appropriate direction with the honorable court. This is well considered the order.
Today we will have
Yes,
to.
what do you say?
My lord, the dispute which was initially.
You are who?
I am appearing on behalf of respondent number.
Private respondents, but
Private
you are
respondent.
related to Niva Park or the club?
I am related. I was the erstwhile secretary and president. Now I am
Of
not
what, the association?
of the association. At the point of time when the earlier writ petition was filed before your lordship, this point was also taken that the association was not included as a party. Secondly, lordship, the plots which my learned senior friend claims to be his plots are not actually there, lordship. That is why lordship had relegated the matter to the civil court, because they had sought for a declaration where I had a counterclaim for cancellation of his deed. So lordship, the order.
There is only one suit.
Yes.
Title suit and
Two suits, my lord.
no, he is saying there is a counterclaim.
To my knowledge, lordship, there is a counterclaim, not a counter suit.
I have attached, my lord. My document carries it. One is 480, my lord, of 2022 at page 7. Another is, my lord, title suit 767 of 2020. By the plaintiff is 2020, my lord.
Even in the plaintiff, lordship, the petitioner suit, I have a counterclaim. Lordship, I stand corrected. There is a second suit where I have sought for cancellation of the title deed. So, lordship, in that situation, lordship, it is impossible to give connection at his, and already there is an existing, pre-existing meter in the name of the association.
Yes, let us hear it, Mr. Bhattacharya. Yes, my lord.
Now, firstly, this club is creating all sorts of hindrance in getting the
Which
electricity.
club? What is the name of the club?
So that club was, I have said in
You have not
paragraph
included
11.
any club.
Kindly come to my paragraph 11, how I am suffered. They formed a club that the local members of the legislative assembly is a close associate of the private
You have not
respondent.
named the club. You have not implicated the club.
Yes,
Mr.
yes,
Bhattacharya.
club is there.
Where is that? The club.
Club in Namta.
Which respondent?
No,
It's not there, not there.
I have not individually made the club as a party.
You have not even named the club.
I am not interested to name the club. Club has not come forward in its entirety.
Your entire allegations you are making against the club.
Against the persons are the members of the club. That is the members of the club. These admittedly property was purchased. That was initially under the jurisdiction of the said club. A part of the property, vacant land, was sold, and I purchased the said land. That is the sin I have done. That a part of the land has been purchased by me. Club has no right title interest over the said property. They have no iota of evidence before your lordship to lead. Admittedly, my lord, my name has been mutated. Kindly lordship look for once. Kindly look for once the documents, my lord, annexed to the petition. It is the director of register of stamp revenue, and all stamps and duties were paid.
Where is the mutation certificate?
And mutation has already been made in my favor. In respect of the lordship will get it after the registration.
I want to see the mutation certificate only.
My lord, kindly look at page 46. Yes, page 46. That is Khotian number. My name is their owner's name.
This is an information issued by the authorities. It's not a mutation.
Niva Park. Address is Niva Park. Area is Niva Park area. That is the address. And kindly come to page 47, the Khotian.
I don't find any mutation certificate, Mr.
Municipal assessment, page 49 is there. It has been assessed in my name. Ramesh Jha, lordship will get it at page 49. Tax bills are raised in my name, in the name. Left hand side.
Yes.
2-3 column down. Tax bills are paid by me.
Why don't you file
Electricity
an appeal?
distribution.
Why didn't you file an appeal against the district, the order of the district magistrate?
But I am not, the district magistrate has admittedly, my lord, wanted me to go to civil court. That is, that order itself, my lord.
If that order stands, you don't have a right to get electricity.
Order, my lord, district magistrate order may be appealable, revisable under the before the commissioner.
Yes.
But I have come up before your lordship, my lord, in order to establish the legal right of the petitioner to the extent that as a owner of a property, I am entitled to electricity in my name. That is a fundamental requirement under the constitution. It is a constitutional right has been infringed. I have a fundamental right to get the electricity. Even if the title of my goes in future, that also, my lord, will go along with that electricity. Even a person against whom eviction suit is filed, my lord, he is also entitled to, my lord, electricity.
Learned counsel for the parties. First of the petitioner claims that the petitioner is the owner and occupier of the property in dispute, but is not getting electricity connection from the WBSEDCL due to resistance put up by a local club, which is sponsored by the MLA
and the minister himself.
Having the MLA and minister who is having sway over the issue. Push up next para. However, learned counsel for the respondents, including the district magistrate as well as the WBSEDCL and the private respondents, argue that two suits are pending at present between the petitioner and the Niva Park Housing Complex Resident Association. Push up next para. The subject matter of the suit of the petitioner is the petitioner's alleged title in respect of the property, whereas that of the Niva Park Housing Complex Residents Association is a challenge to the title deed of the petitioner and to the alleged possession of the petitioner as recorded in the purported records of rights. Full stop. Next para. The matter was moved previously before this court when when the writ petition was disposed of by relegating the parties to the concerned civil courts where the suits are pending. Full stop. However, a challenge was preferred thereto by the writ petitioner. Full stop. In appeal, the learned division bench referred the matter to the district magistrate for an adjudication of the issue under the conspectus of the Works and Licenses Rules, 2006. Full stop. Next para. Upon hearing the parties pursuant to the said direction of the division bench, the district magistrate has now come to a finding that the matter is pending before the civil court. Full stop. That apart, it has been observed by the civil court that upon consideration of the relevant facts, submissions and objections, as well as site inspection report submitted by DE and SM of Boral CCC, WBSCDCL, and field inquiry report submitted by PL and LRO Kolkata, a factual finding has been arrived that the premises identified by the appellant therein, within bracket present writ petitioner bracket closed, is physically possessed by Niva Park Association and is already electrified with a meter number IPG 068103. Full stop. Next para. It was observed by the district magistrate that though it is evident from the record of rights submitted by the petitioner that a portion of the plot number 584 is recorded in his name, such recording, it was observed, would not by itself hold good title in favor of Ramesh Jha, as the issue of title in favor of Ramesh Kumar Jha in respect of the suit land is sub judice before the competent civil court having jurisdiction. Full stop. Next para. Thus, the magistrate went on to observe that the petitioner was not entitled to electricity at the present juncture, particularly citing the pendency of the suits before the civil court. Full stop. Next para. It transpires from a perusal of the order of the district magistrate that the same is sufficiently well reasoned and takes note of all the germane materials on record, including not only the site inspection report of the WBSCDCL, but the inquiry report submitted by the BL and LRO as well. Push up. Next para. After such careful scrutiny, the observation of the magistrate was, in terms of the WBSCDCL report, that the property in question is being physically possessed by Niva Park Association, which is already enjoying an electricity meter in its name. Full stop. Next para. Thus, there is no occasion for the petitioner to have established his physical possession in respect of the property sufficient to get electricity connection under section 43 of the Electricity Act 2003. Full stop. In any event, the matter is sub judice before the competent civil court and cannot be pre-decided, more than that it has been done by the magistrate pursuant to the division bench's direction, at this stage. Full stop. Hence, I do not find any illegality or irregularity in the order of the district magistrate. Full stop. Next para. In such view of the matter, there is no scope of interference in the writ petition. Accordingly, WPA 24926 of 2023 is dismissed without any order as to cost.
We are grateful, Milord.
A copy of the report filed in court today by learned counsel for the district magistrate be kept on record.
We are
One
grateful.
more thing, Malad,
Yes,
I
Mr.
have
Bhattacharya.
said.
Yes.
I have said in paragraph 11, 12, 13, since the minister himself is involved,
I've
all
recorded-
reports will go against me.
I've
All
recorded this.
reports will go against me. This cannot be tried by a state electricity board. His minister is personally involved in this. No one
Many
has.
ministers we have seen, so many ministers, Mr. Bhattacharya, we have seen their end. So let us not be on that. Call on the next.
No dispute to that has been made by an MP.
Item 12.
Yes. Yes, what is your matter? Moving.
Your Lordship, I want to withdraw this writ petition today.
Learned counsel for the petitioner seeks
With
leave
the
to
liberty to file fresh because Your Lordship, certain documents are not been incorporated. We will not.
Learned counsel for the petitioner seeks leave to withdraw the writ petition with liberty to file afresh since certain documents, according to learned counsel, have not been properly annexed to the writ petition. Pushed up. Accordingly, I'm granting that leave. Although you are ready in the matter.
More than ready because a similar matter was before my lord and I was to file my written objection there. So I was more than ready.
Accordingly, WPA 25577 of 2023 is dismissed as withdrawn with liberty to the petitioner to file a fresh writ petition on the self-same cause of action. No address to cause action.
Leave due.
13.
My lord, I am appearing on behalf of the writ petition.
Yes.
My lord, I appear on behalf of the CSC in this matter.
Right.
Hearing we have to respond number 3.
My lord, affidavit of service.
Yeah. What is the matter? You are Mr. Bandyopadhyay, aren't you?
My lord.
Yes, Mr. Bandyopadhyay, what is the matter?
My lord, the writ petition is carrying out a business, mobile business at the premises of the landlord.
Yes.
Which is under the jurisdiction of the Uttarpara Police Station, District Hooghly. But my lord, during the pendency of the tenancy, the landlord disconnected the electricity connection, and thereafter they have filed the civil suit for eviction before the Landed Civil Judge Senior Division, Srirampur Hooghly, and also filed an application under Order 39, Rule 1 and 2 for restraining the CSC authority not to give any electric connection in favor of the writ petitioner, and same has been also rejected by the Landed Trial Court. In the meantime, we have the writ petition apply for CSC authority for new electricity connection for installation, and the CSC authority till now did not take any action for installing the meter in the premises of the landlord. And we also paying, my lord, kindly see the page number 49, annexure P9. We have till now paying the rent of rupees 12,000 in favor of the private respondent number 3.
That is sub judice. I mean, the eviction certificate.
Paying rent.
But pursuant to an application for
So this is the previous, no electricity connection.
I'm paying for electricity immediately.
You applied for new electricity
Yes,
connection?
yes, my lord.
Any quotation has been raised?
Inspection has already been done.
No.
As per my instruction, my lord.
My lord,
Can you see the page, annexure P10, my lord?
Page
55. Page 55.
maybe this is a letter for inspection, but we have not done the inspection.
Yes, due to their resistance.
And we will seek for a police help for inspection and file a report, my lord.
Yes, sir. Why are you resisting?
But I will take my lord to the page number 4 of the writ petition.
Yes.
Here is the agreement. What type of agreement? They haven't disclosed. Neither annexed. Agreement starts on 11th July 2022. Expiry date is not there. In my lord, come paragraph number 4 in the very next page.
Yes.
They have granted a certificate, enlistment certificate from the authority concerned. But in their prayer, whether they have annexed the agreement or not.
Your agreement.
Yes. Not stated. Then, my lord, page 8.
8.
In the middle portion.
Yes, you have disconnected.
The question of disconnection I will come later on, my lord. There is a malified intention
to enjoy electricity.
The electricity from the very beginning. There is a malified interest.
Wait. Who is this? Whose phone is this, please? Phone ta sis ko na. Phone ta niye. Phone ta niye na. Jama thak ekon. Recess pot debe. Switch off kore rekhe daw. Yes, please continue.
From the very beginning, there is a malified intention. And regarding the disconnection, it was not done by ourselves. That is the private respondent. Secondly, there is a tampering of the electricity meter or electricity connection.
It is standing in your name, the meter.
The line which has been provided by us, provided from our meter.
So I'll direct them to take steps against the tampering. They'll disconnect your electricity connection and they'll give connection to this person. Yes.
The question is that we are ready.
To do what?
We are ready for subline. We have repaired the connection by our from our own pocket. And in the melody, In the prayer question, they are not saying that the connection has been disconnected or in the prayer getting the electricity from our
They're in
meter.
possession, you have filed an eviction suit, enmity is clear, they're entitled to electricity connection. They'll have an independent connection, no difficulty in tampering and all this.
We are ready to give.
No, your
The
readiness
line
is
been
immaterial.
repaired.
My lord,
Line has been repaired.
may I come back with a report?
No,
madam?
no, no.
My lord, why I am saying, my lord,
What
whether it has been disconnected, my lord, whether there is tampering on as far as
eviction suit is pending, that is sufficient.
yes,
Is entitled to a new
yes,
meter.
that is there, my lord. Then, my lord, we kindly direct, my lord, with police help and
Yes,
break
yes,
open
definitely.
at the existing meter.
Now, counsel for the petitioner submits that the petitioner is a tenant in respect of the property, full stop. It is alleged that the petitioner's electricity connection, which was being enjoyed from respondent number 3, the landlord, comma, has been disconnected and the landlord has initiated an eviction suit against the petitioner. Full stop. In the eviction suit, comma, the landlord made an application for injunction restraining the CSC Limited from giving electricity connection to the petitioner, which has been refused by the trial court. Full stop. Due to hindrance created by the landlord, comma, the CSC Limited is not being able to give electricity connection to the petitioner. Full stop. Next para. Learned counsel for the CSC Limited submits that the CSC could not hold an inspection due to resistance by the landlord and seeks to hold such an inspection to ascertain whether disconnection has been effected or not. Full stop. Next para. Learned counsel for the private respondent number 3 stroke landlord submits that the petitioner has left it unclear as to who disconnected the electricity supply. Full stop. It is denied that the landlord disconnected the electricity. Full stop. Learned counsel submits that there was a tampering in the electricity line standing in the name of the private respondent, for which the private respondent has taken steps duly for getting the line repaired. And the private respondent is ready to give electricity connection again to the petitioner. Full stop. Next para. By placing reliance on the pleadings in the writ petition, comma, it is submitted that the petitioner admittedly entered into an agreement with the landowner stroke private respondent regarding running the petitioner's business in the shop room concerned. Full stop. However, comma, no copy of the said agreement has been annexed to the writ petition. Full stop. Next para. It is thus submitted that the fresh connection sought by the petitioner may not be given. Full stop. Next para. The petitioner, comma, admittedly, comma, is in occupation of the property which has been admitted by the private respondent by filing an eviction suit against the petitioner. Full stop. Next para. It is well settled that electricity is a basic right and has been guaranteed not only under Article 21 of the Constitution of India, but under Section 43 of the Electricity Act 2003, irrespective of the lawfulness or otherwise of physical possession. Full stop. Next para. The petitioner being in physical possession, comma, is evidently entitled to get a fresh electricity connection. Full stop. Insofar as the question of the petitioner getting electricity connection from the private respondent stroke landlord is concerned, comma, in view of the eviction suit filed by the landlord, comma, the enmity existing between the two parties is evident. Full stop. Hence, it cannot be said that the present application is collusive between the petitioner and the landlord. Full stop. Next para. In any event, comma, the petitioner need not remain on the mercy of the landlord to get electricity connection, comma, being entitled to do so in her right independently as a tenant of the property against whom an eviction suit is pending. Full stop. Next para. Thus, comma, WPA 2575, আচ্ছা না আরেকটা লাইন অ্যাড করে দাও, however, comma, the rights of the respective parties with regard to the property shall be finally and conclusively decided by the competent civil court in the pending suit. Full stop. Next para. Accordingly, WPA 25751 of 2023 is allowed, comma, thereby directing the CSC Limited to hold an inspection within a fortnight from date upon prior notice to the petitioner as well as the private respondent. Full stop. Upon such inspection being held, comma, the CSC Limited shall raise a quotation to the petitioner within 3 days thereafter. Full stop. Upon the petitioner complying with all formalities with regard to such quotation, comma, the CSC Limited shall give electricity connection to the petitioner independently from the existing meter board position at the suit premise of the uh, uh, concerned premises within a week from the date of compliance of such formalities by the petitioner. Push up next para. At any stage, comma, either at the time of holding the first inspection or at the time of giving electricity connection, comma, if the CSC Limited face any obstruction from the respondent number 3 and or his men and agents in any manner, comma, it will be open to the CSC personnel to approach respondent number 5, the inspector in charge of the Uttarpara police station, who will grant adequate police assistance to assist the CSC personnel in holding the inspection and giving the connection respectively, comma, if necessary by breaking open any padlock or other hindrance if put up by the respondent number 3 to impede the access of the CSC Limited, full stop. Such police help shall be given by the respondent number 5 by acting on a server copy of this order without insisting upon prior production of a certified copy, comma, at the cost of the petitioner on both such instances. Full stop. It is further clarified that nothing in this order or the electricity connection as and when given to the petitioner shall create any special right or equity in favor of the petitioner which the petitioner does not otherwise have in law and shall be and shall not in any manner affect the rights and contentions of the private parties in the pending civil suit between them. Not as to cause urgency.
Only one thing, Honor, we will give the connection at the existing.
I've said that. I've said that in my order. Yes. Next.
I'm grateful.
Your Lordship, next matter, I am the private
My
respondent.
lord, this is my application, my lord. This is the matter, my lord, where the bid conditions were changed after the opening of the bid document, my lord. I am challenging the resolution dated 4th September 2023 at page 128, being annexure P3. The bid document was published finally, issued on 13 June 2023, and my lord, the particular resolution
Finally published. Bid document was published.
bid document was issued finally on 30th June 2020.
Finally, where you say finally, it is issued only once.
It is published on 13th June, my lord. 13th.
13th June, yes.
Yes, 13th June.
The last date for submission of bids?
Last date for due for time of submission was 24th July 2023. That will be appearing at page 21 of my writ petition.
24th June.
24th July.
July, I'm sorry.
Yes. And my lord, the date and time of opening of financial bid of intended to be notified later.
And what is the date of the impugned decision?
Impugned decision, date of the impugned decision was 4th September 2023. And it was made published on 4th November 2023 while the entire financial bid was opened.
What was the change? Let me see that. 128. Page.
128, my lord. The tender selection committee of this hospital unanimously, your lordship got it?
Got it.
Yes. Unanimously decided that increase of the bidders offer low rate from the rates mentioned in the diet. I shall come to your lordship. These diet schedules are given here, my lord. I shall refer those after pressing this. Diet 1 to Diet 8, which was obtained from the Agricultural Marketing Board, West Bengal. Total average cost of diet 1 to Diet 8, excluding the cooking gas, service charges, including profit and taxes, if any, below rupees 88.63, rupees will not be considered as a valid bid. That is they have fixed, that is the person who will be quoting the below this rate.
You had participated.
I have participated, and from their chart, my lord, I am the L1 candidate and I have quoted 86 rupees. And my lord, it is to be appearing. These rates are given, my lord. Your lordship will get the rates. That is general diet being Diet 1, 122.06 rupees per plate.
So you say that this cutting off of the lower limit to 88 rupees, 88.63 was adverse to your interest and done after you participated and
Yes, yes.
and the last date of submission.
My lord, kindly come to this table, my lord. These are the different rates. That is general diet, admission diet, cardiac diet. All these diets average is coming 102. And these rates of.
What was the provision in the original tender?
Yes, I'm coming to that, my lord.
To show that.
My lord, this is the furnishing of rates at page 26. Cost of materials. This is these are there. My lord, kindly come to the furnishing of rates. This is at page 26, my lord.
26, yes.
Yes, this is furnishing of rates written in capital letters.
Mhm.
Then, my lord, column D.
Hmm.
Sorry, paragraph D. Finally, consolidated rate against each to be quoted, taking together A, B, C, D for supply of each category of diet. Schedule of each category of diets are given here, my lord. That is charts from page 33 and onwards. That is consolidated rates have been given in the particular resolution.
No, it was unilaterally declared by them that the cutoff will be 88.63.
Yes.
And then you go out as L1. You are L1, you are removed.
Yes, this is the chart, my lord. And it is in the chart, it is empathetically showing that I am the L1. This is Lucky Catering Service, lowest.
Let us hear then.
And my lord, kindly have a look, my lord. And there is no benchmark of the rate has been fixed that I cannot quote below the rates. This is D, E, and my lord, nothing, my lord. Thereafter, my lord, again, my lord, the mode of calculation of rate. Mode of calculation of rate is at page 29, being paragraph 13, page 29, mode of calculation of rates. That the calculation of rate acceptable bidder will be on the basis of overall monthly financial implications. Means this is how much can be quantum of the entire consumption. So these are the things they have given. There is no benchmark for the particular plates to be served upon the patient's, my lord. And that was made on 4th September, and there is no scope has been given. That is made published on 4th November, when the financial bid was opened. As if the particular bid was made and it was published, and thereafter it was tailored for suiting somebody else, my lord. And my lord, I have.
Financial bid was opened when?
It was opened on 4th November.
The same date. It was
Yes.
published on the same date.
My lord, the resolution was taken on 4th September.
Yes, but
and my lord, on page 129, it can be observed that signature not verified, digitally signed. It is made on 4th November 2023.
4th September?
No, 4th, next page, my lord, 129.
129, all the signatures are dated.
Yes, but this is uploaded on 4th November. Just below signature.
Oh, achha. Oh, okay, all right.
Because that was their document, their resolution. That was kept.
One Abdul Rashid only signed on that.
Yes, because he has only made.
If he has signed on that date, it could not have been uploaded previously.
Yes, because that is then only they have made it public, and it is and this is the chart I have given, where there is a comparison chart of the bidders have been given, and it is, my lord, this is the larger. But the names of the particular bidders are not
larger. Was the size is larger.
Size is large, large in size. But
larger picture. This is a larger picture.
Larger picture.
Literally larger picture.
But
what will I find out from this? So much mathematics? No.
No.
These are deterrent.
From the blackhead, my lord, nothing can be found, my lord, because that is best known to them. Yes, this one.
I should return this one.
Yes.
No. Yes.
This
is a blue head.
Blue head. That is.
What is your name?
That is Lucky Enterprise.
You are Lucky Enterprise.
Yes, I'm Lucky Enterprise.
Misnomer.
Yes.
Yes.
It's the proprietorship, my lord, and the writ petitioner is the proprietor of the said firm.
So, what is the use of this, Mr. Sinada? Why are you placing this?
First of all, my lord, this will only.
That you are the L1 bidder.
I am the L1 bidder.
And
my lord, this particular modification has been made for the particular bidder that is being, I think, this is respondent number 13, Loknath Enterprise. whose bid is much suiting to the proposed modification made after the publication of the particular bid.
Number 13.
13, yes, respondent number 13.
His rates are just
Just
above that.
Just above that. He has quoted 91.88 something, and their benchmark is 88 point something. And 91 comes after adding one. There is also
New supply syndicate is also there, which is 88.210, but that is just below 8.
yes, just below.
Acha. Where is your rate? Where is your name?
My name is Lucky Enterprise, and my
Lucky
rate
Enterprise, I can't find it. Lucky Enterprise, where is that? Next page. Lucky Enterprise, yes. Your rate of 85 point something.
85 point something.
Very good.
So these are all my submission, my lord. I am relying on the two judgment, my lord. One is HON'BLE India Private Limited, reported in 2022 5 Supreme Court cases 362, my lord. The ratio of the said decision has been discussed following the opinion. And my lord, this ratio has been derived following the
paragraph of that judgment.
Yes.
You can just indicate the paragraph.
My lord, actually this judgment is based on the Jagadish Mandal versus State of West Bengal, where it has been observed that anything is in violative of the Article 14, my lord, that is required to be struck down.
That was a tender matter.
That was in the tender matter.
Very good. What about the other decision?
These two decisions, otherwise there are...
What is the citation of the other decision, Jagadish?
Jagadish is 2007, volume 14, SCC, page 517.
Cite those formally.
Yes. This is Agmetal, my lord. Here there is a question of interpretation of the covenant of the contract. And my lord, actually, my lord, I'm just making the things much more coincides.
Complicated.
No.
Yes.
That is at page 382, my lord, where the Jagadish Mandal was followed.
Right. So Jagadish Mandal is a plinth.
Is a plinth.
This is also on the basis of that.
This is on the basis, my lord. I am coming just from the 381.
Yes.
That is last line. Last line of the 381, my lord. That is without therefore going into the assessment of the document that has been supplied to this court, it is well and settled that unless arbitrariness or malafide on the part of tendering authorities alleged, the expert evaluation of a particular tender, particularly when it comes to the technical evaluation, is not to be the second guessed by a writ court. And my lord, then their lordship quoted the paragraph 22 of the Jagadish Mandal, my lord. That is at page 382, my lord, of the particular
citation. Yes.
Citation. Judicial. I'm not reading this, my lord.
Not it.
And
the usual test, arbitrariness,
yes.
irrational.
And my lord, there are three tests has been given. That is, one is Roman 1, whether the process adopted or decision made by the authorities malafide or intended to favor someone. Or, my lord, my case is coming in the Roman 1, and whether the process adopted or decision is made so arbitrary, irrational that court can say decision is such that not responsible authority. Either there are two options. Either they should have been recalled the entire thing and made a fresh thing, giving the particular covenant added therein, or rather they should have they should not have given the particular resolution adopted on 4th September. While there is already from their chart, it is available that there is a writ petition is L1. You know, my humble prayer before your lordship is that direction may be made to issue the particular work order in my favor, as because the covenant was changed after the publication and receiving the bid, and even after opening the bid, at the time of opening the bid, which is the penultimate situation when I cannot actually...
We hear them now, yes. Yes, Mr. Ganguly.
My lord, your lordship, may I, before I'm appearing for the bidder, L1 bidder right now.
No, no, first let me hear the states, Mr. Shenna.
No, I just was beseeching your lordship to take the matter of tomorrow. I have bad fever. I have
No, Mr. Shenna, no. I've already heard the petitioner, yes.
My lord, in this, why this, the requirement is, actually there was a supplier who is still now supplying. The quality of the food, it is supplied for the...
Not the existing supplier.
Please take your seat, Mr. Senator. Yes. Quality of food?
The quality of food, number of times there are complaints, and the quality of food are...
This arbitrary thing, suddenly
My lord, I'm just coming to that only. My lord, if I don't have anything to show from this,
After
I
the
cannot.
submission of bids, how can you do?
No, my lord, why? Actually, for the purpose of the food, my lord, if your lordship kindly takes up page 27 of that NIT, my lord, 13 June.
Page 27 of the writ petition.
My lord, writ petition. That was the 13th June, that NIT itself.
Yes.
My lord, paragraph 33. My lord, that 33. If your lordship kindly take up the rate.
33, right.
Be quoted clearly in both figures and words in specific unit. A, the bidder should not quote the rates above the standard rate for all categories of diet to ensure the quality and quantity of diet as per the rates obtained from the Agricultural Marketing Board. Well, they normally fixes up the rates in entire Bengal in all the products.
Mr. Ganguly, whatever. You could not arbitrarily fix the rates after the submission of bids.
Well, just bear me just 1 minute. I won't take much more.
What is your best point, Mr. C?
Yes, then the B. If the bidder offers abnormally low rate, she should justify his or her quoted rate with facts and figures. The tender selection committee will decide whether the rate is applicable or not. Now, well, there we have issues.
You have issues. 85 is abnormal and 88 is not abnormal.
No, we have to fix a standardized rate. What has been fixed by the agriculture?
You have done that at the time of the issuing the notice inviting tender.
My lord, if I may show, my lord, the current rate also, the existing supplier is offering much higher than this.
Maybe.
This is abnormally low, my lord. Once again,
3 rupee.
My lord,
88.63. Why this figure?
That has to be, my lord, that has been determined by the agricultural market. They are the sole authority to determine the rates that as it exists today. My lord, if I will show you, your lordship, I have only one copy, but I am showing from my copies only, my lord. The rates on 2000.
Why didn't you then cancel the entire tender? If you had not put it in, you should have, before issuing the tender, you should have known the rates from the Agricultural Marketing Board. Why didn't you ascertain that?
My lord, may I say on issues, my lord? If all the parties be called upon, my lord, what we have not done, admittedly, as per so far my instructions are, we have not done after
one
this.
person has already become the L1 bidder. After that, you can't do this.
L1, my lord, we can say that up to 88 is the benchmark that has been made out. My lord, how the deviation can be 5%, 10%, not less than that. My lord, the deviation is coming.
Mr. Ganguly, there was no such rider. This person quoted the lowest, which is only 3 rupee different from the others. Your cut-off rate. Now, what is the basis of subsequently we are introducing this?
Your lordship, there is a judgment of the High Court.
Please. Yes. How can you do that?
My lord, this has already been mentioned in the NIT itself that it has to justify the facts and figures what we obtain. My lord, we have obtained from the agricultural marketing before opening of the financial bid. My lord,
you should have done that at the time of issuing the notice inviting tender.
That has not been specifically written. My lord, admitted position is that we cannot change the situation. But what we are on, even today, the existing rate says is 84.60. Now the people who are supplying right now, it was at that point of time in 2016 itself. My lord, lordship, kindly may see. My lord, now if I get a bidder who is giving much lower to that rate itself, it is in 2016 itself, who are now, that is A1, who is now continuing. Well, kindly look at the rates, what they are supplying to us now.
You should have put it in the notice inviting tender. This is the minimum cutoff or maximum cutoff.
Well, that
should have been in the tender, whatever may be the reason.
Well, that is not there. Well, admitted position is that is not there. But thereafter, what we have done that as per the Agriculture and Marketing Board has fixed up, that is the government authority, that the only authority who is for this fixing of the benchmark. We cannot do that, my lord. On that basis, we have said that the cutoff is 88.63, exactly what they have quoted. We can put it on affidavit also, my lord. That has been inducted by the Agricultural Marketing Board. They are the authority, my lord, only to determine what are the exact rates or the government rates as on this date. Well, that has been taken up, my lord.
Mr. Sinha, I'll hear you after the recess. We'll continue after
Yes,
recess.
very well.
এটা চলবে recess এর পর। কিছু fix নেই তো কিছু? Yes. Mr. Ganguly, I'll continue with Mr. Sinha after this. Yes. There.
quality of food important.
My, my lord, my lord,
Yes,
may I
no
be-
mentioning now. We are in the midst of a matter. Yes, Mr. Sinha.
Continuing matter, item 14.
Your Lordship, can you hear me?
Yes.
Your Lordship, before I start,
Hmm.
I just wanted to be, will give me a brief moment to explain how this entire food thing works. Because it started in 2002, because it's very important to know why this entire problem has started. It was only in the year 2002 that the government of West Bengal started giving out tenders to private contractors to supply food to the government-run hospitals.
Right.
And thereafter, it was started in ESI hospitals also, which was done. Otherwise, it was taken place. Now, the first impediment and judgment which comes in this regard, the big judgment which comes is Bablu Mitro's judgment in 2009, heard by Justice Sanjeev Banerjee, where something very important is decided. Now, at that point of the issue was different kind of pricing regimes which were being taken up by the government at different points of time through different corrigendums after the tenderer had been selected. After the tenderer had been selected, without doing another tender, for months, extension would be given and arbitrary change would be made only after. So various parties for different considerations and got the court at that point of time had directed that every 3 years that the rates would be changed, has to automatically be changed, because the outlook, and the court gave a guidance that at the end of the day, it is not really with regard to the contractors, it is with regard to the poor patients who are actually there, and they have to be given proper food. By fighting for money, the government cannot be in a situation where the prices are lower to the detriment of the patients who are in the hospitals. Now, this is the background of that clause where, and for years, since 2009 till now, Your Lordship, I have had the occasion to do some of these matters. We have never come across a single contract, and all of my friends who do these matters, so Maitri and all are here in front of you. Your Lordship, we have never come across a clause where they say that this is the minimum year you have to quote. Why? I will tell you why also. That also is because of a judgment which has come in 2023. Now, what happens is the practice which developed over period was that there are 3 components in the price schedule, and I will take you through that also. Price schedule. One is the food products which has to be taken from the agricultural board, that is a raw material. Then you have the cooking gas, that is the second component. You have to quote for the cooking gas or medium, whatever you use. And the third one is the service charge. That is for your labor, your benefit, whatever you want to do. And it will include the taxes, if there are any taxes which are imposed on you because of the tax regime, that will also be covered in that same part. That is a service charge. What happened after Bablu Mitro and during this prevailing period is nobody would give anything on service charge. So there would be a charge which would be given for the agricultural part. If they asked for a separate cooking gas charge, they'll be given a cooking gas charge, everybody. And that was almost the same, everybody, because the agricultural board had a fixed price, everything had a fixed price. So where the difference could have been in the service charge, everybody will be giving a 0. And thereafter it will be decided on lottery, or otherwise it will. So obviously when there is no charge which are being sought, no charges which are being sought for any kind of service which is being done and payments are being made. So what would result is that the quality of the food which was being provided, or the quantum of the food which was being provided, that was compromised. And this came up for the last 1 year. I don't know how many of my learned friends who are involved in that expose are there. For the last 1 year, there are various exposes which have come over in the TV networks and all these things, that government hospitals are providing rotten food, no food, deficient food. This was going on. And this has become a really very important issue in many circles, political circles otherwise. So thereafter, Your Lordship, what has happened is in many of these contracts, whenever you are not giving a service charge or making your service charge 0, it is being rejected. And a specific clause was included in all NITs, which is also there in this NIT. I'll show that. The petitioner here has fallen into the same trap. All the other persons who have been added, wherever they stand in the final portion, they all have given a service charge. The petitioner has given 0. And 0 service charge, as per the NIT, cannot be accepted anyway, irrespective of whether he is L1, L2, L3. This is my factual point on this, Your Lordship. This is a clear factual point on this. Your Lordship, now Your Lordship, I'll take you through the documents. Your Lordship will first come to page 22, that is the terms and conditions which are there.
Yes.
Yes. Your Lordship, this is the terms and conditions. Your Lordship comes to the next page in page 23.
Yes.
Your Lordship comes to absolutely the bottom, where after financial bids 5, Your Lordship will see III. It says the rate offered, which I was just telling you, how it has to be done, should be consolidated. A, cost of raw material, B, cost of cooking gas, and C, service charge including profit and taxes if any. It is not profits if any, it is taxes if any. Well, it's profits and taxes if any. So there are 3 components which have to be mandatorily done. Now these clauses are coming in only because of the problem which has started of giving 0. Now Your Lordship will come to the next page, is page 26. That is with relevant of how to furnish rates. Your Lordship has found page 26.
Yes.
Your Lordship, the first one is cost of raw material, second one is cooking gas, and the third one is cost of services including taxes if any. The cost of service charges including taxes if any will have to be shown separately for tea, breakfast, lunch and dinner for each category of diet. Now, I will just come to this one point which I perhaps should have explained before. Your Lordship, it is not a single rate which they are talking about, that 88 and all. It's a mathematical calculation of how it happens. Because there are 8 sets of diets which are given. There are 8 sets of diets which are given, and those diets, for each of those, I will just take you, they have also done that. For each of those diets, ranging from 40 rupees, 41 rupees or something to 85 rupees, 86 rupees, people are giving bids. Now, thereafter, what happens is the government goes into the last 3 months or 6 months, depending on the tender, of how many such diets have been required, and do a multiplier, they come to the final number. It is not a simple thing that, somebody gives 80 rupees or 85 rupees, something just comes around and I am just demarcating 88 rupees so that some people fall behind. It depends on a complete focus on how many patients wanted a dinner diet number 2, how many wanted a lunch diet number 8. I'm just giving figures, hypothetical figures, but there are 8 diets on which the different charts have to be prepared by the bidders, or everybody has done that. So in that is why it's shown separately for tea, breakfast, lunch, and dinner. For each of those 8 diets, everybody now has to provide 3 components: raw materials, gas, and the service charge component. Now your lordship comes to the next one, D. Finally, consolidated rate against each to be quoted, taking together ABC for A, B, and C. Your lordship sees page A, B, and C.
Yes.
All clearly demarcated that you have to provide something for C. For the supply of each category of diet. As I was indicating, 8 categories of diet, each category of diet. Your lordship, I will not take your lordship longer, but last 3 lines of the D. Rates must be quoted against each category of diet and each scale of diet, and not in a single category of diet should be left unopened, unquoted. The bid will be cancelled if the bidder does not quote the rates properly. Now, this question of properly, how the rates are going to be quoted and whether you have to give 0 or otherwise, that is the domain of the technical committee, technical selection committee. Technical selection committee is not just going to rubber stamp. They have the power, and I'll show a judgment also. They have the power to reject if they think it is not going to be beneficial for the patient. Because as I was indicating, till now, and perhaps that is what has fallen from your lordship is the correct thing. The basic, it cannot go lower than that. The cumulative figure which comes, it has to be quoted. But I'll tell you the problem in why they don't quote it. I'll explain the mathematical problem. A bid is given, say in January. And the financial bid after everything will be opened in July. So the mathematical calculation of the last 3 months or 5 months will be of the last before the bid, before the tender is opened, and not when the bid is opened. That perhaps weighs, but that again can still be rectified. I don't know. Right? That is how it is. Because if your lordship sees that bid was supposed to be given in July, has been opened in November. So that period of 3 months or 6 months becomes a problem from when to calculate. Because then the host of litigation will be that when you're in November, you should calculate at November, not when the bid was done. Your lordship, then I will take you to page 27.
Yes.
Page 27. Now, this is what my learned friend for the state was, I think, indicating. Page, this is 33. Your lordship, this is. The bidders should not quote the rates above standard rate for all categories of diet to ensure the quality and quantity of the diet as per the obtained from the Agriculture Board. Then comes the bigger important part, 33B, which says if the bidder offers abnormally low rate, she should justify his or her quoted rate with facts and figures. The tender selection committee will decide whether the rate is applicable or not. So there is a proper body. It is not that they are being rejected, they are being said, no, you don't have. The tender selection committee can sit and decide whether your documents, what you have produced, are correct for showing that why this abnormally should be there. the power of the technical selection committee, all I'm emphasizing, your lordship, is that the power to do this aspect has been given in the tender itself. Yes, it is open-ended. Yes, it may be open-ended, but because at the end of the day, it is for the patients and all, and that it has been provided. That power has been provided for the tech, because they are the technical people to understand whether it will be there or not. Now, your lordship will come to page 29.
Yes.
First, I will take you, lordship, out how the selection, the rates are determined. That is in 39. 39. Calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of diet based on weighted average of monthly consumption figure of the last 3 previous years, whose rates quoted by the bidder. In case of the tie of the lot will be done, that is not important, but the reason why I think my learned friend from the state was showing you what the others, what the current supplier was doing is, this is the reason. The current supplier was giving for 3 years, that it has to be based on that. When that is lower than that, and taking the quote from the Bablu Mitro judgment, where after 3 years, anyway, it has to be increased by almost 8% or something. It clearly indicates that there is an abnormally low figure. These two aspects. Now your lordship comes to 40, which was not shown. 40 is tender selection committee's power. Reserves the right to accept or reject any tender without assigning any reason whatsoever. I'm not going into the fact that they can do arbitrarily. I'm not going into, but I'm just saying that they have a power to look into the matter and then reject if there is an abnormal. Now your lordship will come to page 72. It is part of their bid documents. And which I said, that's why, that today, perhaps, whether judging, it's not a public interest litigation, we are not judging the entire thing on its own. The petitioner's case falls, there is nothing much to argue. Your lordship will see page 72, the fifth column, service charge, servicing charge, including profit and taxes. Your lordship has seen, goes to the bottom, it is 0. Your lordship has seen, this is for diet 1. Your lordship from page, then comes to page 73.
Yes.
Page 73, this is diet 2. The rate is 49 rupees. Service charge is 0. Tax, everything is 0. This is at the time, your lordship, how it works is, the people employed to cook. This is very important for this aspect. The people employed to cook, they don't change. It is not like my cook goes there to cook. No, the cooks are already there. Servers are already there. It is the contractor just takes over the supervisory thing. They buy this rate. If your lordship sees, they buy the rate as per government rate. So there is nothing they can make money over that, unless they give you rotten food or less food. The second aspect is gas, which is again a price which is prefixed. It cannot be changed. So only place where somebody can make money by doing a venture for 3 years is by a service charge. If you are not quoting a service charge, it is a clear indication that you are going to otherwise compromise the food, because gas you can't compromise. So that is why these new clauses have been added. Now your lordship will see page 73, we have seen page 74, 75. All of them are related to different diets. Diet 3, diet 4, goes on to page 79, I think. Yes, till page 79, which is diet number 8. All of them, the service charge is 0.
Right.
So they fail on the premise of the technical bid itself, that they, and in the financial bid, that they have not quoted it. They have not even quoted it. So anyway, they are not eligible. To come up and say that I am L1, Today, even if it is taken, why did you, I'm coming to that publication later on, but even if it is taken, yes, publication is later on, should have been done correctly beforehand, should have thought over this beforehand, all of this. Will they still succeed? No, because they have quoted 0. It will be an exercise to go over again, but now that everybody's financial bid is open, everybody knows what their financial bid is on, I can understand if they were otherwise qualified. They're otherwise disqualified because of the tender conditions. They have not given a figure. Now, Your Lordship, leaving this aspect, I'll not trouble too much. Your Lordship will come to the impugned resolution which is being talked about. Your Lordship will come to page 128.
Yes.
Your Lordship will see here also, they are talking about a combined diet of diet 1 to diet 8, not one thing, and it's a composite calculation which has been done. Your Lordship perhaps correctly indicated that 88.63 should have been quoted. But this 88.63 is a figure for last 3 years sometime in October, I think. In July, it would have been a different figure. So it's very difficult to quote. On which date? It becomes very difficult to quote. But it really cannot be that after 3 years, somebody will be quoting lesser than the person who is the existing tender contractor right now. This is that is the reason why technical committees are there. Otherwise, there is no requirement of a technical committee to look into this exactly in these figures, other than the figures which are coming up, because these are all otherwise automated. Now, Your Lordship, this entire thing comes to the next page. The signatures and all were shown, but there was something else also to be shown. As I was indicating, to make it amply clear, it is also, again, Your Lordship sees on top of page 129.
Yes.
Looks at that. After evaluation of financial bid, if it is found that the average rate of multiple bidders are same, then in that case, the bidder who has the lowest rate at 5 diets will be considered as such. Next, service charge should be quoted from minimum 1.5% to 2.5%. So A plus C plus 1.5% or 2.5%. Service charge 0 will not be accepted. This is because of what was happening last year, Your Lordship. What was happening and many cases and which were coming up, this is coming. The important thing is, the financial bids were not opened prior to this resolution coming in. If it is a suggestion that there is some kind of a malafide action, there is no such malafide action. I don't know what this is at the bottom of this page, which shows 4th November 2023, but that would only be a date when nowadays for digital signature, if you are bringing something on a particular portal of yours, you're uploading it on a particular page, you need to have a digital signature in the government. Maybe that. But other people who have passed the resolution, they have passed it in September. It was not done afterwards or after seeing whose bid is what. Whether Mr. Maithi's client's bid has been won or my client or somebody, Mr. Sinarai's client. That was not the case. The case was the government felt threatened and government officials saw what was happening in other cases and everything which was going on. They have done this to safeguard, and this is only to safeguard the patients at the end of the day. Now, Your Lordship will just look at, I will not trouble anymore. Lordship will just look into one judgment which my junior will just give a copy. Your Lordship, this is a judgment of 2023, and my junior has given a copy to Mr. Sinarai and Ganguly.
Yes.
Your Lordship, this is Geeta Rani Jana versus State of West Bengal. Jana Enterprises versus State of West Bengal. I think most of my friends there already know this judgment which has come. Now, Your Lordship will see. Your Lordship will come to paragraph 3 onwards. Paragraph 3 onwards. Clause 26 of the tender conditions relate to furnishing of rates and require the bidders to furnish a consolidated rate against each of the items quoted for supply under the individual categories of diet, which is exactly the same that we had clause 33 are, 33 and otherwise paragraph 5 and all. The bidder is required to fill up the diet schedule in the manner as indicated in clause 26D. Thereafter, the dispute centers around clause 33, which requires the rates to be quoted clearly for each of the categories. Clause 33B requires a bidder to justify the quoted rate with facts and figures if a bidder offers abnormally low rates. Your Lordship sees this is exactly the same, that the technical selection committee is authorized to decide whether the rate is acceptable or not. Now, in this, Your Lordship, what happens is paragraph 6, now Your Lordship comes to paragraph 6. The point is whether the private respondent as a successful bidder quoted offers which were abnormally low as mentioned in clause 33B of the tender conditions. The rates placed before the court indicate the few of the rates quoted by the private respondents are between 25%, 30% lower. Now, Your Lordship, we don't have the privilege of using an affidavit to indicate particular individual diets, which one are which lower and all that. We only have a consolidated rate which has been filed by the writ petitioner, which shows that there is a divergence of almost 8-9% of the overall, which itself is a huge swing coming from overall of what was previously there, not what my clients have quoted, what was previously there, and not 88%. Documents have been produced, so and so. Now, Sirampur, to show that here, Your Lordship, this stage has not come. We have not produced documents and we have not shown anything because we are only doing it at an interim stage, this entire thing, exercise. But all I'm indicating, Your Lordship, is now Your Lordship comes to paragraph 8. Clause 33B. That's, I think, page 3, internal page 3. Clause 33B makes it clear that the bidder would be required to justify his or quoted rate with facts and figures. The schedule for the tender indicates that the last date for submission so and so. Hence, there is no scope for any bidder to furnish documents after the last date of submission for justifying the facts and figures quoted. So, to say the technical committee should have given them a chance to call upon themselves and all, that is also perhaps not possible. The technical committee has to be presented with all the facts at the time of bidding itself. If you are giving a low bid, you have to give them figures. The requirement of uploading complete bid documents would become meaningless if bidders are allowed to justify rates after the last date of submission. Your Lordship, thereafter, there's a question of pre-bid meeting which is not relevant in this case. And thereafter, Your Lordship holds that this kind of bids are not allowed. Your Lordship will see this is what has happened here. So, Your Lordship, taking a cue from that, this is what has happened here. The technical committee has the power and it has rejected it. It has rejected it. To say that the technical committee could not have done it at all, the only perhaps the thing they should not have done is perhaps come to the resolution and make it very clear. Had they rejected it, Your Lordship, without assigning those reasons by just saying that no, your low rates, and then I think the NIT would be okay. To say, now the argument now stems this, that otherwise technical committee, this judgment, otherwise Bablu Mitra and all those things, technical committee always had the power to reject it as per the NIT documents also, to give some semblance of reasons and reject it. But because now this resolution has come in September, much before the financial bids were opened, 2 months before the financial bids were opened, or any government authority would, or at least the 3 signatories would ever get to know what the financial bid of any of my learned friends was, to say that no, zero service charge is not allowed. This thing is otherwise not allowed. You have to ask for some profit, because otherwise it would indicate that you're going to compromise on the food. Because gas you cannot compromise, third party supplying you. You will compromise on the quantity and the quality of the food. Your Lordship, actually, most of my learned friends here knows, last year there was various exposés where they were showing that old eggs and all were being sold, being treated to everybody, and most of the non-veg diets were not even being given. So that is the basis, Your Lordship, and my submission is simply this. There's a technical committee. The technical committee has been given the power. That power is clearly enshrined in the bid documents itself. It is not that the resolution brings in that power. Even with dehouse the resolution, the petitioner's bid cannot be proceeded with because they have not given anything with regard to service charge. Irrespective of anything. That is the absolute condition, mandatory condition of that NIT, that you have to give something on service charge. You just cannot say that I'm not going to take. It is like saying that for 3 years I will not take any money to doing a service every day in a hospital. I will run a hospital's food and I will not take any money. That is exactly what is being quoted here. And that is exactly what the court in these orders, otherwise they are trying to boot it out. That it cannot be done like this, because at the end of the day, the people will suffer. The patients will suffer in this kind of melee. Because that is exactly, Your Lordship, there is another matter which is pending, where we have taken the same argument that everybody who qualifies in the technical bid, everybody who was qualifying in the technical bid was being called for the financial bid, because everybody's financial bid is the same. But that cannot be the reason, that cannot be the mechanism of how it works. Because the other two, Your Lordship, is A, B, C, A and B are constant. The only difference can be in C.
Yes.
Very well, Your Lordship, these are my submissions.
Right. Yes, Mr. Sinara.
For the respondent, private respondent, 6 to 12.
He's also for the other private respondent.
Lordship, he's for 13, I'm 16.
In any event, you have no locus standi because
I'm also selected. I have made a
part. You won't be the L1 bidder, either him or him.
Lordship, I'm also selected bidder. Lordship, they have made me party. If Lordship allow me, I can submit, Lordship, because the corrigendum, the resolution adopted by that is entirely change the terms and condition of the tender. Lordship.
You're supporting the petition.
Lordship, I shall take 2 minutes time, Lordship. Page 27, Lordship.
27, yes.
Lordship, first clause Your Lordship has seen. I am not. Second clause. The
Your private respondent numbers?
I'm 6 to 12.
Yes.
Second clause also placed before Your Lordship.
Right.
That is abnormally loaded. Clarification should be there. Third clause. In case of tie of rates, the successful bidder will be decided of draw of lots. That also change. Lordship, to suit the petitioner, Lordship, they have done this 128. At 129. After evaluation of financial aid, if it is found that average rate of multiple bidders are same, then in that case, the bidder who has the lowest rate, at least 5 diets from diet 1 to 8, will be considered as L1. Entirely change.
No, lowest rate in any event, even as per the
tie.
There was no tie in this case, Your Lordship. There was no tie.
Tie is not even. Will be considered as one.
After evaluation of financial bid, if it is found that average rate of multiple bidders are same, right?
Lordship. Then at least 5 diets from diet 1 to 8, at least 5, they will consider at least 5 diets. Change has said, Lordship and Lordship, my learned friend has praised that service charge, Lordship. If any, the word has used, there is if any. That means they insist you can quote 0.
Your Lordship, tax.
Lordship, they have fixed at 1.5.
Where is that language, if any?
Lordship, he has relied, Lordship, page 29. Sorry, 28, I think.
No, 27, he said.
27.
Your Lordship, page 23, 5.
23.
23, 25.
Right.
It is after tax, it says if any. Because tax is not levied on the government. Yes.
You have already argued.
The rate offered should be consolidated. That is A, cost of raw materials. B, cost of cooking gas. C, service charge including profit and taxes even.
So that pertains to taxes,
Profit and taxes. Lordship, can you see the column?
Not service charge, if any.
Lordship, column C. Page 72, column supplied by them. Page 73.
Them means?
Authority. Authority has prescribed this column, this chart,
yes.
And we have to put the rate.
Yes.
5, Lordship. 1, 2, 3, 4, 5. Top. Service charge including profit and taxes, if any.
So that if any pertains to profits and taxes.
All everything. Service charges, stop. Service charges including. Service charges including, Lordship, the word including.
Yes, including what if any is if
Service charges including profit. These are single column.
Service charges can it be if any?
Including profit and taxes. That means service.
Anyway, that's one of
And
the
Lordship, they have changed entirely, made that clause that 1.5 to 2.5. And when Lordship taking granted that the resolution 4th September, what is argue, my land friends? That is after completion of the submission of the bid. Can they do this? After submission. And he is saying that decision was taken 4th September and it has been uploaded in the portal on November. But Lordship is a e-tender. So unless and until they have put it in the portal, bidders will not come to know what is the fate of the thing. What is the resolution they have taken. And that has been done admittedly 4th November, after completion of everything. This is arbitrary, Lordship. Other
4th
part,
September, even 4th September, the date of that is also subsequent to last date of submission of bid.
Lordship, last date of submission, best
Even without going to the date of publication, even the date of that when it was entered into, that is also that
July.
argument
The
remains.
last date of submission, July.
So even if it is 4th of September,
That is my argument.
it
If
is after that.
everything is over. So this is my submission. Let's not put that.
Yes, Mr. Sinha.
Yes, my lord, entire thing has been made. That is, entire covenant of the contract has been affected and changed after submission of the bid.
That don't reiterate.
Yes, my lord. And thereafter, my lord, I'll draw your lordship's
What is your
attention.
reply to Mr. Sinha's arguments?
Yes, my lord, I'll draw your lordship's attention at page 33, my lord. And my lord, it will be appearing from the page 33. That is the diet 1. That is the diet 1 means that is the normal patient diet. Admitted patient diet.
What about service charges being 0?
My lord, service charge has not been made compulsorily be given something, my lord, because that has been made after 4th September.
Can there be any service without service charge? How will you?
Actually, my lord, these are the cost, my lord. That is, we are buying from the market and supplying to the offices, and there are certain profits are being made, my lord. And that is the reason the practice made by the contractor to provide the service charges 0. And my lord, this is the.
No, I don't understand. Please repeat.
My lord,
You're buying from the market and cooking it.
We are
cooking it. The persons who are cooking, they have to be paid.
No, my lord. The cooks and alls are being paid separately from the government itself.
Achha.
That is in the column below. The minimum wages including bonus as fixed by the government of West Bengal.
That which column? Page?
My lord, page
Oh, minimum, last column.
33, last comment, remarks.
Right.
Will be reimbursed separately as per manpower guideline given in terms of the condition no wage.
No, not that. You have to pay according to their guidelines.
Yes, I am to be reimbursed for the same. This manpower, that is this much manpower which I am providing, and that is to be
There is
reimbursed.
a question of reimbursement. Minimum wages including bonus as fixed by West Bengal government time to time. ESI and EPF will be reimbursed separately as per very.
Yes, that is to be reimbursed.
Right.
And my lord, then my lord, I am coming to the second column. The items to be provided, that is category items to be provided, then cost as per agricultural marketing rate. My lord, this agricultural marketing rate is for the diet 1 is 122.06.
This is your submission, your bid.
No. This is
General
the
format.
schedule of the tender.
Yes.
That is the rate fixed by the cost of the that is the agricultural marketing board. And my lord, that is their minimum rate is 122.
So minimum rate is already given there.
Already given there 122.
What Mr. Sinha argues is due to the time lapse in between.
No, time lapse is
Valid.
this rate is valid for 180 days, which is already been lapsed. And my lord, Mr. Sinha is referring Bablu Mitra 1, my lord. And my lord,
Bablu Mitra 2.
yes, Bablu Mitra 2 is already come before your lordship.
Oh. Yes. But you are also Bablu Mitra, I hope no.
So this is the rate which has been proposed by the Agricultural Marketing Society, my lord, and the 4th September's resolution shows that the rate of the food is 88.63. So the state cannot claim sanctity that they are this rate has been given, benchmark has been made for the benefit of the patient itself. So, my lord, this is the in the resolution they have said that the entire 8 rates has been given, my lord, quoted, and the average of entire 8 rate is 102.48. Even that is these rates which has been proposed by the government, that is even lower than the rate average quoted by the authorities. So, my lord, this resolution is not only vague.
So one other argument was made, Mr. Sinara, by the state that your rates are even lower than the previous, the existing suppliers' rates.
My lord, let's assume this 88.63 is the rate offered by the government, that below this is the cutoff rate, and I have offered 85 point something. So my rate is
The variation is not much.
Not much, not very gross. Even there is a provision, my lord, that if I have quoted abnormally low rate,
yes,
before rejecting my bid, they have to seek my clarification. I shall clarify that why I have offered the zero service charge rate for the service. I have quoted zero service charge and the 3 rupees less. These are all my submissions, my lord.
And your bid has not been rejected as such.
No, my bid has not been rejected as such.
Half a minute, my lord. I'll take just only half a minute. My lord, that has been shown just now. Page
Then Mr.
30.
Sinha also gets half a minute if you get half a minute. Yeah, obviously, I
My lord,
shut him
no,
out.
only with respect to this, the document 33 at page, my lord, that indicates only about, if your lordship kindly takes up page 33.
I'm there, yes.
33
I've never
is,
moved
at
away
the
from
bottom, that is that one only. The average cost 122.
one.
And thereafter, my lord, the immediately next page, that 2.
Hmm.
The 66.75. Thereafter, my lord, 112, that is that 3. And this way it goes on. And my lord, at 128, the average cost is out of this 128 that. My lord.
Yes, I am saying so.
That is 88.
He's
My
saying
lord,
that.
as it has been said, 122, it has been made an average of this, and that says
He said he has adhered to this.
And my lord,
if that is so, then thereby it is abnormally low what they have quoted.
My lord,
They have adhered to your own format.
Well, no, not
This-
this,
this-
one. But what I am on, their average doesn't comes to that one. That is what the issue is.
So why didn't you just reject them on that ground?
Well, we have made out a notification that look,
What is the basis of this magic figure 88.63?
this is the calculation.
Yes, my lord, that is the logic.
This calculation.
Well, that will come up. Well, that is the average. Well,
What is the need of issuing a rejoinder? And
well, no, the resolution that we have
if
taken
it is already there, that will be the basis of your rejection.
My lord, why? As it has rightly pointed out, my lord, I am grateful that Mr. Sinha has said that at the initial stage,
Yes.
what was that point of existing time, the market value that has been ascertained. That is an approximation.
You can change that after the bids are given.
My lord, why? Because these changes, my lord, this is a food. This is for the purpose of hospital. My lord, every time, if I fix
Hospital
it,
is the windmill you are citing every time.
my lord, no,
Hospital, because
my lord,
yes,
why?
you knew it was
Why,
hospital.
my lord, why? Because in between, if there is influx or any change, ultimately it indicates categorically we have to post that it will be a threat to the only it has
Ganguly,
to be
that has to be
compromised and
taken
nothing
care
otherwise.
of in your contract if necessary.
That's why this clause
You
has
cannot
been made.
deviate from the bid without cancelling the entire tender
Well,
process.
that's why this clause has been mentioned, that we'll figure it out that day. Otherwise, there is no
Tell us.
relevance of this clause, my lord. As I have indicated, my lord, I rest.
If there is no relevance, I'll strike it out. Let it not be there.
My lord, but it has to be, because otherwise,
So there is some relevance then.
My lord, it has to be ultimately the compromise with the food only. There is no other way out.
Due to your tender language.
Well, that's why we have
You did not contemplate this in your
well,
tender.
that's why only I have pointed out only that one page. That is 27. Why we have taken these 3. That means
You should have reflected whatever you had to reflect in the inception, at the inception, or kept a provision for that, Mr. Ganguly, that this should be done at least prior to the last date of submission, so that they have sufficient time, each of them have sufficient time. Suppose if he knew that you have added this clause also, service charge cannot be 0. If he knew, he might have added some service charge and calculated with the others.
But
if he knew, his rate might have been 88.63.
But ultimately, that rate coming, the lesser
That's
than
the
the
rate he's
existing
giving
rate.
unilaterally. He's giving on the premise that these clauses are not there. He is adhering to the terms of the contract. He is giving a quote. If he knew that service charge cannot be 0, he would adjust with the rest of the amount and he would make it 88.63 exactly. And then Mr. Ganguly, the risk is, if you say this is the cutoff rate 88.63, I'm telling you, if there are 100 bids, all will quote 88.63 itself. Mr. Ganguly, it's very obvious.
Yes.
All the 100 bids will be 88.63, not 1 rupee, 1 paisa less or more. I'm telling you, that is what will happen. It's common sense.
May I join your lordship?
This is the cutoff. Yes.
Only one point.
Hmm.
The fact they have adhered to the conditions is wrong. That perhaps is my humble submission is wrong.
Neither here, not there, Mr. Sinha. They have not. Their bid has not been rejected at all.
Your lordship, may I be just submission?
They have changed the rules of the game after you.
Your lordship will leave the resolution aside. Leave the resolution aside. I'm not going to argue with the resolution.
No, I'll not leave it aside, Mr. Sinha. I'll set it aside.
Yeah, very well. Your lordship set it aside. Your lordship, then also this writ petition fails because at the end of the day, in 5 III, it is clearly indicated that you have to charge service charge. You have to do that.
That will be premature. It was not done by the authorities. You are
no, it is there. It is there in the tender conditions, your lordship.
No, Mr. Sinha, you cannot argue that their bid ought to have been rejected, which has not been done by the tender issuing authority.
No, I'm not going into that.
The premise of your argument, definitely not. We cannot.
I'm only indicating that they themselves.
The validity of that bid when the tender issuing authority has not rejected it. How can you do that?
Your lordship will send it to the tender committee for re-evaluation. Your lordship will send it to the tender committee for re-evaluation. But I am rather than see what happens here is, your lordship, everybody, if this bid goes, this tender goes, it will take 8 months to 9 months for the entire thing to be done again. Who benefits is the existing contractor. And that is exactly the existing contractor sits behind and all these matters are done.
You're right. That is a valid argument, Mr. Sinha. That also has to be taken care of. You are right.
All I'm saying is that your lordship will send this to the technical committee. The I've shown the judgment which says the technical committee has all the powers.
Yes.
That judgment clearly says that
it's over now. Yes.
Okay.
Heard counsel for the parties. Arguments are hearing is concluded. Judgment is reserved in the matter. I'll be as fast as possible. Yes.
Lord, Jagadish Mandal has been referred, but citation has not been given.
Next.
ওর মধ্যে দিয়ে দেবেন
15
দ্বিতীয় জাজমেন্টটা নিয়ে নিও উপরে পি লিখে দেবে লাল yes
I beg to appear for the petitioner, my lord, but
use the mic please. Yes,
my lord, I beg to appear for the petitioner, my lord. We had challenged the sale notice by the bank authorities, but that was because the learned DRT bench was not there at that point in time. But what I have gathered is, my lord, this challenge has become infructuous because no action has been taken.
Appearing on behalf of the defendant number 4, 5, and 6, my lord, Indian Bank. Yes.
You agree to that?
Yes, my lord.
Learned counsel for the petitioner submits that the challenge has become infructuous since no action has been taken on the basis of the impugned sale notice issued by the respondent bank. Push-up affidavit of service filed today be kept on record. Push-up learned counsel for the bank corroborates the submission of learned counsel for the petitioner. Accordingly, WPA 2593/8 of 2023 is dismissed as infructuous without any orders to cost. Thank you.
Deeply obliged.
Yes.
16
I appear for the petitioner.
To appear for the respondents along with Mr. Indrajit Dashgupta.
Appearing online,
he was supposed to.
Anyway, let us hear the petitioner. Here for the petition.
My lord, here the service, my lord.
Which respondent are you appearing for, Ms.
1 to 4, my lord, except the private respondent.
Private respondent, my lord.
Private respondent has been served.
My private respondent has been put to service, my lord, but it has come service with left without instructions. May I, my lord?
Without instructions, you have served them.
My lord, I have served on the registered address in which the tender was granted. I have served on that address only. I just came back.
Very. What is the matter?
My lord, it's in this matter, my lord, I am.
Shahadatta, please take your seat, both of you. Yes.
My lord, in this matter, my lord, I am challenging the process of granting a tender, and it is being granted in illegal and arbitrary manner. Now, may I show, my lord, first of all, the tender conditions NIT, but it starts on page 25. It is, my lord, regarding the NIT, regarding the operations and maintenance of
early fire alarm system for SRFTI Kolkata for the year 2023-24. Now, my lord,
what is the SRFTI?
My lord, this is Satyajit Film and Film Television
very, very,
for
yes.
2024. My lord, it was for an amount for 25 lakhs of odd. Now the technical bids were invited, and I was the L2 bidder. It was granted to the L1 bidder for 70 lakhs 60,000. Now my challenge is on two counts, my lord. First of all, my lord, this tender was granted in violation of the general guidelines of e-procurement, a central public procurement portal dated 7 June 2009.
The tender clauses itself, terms itself.
10 clauses I will come later, my lord. May I say first?
You're challenging the tender terms.
No, I'm not challenging the terms. I am saying that this process of granting the tender violates that's the general guidelines. May I show you the guidelines first, in which I am saying that that is violates. Now, may your lordship, my lord, come to page 57 first. Here, your lordship will find, my lord, a chart.
Right.
My lord, on the right hand side row, second row. The second, my lord, paragraph. Second, not the third paragraph, the bid evaluator. Have you already got it, Mal?
Bid evaluated, yes.
Yes, the bid evaluator is authorized to upload the results of various stages of bid evaluation. The next stage is, my lord, minimum of 4 bid openers must be configured against each tender to avoid any issues in tender opening. Near I pause here for a minute, my lord. There was no 4 bid openers in this case, my lord. There were only 3. I was the L2. The third one was rejected at the technical stage only.
What is this configured? What is the exact meaning of this? Minimum of 4 bid openers must be configured.
My lord, in simple terms, in balance means it must be 4 bidders for the tender.
Very well.
There is first violation, my lord. Next, my lord, I may take your lordship to page number 64 for once. Now here, my lord, your lordship will say, here's a chart also. Well, after the chart comes, my lord.
How many total bidders were there? 3.
3. The one was rejected at the technical committee itself, and in financial bid, my lord, me and the respondent number 5, the successful bidder was there. I was L2. Now, my lord, in that page 64.
Page 64, yes.
No.
Page 64,
my
right?
lord, in the page 64, your lordship will find a chart. Now, my lord, your lordship then comes to the third paragraph after the chart. Now, my lord, your lordship will find that visibility of bid documents enabled to participating bidders after technical opening of the tender. Here I pause of the moment. That no, I may submit, my lord, that no stage of the tender granting process, the technical credentials of my co-bidders were visible to other co-bidders. That is the violation that, my lord, that was made. So, my lord, even if I wish to check credentials of my co-bidder, I don't have an option. I don't have an option to verify their address. I don't have the option to change their credentials, nothing. There's a very glaring, my lord, fact. Now, my lord,
till today, it's not visible.
No, it is
after the technical opening of the tender, it was never visible.
No, my lord.
Very well.
Now, my lord, this is regarding the general guidelines. Now, my lord, having come to the clauses, the second of all the thing is that the rate that has been quoted by the L1, in my submission, my lord, is given in the abnormally low rate, and that is in violation of the provisions of the Minimum Wages Act and also the GST provisions, which are mandatory to be followed here. Now, may I show your lordship where in the tender documents this provisions were made. Now, my lord, if your lordship first comes to page 32 for once.
Yes, 32.
My lord, if your lordship, my lord, goes through all the provisions, here is mandatory that the rate quoted by every bidder should be inclusive of GST. So, GST provision is applicable in this way. Yeah, I'm only showing your lordship, impress on lordship, the GST provision is applicable. Next, your lordship, if your lordship comes to page 49 for once.
Yes.
Now, if your lordship may be kind enough to come to paragraph 4, that is para 2.9. My lord, may I place upon my lord?
Please.
Contractor will have to follow order of a Labour Commissioner C, Government of India regarding hike of minimum wages and pay their engaged labor accordingly with individual bank accounts. So, my lord, the provisions of Minimum Wages Act has to be followed up. Now, my lord, in my humble submission, the rate quoted by L1, that is 17,60,000, will violate both the provisions of the Minimum Wages Act and the GST. It can't be so abnormally low. Now, my lord, I have also provided a calculation chart that is on page 71 regarding what should be minimum quotation amount without violating the provisions of minimum wages and the GST provisions. But I am given an impression, my lord, that regarding that it was done in utter haste in support. There are two things had not been materially given. But anyway, that is a chart, and that is also substantiated by the circulars of the Labour Commissioner. My lord, I have also annexed those. If your lordship, but it is purely mathematical. Now, if your lordship wishes to think, I can give you a prima facie idea of how the calculation is being made for reference.
Work order has been issued.
My lord, it's in page 70. It's I was under impression, but as per my instruction goes, the formal agreement has not been entered upon.
Difficulty is the work cannot wait.
But my lord, the issue is that palpably violates the provisions. That's it.
No, the difficulty is you are Mr. Ghosh.
Yes, my lord.
Mr. Ghosh, the difficulty is that regarding the calculation, they're entitled to probably affidavits. Otherwise,
I will short evidence. I will take short time. Let them corroborate.
Yes,
and another starting, my lord, that in the address in which they are being granted, that is being coming up return with left with instructions. I doubt.
There's a doubt on that also.
Yes, I have doubt regarding. If I'm allowed to say, there was never an avarice regarding that, and also regarding the place of existence of the successful bid.
My lord.
Yes, Ms. Sadatto, even apart from that minimum wages thing, the other violations, what do you say to that? Page 57, page
My lord, as regards the minimum
those are sustained, then the tender goes in any event.
minimum wages laws, my lord, we are not saying that they are not entitled to provide the minimum wages, but since the department must see that is my instruction. But since the wages have not been disbursed as yet, my lord, so
how do you overcome page 57 and 64? Apart from that,
it's a
calculation. Page 57, 57, please come to that. There is a e-publishing module and all.
3 bidders were selected, my lord. That is my instruction.
See, it has to be minimum of 4 bid openers must be configured. How do you explain this?
My lord, kindly let me take instruction in the matter. In this regard, my lord.
And what about page 64?
As regards
visibility of bid documents.
My learned friend, he was just saying that he got the address from the.
No, that address I got from Google.
From just now he said that from what has been given in the tender.
Yes, you actually said that.
Yeah. No. The successful bidder right. Point number 5 is I got from Google. But the person who has been disqualified in technical bid, he is a person residing outside Kolkata. So I didn't get that of that address. Got of the address. Otherwise, I would have made him apart.
Learned, how soon can you take your instruction, file your opposition within a week?
I will.
Within a week. Just these points. I'll enumerate the points.
My lord.
The impugned tender has been challenged primarily on 3 counts by the petitioner. First, it is submitted that there are 2 palpable violations of the general guidelines for e-procurement under Central Public Procurement Portal dated June 7, 2019. Annexed at page 55 of the writ petition. As per clause 2 of the said e-procurement module, minimum of 4 bid openers must be configured against each tender to avoid any issues in tender opening. In the present case, there were 3 bidders in total, out of whom 1 was rejected at the technical evaluation stage, leaving behind the petitioner who turned out to be L2 and the private respondent who turned out L1. Hence, the minimum criterion of 4 bid openers was not followed. Next para. Secondly, in the penultimate bullet point of the same module, visibility of bid documents are to be enabled to participating bidders after technical opening of the tender, comma, which has not happened in the present case. Full stop, next para, that apart, comma, learned counsel for the petitioner harps on the calculations given at page 71 of the writ petition, comma, which it is submitted are rough calculations, comma, indicate that the price quoted by the L1 bidder of rupees 70,60,000 could not satisfy the conditions of the tender, comma, two of which, as evident from pages 32 and page 32 and page 49 of the writ petition, is that there has to be GST compliance and compliance of the Minimum Wages Act, comma, which could not be possible at the said rate. Full stop, next para, affidavit of service and envelope returned without service on the private respondent today be kept on record. Full stop. It transpires from the said envelope that although the petitioner sought to serve the private respondent stroke successful L1 bidder at the address as appears from the bid of the said tender, comma, the same has returned without service. Full stop. It is argued that as such, comma, the validity and identity of the said entity is also in doubt. Full stop, next para, learned counsel appearing for respondent numbers 1 to 4.
My lord.
1 to 4 at the outset points out that if the bids of all the tenderers were not visible, comma, the petitioner would not be able to ascertain the address of the L1 bidder. Push up, next para, that apart, comma, learned counsel controverts that the GST and minimum wages contravention, as argued by the petitioner, has been given a premium by the tender issuing authorities. Full stop. On instruction, it is submitted that the respondents shall adhere to the Minimum Wages Act. Full stop. Next para. As regards the other violations regarding alleged non-compliance of the general terms of e-procurement, comma, learned counsel for the respondent numbers 1 to 4 seeks to come back with appropriate instructions. Full stop. Next para, to enable the respondents to controvert the allegations made, comma, the respondents are directed to file their affidavit within bracket S in opposition within December 11, 2023. Full stop. Reply, if any, shall be filed by December 14, 2023. The matter shall be listed under the heading upgraded matters on December 15, 2023.
Deeply obliged, my lord.
Thank you very much. Original.
Your Lordship takes up original side, my lord, may I mention a very urgent writ petition? But this is a tender matter. Well, Lordship, the EMD amount, the check.
What did you mention in the morning?
Lordship,
this is appellate side.
It's appellate side.
Mention tomorrow. If you did not mention in the morning, mention tomorrow, sir.
Tomorrow.
Mother, audience. Lordship, may I have your Lordship's kind leave to mention one or
original side?
Yes. Item 14 in today's list, my lord. Lordship, my lord, the matter is running in the list for more than
all the matters are running in the list because the first few matters are going on and on and on.
My lord, it was not necessary to mention before your Lordship for any upgradation or because there was no such urgency. But now, my lord, under compelling circumstance, I am mentioning, my lord. Lordship, this is tender matter. My lord, pre-bid minutes was recorded, and my lord, there was a corrigendum wherein, my lord, the original document was suppressed and some fraud has been practiced. The manufactured document came into picture, which is being acted upon.
You can decide that only when you take up the matter.
Lordship, my lord, kindly appreciate the urgency, my lord.
So all the matters are urgent. I cannot take up because of the first.
My lord, kindly appreciate the petitioner has received a communication through email that the buyers are, my lord, interested in
Let us take up the first matter, Mr. Dattu. No.
Lordship, my lord.
No upgradation. Yes.
Lordship, the day after tomorrow is the closing date for the last communication.
Nothing doing. Call on the list.
Item number 1.
Yes, Mr. Bhattacharya, let us be brief now. Yes.
My lord, Mr. Datta was placing, my lord, the 2010 policy.
Yes.
My lord, this is that matter where, my lord, in terms of the catering policy, I was awarded the work orders in respect of 5 different trains, my lord, running from, my lord, within the jurisdiction of our High Court. Now, the trains, I have paid the enhanced license fees. There is no quarrel with that. Now, my lord, Mr. Dotto invited your lordship to certain pages. My lord, may I just for, my lord, a brief recapitulation, my lord, kindly takes the catering policy of 2010, which is 313. That is, my lord, volume 3.
Yes.
And, my lord, the relevant clause is at page 328.
So what is the place? Formulate your points.
My lord, the issue before your lordship is a challenge thrown to the first annexure. The first annexure is page 41.
Half a minute.
I'm sorry. I'm sorry.
এগুলো কি বেরোয় গো যখন কিসের কি জন্য রোজ মামলা হওয়ার সময় ইরিটেটিং লাগে রোজ অরিজিনাল সাইডের সময় কেন ওঠা লিস্টে প্রিন্ট আউট আগে থেকে বেরোনো কেন হয় আগে থেকে বার করে রাখতে হবে নয়তো এখানে যে মামলা চলাকালীন প্রিন্টে এসছে এটা কি কারখানা চলছে নাকি রোজ এক জিনিস হয় আগে বার করে রাখতে হবে নয়তো আগে অন্য জায়গা থেকে বার করবে ঠিক আছে এখানে এসে লিস্ট বার করার দরকার নেই মামলা চলছে তো এখন ইয়েস প্লিজ কন্টিনিউ
No, my lord. Page 41.
No, your points. Yes.
You know, in terms of page 41, they have saddled us, the writ petitioner, with a responsibility to pay an enhanced license fees.
Right.
Not in terms of particular this order in lieu of CC 60 of 2019, which is at page 364 of the writ petition.
Yes.
Now they say that in terms of CC 60, which per se does not have any manner of application and which, even if it applies, my lord, it is completely, my lord, beyond the power of IRCTC to, my lord, saddle us with any responsibility because the principal policy is by the railway board.
Mr. Dotto was going on showing the powers of the how far it has been conferred.
Now, and my lord, kindly see CC 60 for a moment. That is at volume 4.
Yes.
It's 364.
Right.
My lord, after reference to the commercial circulars and everything, my lord, this is how a review of menu and tariff of prepaid Rajdhani, Shatabdi, Duronto trains and standard meals that are provided to passengers on payment basis has been done, taking into consideration the requests received from IRCTC and the recommendations of the menu and tariff committee set by the board. Based on the above, the competent authority have decided the following. Not instructions for Rajdhani Shatabdi. This is the revised menu. And my lord, kindly takes
the only corresponding change which they could make to the license fee,
yes,
corresponding with the increase in tariff, was pertaining to tea and coffee.
Yes,
and not the other thing.
Nothing.
This was the argument.
That was the argument.
And is specifically referred to pages. I have taken note of.
Yes.
Yes.
Now, my lord, CC 60 does not say, subject to correction, anything regarding the license fee apart from saying something in page 366.
Yes. Let us see that.
Paragraph 3 at page 366.
Paragraph 3, yes.
My lord, in order to bring quantifiable improvement in the quality of catering services on IRCTC shall put in place foolproof systems and appropriate operation contracting models to ensure that the tariff increase results in visible improvements in quality of hygiene of food, reduction of complaints, and does not give any undue benefit to the service provider. IRCTC shall be accountable for ensuring improvement in quality of food and reducing complaints in catering.
This is relevant.
That is, this is the only wheel reference regarding this improvement part, but that has got nothing to do with license fees per se. Now, coming back to the the 2010 policy, I invited your lordship's attention to page 353 for a moment.
353, yes.
I'm sorry, 313 to 353 is it begins the catering policy of 2010. The relevant clause is clause 18.3 at page 329, 330. At page 330, it begins from 329, fixation of license fee. Now, my lord, this entire policy has been promulgated by the Government of India, Ministry of Railways. That will appear from page 313. Now, 18.3 says, at the time of renewal of license, license fee should be enhanced, reassessed based on actual sales turnover of the unit. License fee will be reassessed and revised at the time of each renewal, subject to a minimum of 10% increase over the prevailing license fee of the unit. To arrive at a realistic figure, zonal railways will ensure that a fresh assessment of sales turnover revenue is conducted during the peak period and lean period, that is within the periodicity of 3 months, periodicity of 3 months, in order to assess the actual sales turnover so as to fix the revised license fee. Renewal will be done for the existing licensees only on withdrawal of court cases, etc. I mean, this is the only clause pertaining to this license fee and the enhancement thereof. Now,
2010 policy.
Yes. Now, this corresponding 18.3, there is a 2017 policy. Now, we were all awarded the work orders. Your Lordship may mark, there are 5 trains involved here. 5 trains involved here. Train number 15648, the relevant trains, that will appear from page 41, the impugned document. The relevant trains, your Lordship may mark against it, that we were awarded the contract. First 15648 is 17th October 2014. The letter of award, that is page
646.
15648.
I'm sorry.
Annexure 2.
Yes.
That is the letter of award is page 52.
You are awarded only in respect of this train?
No. 5 trains.
You're giving the dates?
Yes, the date, the letter of award, just for, if your Lordship wants, because 2010 policy, in accordance with the 2010 policy, at the period of time when 2010 policy was in operation, we were awarded.
These contracts?
All these. All of them. 2010.
That means between 2010 and 2017?
My lord.
Very well. You're saying that I'll take...
one was in 2016, 15646. And one was in 2015, 12505. But all are within 2017. Now, the 2017 policy kindly notes. That is 279.
Why should you look into that policy?
Because, 2017 policy, it says that whatever was there in the 2010 would per se apply. I'll just show your Lordship the relevant clauses. 279 kindly comes. 279 is volume 3.
Yes, got it.
I invite your Lordship's kind attention to 3.7.4 first at page 281.
Yes.
3.7.4. IRCTC shall determine the menu of standard meals in consultation with zonal railways, keeping into consideration the local taste and cuisine. The standard meal served in trains shall be within the fixed tariff approved by Railway Board. This is one. Then, please see clause 14. Clause 14, the menu and tariff. That is again, Milord.
Yes. So why are you stressing on these? License fees.
License fees issues is at page 292.
292.
That is only for static units.
Not trains.
Not trains. 12.
Which clause?
Clause 12. 292.
Yes.
For static.
For static units.
Yes. And my lord,
What are static units?
the static units are those units, my lord, operated by IRCTC.
In the station, in the station. Right.
And my lord, I also request your lordship to kindly see clause 20.2. 20.2.
Where? Which page?
My lord,
295.
at page 295. I'm sorry.
20.2, yes. Yes.
You know, the tenders that have been finalized and letter of award issued prior to the date of notification of this policy, all of us are covered by this, shall be allowed to continue as per policy guidelines prevailing at the time. Zonal railways will cancel all such tenders and return the earnest money to the tenderers in cases where LOA has not been issued before issuance of this
So
circular.
you are not governed by these.
We are covered by, because of
2010.
the 2010 policy.
Yes.
So therefore, 2010 policy, in terms of the 2010 policy, the enhancement part is indicated. How the license fee is to be enhanced to the maximum of 10% and nothing beyond that. And that too by the Railway Board, Ministry of Railways, nothing by the IRC.
Maximum or minimum? Let us see.
Well, I'll just come back
just see
to the 2010 policy. Minimum of 10%.
Minimum
I'm
of
sorry.
10%.
Minimum of 10%.
But it had to be assessed and reassessed on the basis of actual sales turnover.
Yes.
Which was to be looked into on the average of the peak and lean periods.
Minor.
And it has to be minimum of 10%.
And
So
3 months.
Yes. Yes, 3 months that average. And it may be more than 10% depending on your actual sales
Minor.
turnover.
Actual sales turnover.
Right.
Now, my lord, let us, my lord, for the present, my lord, if your lordship takes into consideration one of the renewal letters, page 301, in respect of one particular train.
All are similar?
More or less.
More or less.
My lord, the original letter of award in respect of this particular train is page 52.
301 must be similar.
Yes, 301 is the revised award.
Yes.
That this is the renewal of contract. You know, kindly see the subject at the top.
Yes. Right.
Of train number this. The original contract, my lord, will be pleased to find at page 52. At page 52. The original license fee, the license fee was 1 crore 16 lakhs and odd. The first installment of the license fee was first installment of license fee of rupees 1 crore 16. That is page 53. Now, my lord, here the revised license fees kindly sees for another 5 years. This is 329,763. That is, 3 crores 29 lakhs and odd. Now, my lord, therefore, the revised license fee has been earmarked, prefixed. We have paid that. Whatever was obligatory on our part, we have paid. There is no quarrel with that, subject to correction. We have paid that amount.
The prefix, why do you say that? I don't get it.
Original license fee is page 52, kindly see.
52, yes.
52. Please turn over to page 53.
Yes.
Paragraph 2.
By tender.
Yes. On selection, this was the license fee. 1 crore 16 lakhs and odd.
That was at that point of time.
At that point of time. This was the first award.
Right.
This is the renewal. First award is 17th October 2010.
Yes.
5 years, 2019.
What was prefixed?
The license fee was prefixed then. Whatever, the earmarked license fee at the material point of time when the letter of award was awarded was 1 crore something.
That was not prefixed, fixed.
No, fixed. I'm sorry.
For a later period, it was fixed.
I'm sorry.
Fixed, yes.
Fixed. The license fee was this.
That clause applies 10% minimum
Yes,
and all.
10% maximum or minimum. I'm sorry, minimum, right? So that clause, in terms of that clause, this is the revised award.
Right.
And we have acceded to the revised award and we have paid whatever was obligatory on our part to pay. Now, Milan, after everything is over, this CC60, on the basis of CC60, the revised award dated is 12th December 2019 in respect of this particular train. 12th December 2019. Now, then prior to 12th December 2019, there are two communications which needs to be shown. First is this 23rd September 2019, which is at page 393 of these papers. Of the same volume, of the next volume, volume 4.
390.
3.
Volume 4 is up to 344.
No,
Oh, it's a wrong
volume
page, pagination, I said. Wrong page numbering. On the cover page, the numbering is wrong. Should be 394. Oh, it should be 434. The 3 and 4 have been reversed.
It is my mistake, my lord, I take it.
Nothing.
No,
393.
My lord, the original letter of award,
Yes.
your lordship has seen.
Hmm.
That is 17th October 2014. Now they are writing to me this 23rd September. Who is writing to me? Indian Railways. This IRCTC is writing to me. Now, IRCTC writes, this office letter dated, reference is to an office letter dated 11 July 2019. Zonal Railway had awarded you a license for operation and management and supply of catering services for such and such trains for a period of 5 years. That is from 4th November 2014 to 3rd November 2019. As per clause, the license may be renewed for another term of 5 years subject to satisfactory performance. Consequent to announcement of catering policy, the said license was assigned to IRCTC by executing a tripartite agreement dated 31st October 2017. In order to consider renewal of the license for another 5 years beyond the expiry of initial 5 years, for this, the assessment of performance of the above train has been undertaken in accordance with Annexure 3 of Master License Agreement. On the basis of the aforesaid assessment of performance, you are found eligible for consideration of renewal of the above license fee for a period of 5 years beyond the expiry of initial 5 years, subject to the following conditions in view of Catering Policy 2017. We are concerned with 2. Quoted license fee will be enhanced by 10% as per clause 17.5 in CP 2010 and clause number 3.2 and 21.1 of Master License Agreement of SBD contracts. The applicable GST will be applicable after these enhancements. This is not the quoted, like this part is recorded.
Yes.
And we have also been called upon to give an unconditional acceptance to the offer of renewal as per format enclosed at page 394. 394 and the format that we have executed, because we were obliged to adhere to it. It's a one-sided thing, as your lordship knows. 395, this is the affidavit for submission of acceptance that we have furnished. They are trying to, since we have accepted these terms, unilateral terms, not bilateral. Now, these unilateral terms, they wanted us to accept. They wanted us to, pin us down by saying that if you have accepted it.
Not a nice villager. So what is
Sir, at the same time, at the same time.
With your eyes open, you are entering into it. It's not a one-sided contract. This is business, commerce. You're earning crores.
At the same time, the policy is done otherwise. The policy of 2010.
They say they are adhering to the policy.
2010 policy read with the 2017 policy. Your lordship will not find.
2017, why should I read that
they
into
say,
it?
They say with respect.
Yes.
Kindly falls back to 393. Now, they say that quoted license fee will be enhanced by 10% as per clause number 17.5 in CP Catering Policy 2010 and clause number 3.2 and 21.1 of Master License Agreement of SBD contracts. Now, the 2017 policy says whatever was awarded in terms of the earlier policy will be governed by the previous policy. The previous policy, if your lordship sees, the enhancement of license fees is only indicated in a particular clause, which I have invited your lordship's kind attention to. And that policy in any event was done by the railway board. That policy was promulgated by the ministry.
They are not deviating from that. They are adhering to that. They are complying with that.
No, yes, let us take it that in terms of these and in terms of the next page, they have awarded me page 301, 12th December 2019, indicating that this is the license.
401.
301.
That's very well.
They have awarded me. Then I have paid that. Now, in terms of this documents, page 48 and page 51, read with again by IRCTC, they are now wanting us to pay for this particular train a balance amount of 60,36,000.
By implementing page 41.
By implementing, by saying that in terms of CC 60, that is page 364, I have to be responsible to pay an enhanced 60 lakhs.
Yes, that is by virtue of page 41.
Page 41 is the communication by virtue of page 364.
Yes, very well. So you are challenging page 41 only.
Page 41,
which applies CC.
which applies CC 60, which per se does not have any power conferred on anyone to enhance these fees in this manner.
Right.
Whatever has been done in terms of 12/12/2019, the enhanced license fees has been paid. We have shelved that money. In the mode and manner I am to pay, I have paid it.
Let us see what happens if CC 60 is taken into consideration.
Yes. Now please come, fall back to 41. Your Lordship has seen 41.
Now 364, let us come to that.
Kindly come.
How does it affect you adversely? Show me that.
Nothing else.
CC 60 in my respectful submission has got no manner of application in the first place.
Don't get deviated, distracted by the chicken biryani and the egg curry mentioned. Don't get distracted, only that.
But he is
not a personal comment.
He is not used to traveling by trains. He doesn't know how tasty sometimes the food can be, though, can lead to some unforeseen
Entirely impersonal in these matters. Entirely impersonal.
Who is saying?
Yes, Mr. Bhattacharya, complete the matter. Other matters are waiting for you. People are mentioning every day. No, complete the biryani, everything, and get it over.
Completing the biryani.
Yes.
364.
Don't read the entire thing. Which part affects you? What?
Nothing.
Doesn't.
It says division in menu and tariff of catering services such and such. Commercial circular. These has got nothing to do with license fees.
Right.
So that is precisely my case. This enhanced license fee in terms of 12/12/2019 I have paid.
So this page 41 you say is dehors everything.
Yes.
CP 2010, everything.
It does not even say 301 thing I have done. 301 thing we have paid this enhanced license.
Yes, that 10%. Yes,
we have paid.
Those you have complied.
Those we have complied with. We have complied with everything. This additional 60 lakhs.
Ultimately, in terms of CP 2010.
Yes.
So which you have complied with.
Additional 60 lakhs by virtue of CC 60 is completely impermissible. It's completely beyond jurisdiction.
In lieu of CC 60.
In lieu of CC 60.
Anyway, let us hear Mr. Bhattacharya.
Yes.
Yes, Mr.
But I think my learned friend has argued it in perhaps a little vacuum. But I'll just take 1 minute to explain what this whole thing is about. But there is a license fee which he pays. There is a tariff which is fixed at which he collects from customers. These policies say that whenever there is an increase in the tariff, in other words, the rate at which you are selling your food, I will be entitled to a immediate, concurrent increase in license fee. But that since it can't be calculated right away what it will be, although my entitlement is concurrent, it will be calculated later. Your Lordship has seen the mechanism based on peak period, lean period, etc. Once that calculation happens, you'll have to pay it. I'll show that, not provision. So this is not the long and short of the policy. Increase in tariff, concurrent increase in license. This is the policy behind it. Now, in this case, what happened was, COVID came in between. Catering services were fully stopped. So we have not charged them fees during that time. Now, once it started, immediately, my lord, there could be no review. Now, he got the higher tariff, but he didn't have to pay the license fee. He was told, soon as it is calculated, you have to pay it. He signs in and he agrees to do it. He calculates, I'm sorry, Lord, he collects at the higher tariff. So that collection has happened. But now he sees that the period of the licenses are coming to an end. Now I will not pay the extra amount I have collected. Although that included an element of the increased license fee. Collection has happened. It's gone into his pocket, but he won't pay. This is the long and short of it. This is the long and short of it now, not the clauses. Now, my lord, one chronology I give your lordship. But policy comes in. After that, there is a my lord, master license agreement executed between them and the government. That includes a clause which says increase in my lord, license fees will be concurrent. That is my lord, at page 169, perhaps. 169. May I just place that one clause first? Volume 2. Now, that master license agreement starts at page 154. And he is a signatory to that.
Right.
So 154 it starts at, if your lordship takes 169, clause 8.3. In case of any revision,
Yes.
clause 8.3, in case of any revision in catering tariff, the licensee shall be allowed to sell food meals at the revised rates to the passengers. In this event, the license fee payable to railway shall be varied based on the reassessment of sale from the date of revision of catering tariff. So it's concurrent. So this is the provision. Now, my lord, like I said, COVID broke out, catering services stopped, trains stopped. Your lordship will find from the notice he has annexed, I have not charged him license fees during that period. Not that he's been charged for it. I give him, my lord, full deduction for that. Thereafter comes the, my lord, enhancement in tariff. He is collected it all. Letters are on record showing that we are reassessing. He participates in that reassessment exercise. This policy, my lord, is 2017. My lord, he is given notice, my lord, in 2019 that there is going to be that calculation reassessment. He participates, those papers are there. Not he comes and challenges it now in 2023.
2017 could not apply because 2017 gives us puts in a saving clause.
Now there's a, I tell you, lordship, there is then not an extension. He gets an extension, which is when he signed that those letters, that affidavit. My learned friend says, not very naively, one-sided contract and all of that.
Yes.
Now, tripartite agreement. Not please come to the tripartite agreement, which is at page 256. That will be the first part of volume 3, first page of volume 3. He signs an agreement on 31st of October 2017. He signs the tripartite agreement now.
Right.
So, my lord, this is between railways, IRCTC and him. So he signs accepting this 2017 policy.
So how does 2017 change things?
But I'm not
What
on
will
that.
it
Please, it really doesn't matter. But if your lordship please sees,
Yes.
IRCTC is given charge of everything. Number one, that's why a tripartite. I'll tell you, lordship, the history.
Right.
The history was at one point of time, IRCTC directly used to handle the catering. Then, Lord, under the first policy, it went out. Railway started handling it directly. Then it is brought back in. So these policies only reflect that. The coming back in of IRCTC, which starts handling it. And then to provide, Lord, further improvements, IRCTC also, Lord, provides for various different types of services. One is a base kitchen, which your lordship has found. Stations will have them. Some is on-board, Lord, railway catering. Third is now, Lord, they have these apps by which one can order any kind of food on the train. It comes to the station and it's boarded on the station. So, Lord, these policies give effect to that to enable IRCTC. Yes. So, Lord, the 17 policy brought IRCTC into the picture, and your lordship will find in the tripartite agreement, page 256. I won't, Lord, trouble your lordship, but your lordship will find that it refers to the Ministry of Railway having brought in the catering policy by a circular. That's my lord, clause 2. Then, my lord, your lordship will find para 3. IRCTC has been mandated to carry out unbundling to create a distinction primarily between food preparation and distribution. Then, my lord, whereas as per policy, IRCTC shall be responsible for management of catering services through mobile catering services, units, base kitchens, etc. And not all those existing contracts are assigned to IRCTC. That's what happens under this.
Yes.
And Lord, he is a signatory to this, and your lordship will find that I am to get the license fee. Lord.
These all pertain to Northern Frontier Railways.
Yes.
Only.
Yes. Yes.
So your clause 5 is also there. You assign contracts. And
Yes, Lord. And there is an arbitration clause also. I'm not getting into it. Clause 8.9. Now, my lord, on the basis of this, my lord, please also see. So, my lord, those tripartite agreements are annexed over here, one after the other. And then, my lord, if your lordship sees, affidavit but please take volume 4.
Yes.
Now, my learned friend placed page 393. Let's please take that letter.
Yes.
Now, he gets a renewal, but he did not sign it just for the heck of it. He would not, but like he said, his license was for 5 years. It was coming to an end. He wanted a renewal. That is when he signs these documents. Now, at page 393, your lordship will find a letter of 23rd September 2019. And I said, look, I will consider renewal provided you agree to the following conditions. Now, that's the second para. In order to consider renewal of the license for 5 years, etc. Lord, my learned friend has read it. I won't trouble your lordship. Now, my lord, what he read was clause 2. But please see clause 3. In case of revision of catering tariff, the license fee payable to IRCTC shall be varied based on pro data from date of revision of catering tariff. He accepts this not unconditionally. That's the letter, not at page 395, affidavit. Affidavit for submission of acceptance. He knows his not his extension is dependent on it. He signs it, page 395.
See, if not anything else on this, he's bound.
Yes, he's bound by this, not if nothing else. Now, Lord, yes, now, Lord, please see clause 3 of this affidavit.
Yes.
The company firm Graham Food agreed to the said terms and conditions of license as enshrined in the letter of 23rd September, which I've showed your lordship, and give unconditional acceptance. Now, 2019, he's done it. He's coming and challenging this in 2023 after having recovered the money. I would have understood if he had not taken advantage of the increased tariff. But he's collected the money and he'll not pay me, although, my lord, everything says that the increase in, my lord, license fee and tariff is concurrent.
Mr. Bachar, there was an argument that it is connected with the tea coffee thing.
Tea coffee thing, Lord.
I mean, that was that is taken
But
care
that's
of by
why,
clause 3.
Yes, correct. Lord, that's why I didn't get into it. Lord, my learned friend has gone into, Lord, niceties of it which are not applicable here in view of this. Lord, clearly, Lord, taken care of by this, Lord.
Now, what is this SBD contract? What is SBD?
Lord,
page 393. Clause
Standard bid documents.
Lord, my learned friends know better. So. Well. Yes, yes, correct. Now, my lord, hereafter, also, my lord, please come to page 403. Or rather, 402. Now, my lord, 16th of June 2022, he signs this. And, my lord, please see. Yes.
Rider means is a rider to the main agreement.
Yes, yes, yes.
Or taken for a ride, I mean.
My lord, anyone on the railways, Lord, is in for a ride. One
By
way or
definition,
the other.
yes, has to be.
Now, my lord, page 403, if your lordship sees this agreement, not clause 1. This agreement shall come into force on 4th November 2019 and shall be subject to the provisions of earlier termination as provided in the master license agreement shall be valid up to November 3rd, 2024. Now, my lord, please see, this document will form part and parcel of not the earlier agreements. And if your lordship turns the page to 404, clause F, license fee for renewal shall be further revised as per outcome of sales assessment in lieu of CC 60 2019 and any other revision in tariff.
What is this in lieu of? I mean, why in lieu of?
I don't know why they use this language. Not government language, I find very difficult to understand. But your lordship has seen that language everywhere. In lieu of, I don't know why, but whatever it is, not the meaning is clear that it will be based on the outcome of the sales assessment. How sales assessment takes place.
How is CC 60 of 2019 relevant here?
Or any other revision in tariff, it says. Not
in lieu of CC 60 of 2019 could be deleted also.
It could be any other revision in tariff. Any other. Any other. I'm not stuck by that. Now, the meaning of it is very clear. Not these are commercial licenses which have been given. But these are contracts which have been handed out. He is making money out of it, subject to not any directions given by the catering corporation. Now, what is happening here is he has collected the money. He signs 5 documents saying that, look, he will give it. We have been fair to him by not doing any assessment during that period of COVID. We wait for passenger traffic to come back sufficiently before reassessing. Now, immediately that the reassessment is done, come the notices which is challenging at page 40. Page 41, page 41. The improved notice is not page 41.
41, yes.
Now, please see. Page 41.
Yes.
And if your lordship takes the second para, I won't trouble your lordship. Further, on issuance of instructions from so-and-so under reference, EZ has calculated revised license fee on the basis of assessment of sales in postpaid SPD and non-SBT trains in lieu of, again, CC. Now, the point here is, this is being done on assessment. I would understand if my learned friend says, look, this assessment is all wrong, it's unfair, etc. And that is why the arbitration clause is there, being aware of it. He doesn't challenge the basis. He can say, look, it should be 5 paise higher or 10 paise lower. It should not be this. Now, done on this, for train, each train we have calculated, and if your lordship sees the next page, page 42, the annexure to it, I've given him full benefit of everything he is entitled to. Not A, revised license fee, percentage increase, it becomes 45. Existing license fees was 33.
47.
Increase in license fee, therefore, is 12.
Yeah.
12 lakhs. Now, difference of license fee per day is calculated. Now, please see the effective period. 126 days.
So this is corresponding with the period when the tariff was.
Now, my learned friend doesn't point out any fault here. He is a businessman out to do business. He's got 5 trains. He's made money, and your lordship can see that the amounts in this case are, and not just that, I've deducted it against the pro rata license fee, etc., to come at not the correct figure, which is roughly about 3 lakhs and odd. Now, there are 5 trains he's running. There's a calculation for each. For some it's higher, some it's lower. But not for him to say that he is not entitled to pay this and yet continue, no deposits made of this amount after assessment. He's continuing to run today. He's continuing to cater on these trains, collecting higher tariff, but not depositing the higher license fee.
Okay. By in lieu of probably, you are referring to CC 60. I mean,
Yes.
CC 60 is the increase in tariff.
It's the last increase in tariff.
Whatever, if you ignore in lieu of, I mean, put in
Yes.
something.
Yes.
Very.
But that's the last one. That's at page 364. So, it's no point getting into any further details here. It's not straight cut out. It's a question of now not paying to the government. It would be a huge loss to the state exchequer. Please give me one moment. But those are my suggestions.
Yes.
My case was, my lord, based on the power or authority. The circulars, my lord, up to CC 60, your lordship would find that there is no power conferred upon the IRCTC to revise my license fee, except that tea coffee is circular. Now, to put it in my own way, my lord, that to revise the license fee, whether based on sales assessment, I don't, my lord, invite your lordship to go into the factual dispute, because at para 47, I've said that there has been no sales assessment. But at this stage, I will not, my lord, invite your lordship to go into that, whether there was or not. Yes. But, my lord, the moot question is, my lord, somebody cannot charge anything from me unless he is so empowered.
How do you deal with the contracts you entered into with IRCTC itself?
Yes.
That empowers them, those rather.
Railway Board is a body corporate. Railway Board has been conferred with the powers of the central government, my lord, by that 1905 Act, Indian Railway Boards Act. If you go by, my lord, the Railways Act, there is only one power of delegation under section 28 of the Railways Act, which has got nothing to do with all this tariff, etc., or the fixation of license fee. What is IRCTC? IRCTC, my lord, was initially, my lord, was a wholly owned government undertaking with railways and others. Thereafter, my lord, it got listed, my lord, in the Bombay Stock Exchange in 2019, if I am not wrong. And today, my lord, the majority of the shares of IRCTC is being held by the government of India. Therefore, my lord, to delegate power, to outsource power, my lord, there has to be, my lord, some source of power both for the railways as well as for the IRCTC. But as I said, my lord, on the first day, that these are, who am I? I am, my lord, providing the amenities on behalf of the Indian Railways, which runs the railway, or the central government, which runs the railway. Therefore, my lord, I am bound by the revision of tariff. Those are to be made by the Railway Board. That is why, my lord, your lordship has noted those, my lord.
Yes.
I need not, my lord, once again, my lord, bring those to your lordship's notice once more. My lord, the respondent says that they have done it as per the sales turnover or sales assessment. Who can do this? But under catering policy 2010, it can be done only by the Railway Board. Page 330, clause 18.3.
Replace clause 17.5 and 18.3.
18.3
is a relevant clause in this context.
Correct.
Yes.
Then, my lord, comes is revision of license fee based on tariff fixation is only to the extent of tea coffee.
What was that page again?
Well, that was page 357.
357, various.
Then comes CC 60.
Right.
CC 60, my lord, has got nothing to do with revision of license fee. Therefore, we need not go into the meaning of the expression in lieu of, whether it is flowing from CC 60 or it is in replacement of CC 60. Because CC 60 had got nothing to do with revision of license fees. Therefore, my lord, the railway, IRCTC, in revising the license fee, whether based on sales assessment or not, I don't trouble you with those at this stage. Well, my fundamental case was, where is your power? You need a source of power. Even, my lord, the central government needed a statute to frame a statute, though, my lord, it is a pre-independent statute, to confer power on the Railway Board.
That section was not placed before me.
I'm sorry, my lord, which section?
You said Railway Board Act.
Yes, but that is section 2.
Section 2 of Railway Boards Act.
Indian Railway Board Act 1905.
Right.
This is a very, very short act. Please take my section 2.
I'll take that, because in either of the two, I mean, print out, I'll take a print.
None is marked. Please take my lord, section 2.
2, right.
Investment of railway board with powers under the Indian Railways Act 1890. The central government may by notification in the official gazette invest the railway board either absolutely or subject to conditions with all or any of the powers or functions of the central government under the Indian Railways Act 1890 with respect to all or any railways and with the power of the officer referred to, I don't go into B.A. Now, previously it was the 1890 Act, today we have the 1889 Act, which has repealed the 1890 Act. But that will not make much of a difference, as your lordships know,
So IRCTC has no authority whatsoever regarding a license revision.
according to me.
Right.
Well, my very respectful submission is, and my
Railways Act, you said it's a different on a different.
Yes, it's only, it confines it to chapter 5, which is opening of railways.
That is different.
Yes. Besides this, at least in the Railways Act, I could not locate any section which confers power of delegation. Therefore, in my very respectful submission, it is true that Railway Board in a tripartite settlement or through a tripartite agreement, has conferred on the IRCTC or assigned this contract to IRCTC to be more appropriate, and I am bound by that. There's no dispute on that. But the question is, what is I am being sought to be put to terms that any revision you will pay. Yes, I've given that affidavit. But that affidavit will not confer any power on them, which is otherwise not there in law.
So why not? It's a contractual power. I mean, simply you have entered into a contract. Let us leave aside those jurisdictional things.
We need
tripartite agreement. You agreed, entered into a contract with IRCTC. You are supplying.
Yes.
So it is dependent on the tariff. You agree to that, and you now have to pay.
Yes. Now
contractual enforcement.
Now, so far as the contractual part is concerned,
yes.
But once again, please look into those two clauses, which my learned friend has drawn your lordship's attention, which is clause 8.9 at page 258. No, sorry, I'm sorry. Yes, 258. Yes, I'm right. Yes. Well, it starts from 256. Please take me, Lord, recital 5.
Yes.
At page 257, and whereas North Frontier Railway shall reassign the contract of mobile units, kitchen units already awarded to IRCTC on the same terms and conditions as per the plan decided mutually by IRCTC and North Frontier Railways. Then yes. Kindly take 8. CCM so-and-so, or acting through a other authorized officer hereby assigns its rights and abilities as licensor to IRCTC, acting through so-and-so. The terms and conditions as provided in the agreement signed between so-and-so shall form the basis of this agreement. Then 8.1, CMD, IRCTC or its authorized officer shall have power to inspect the trains and impose fines, if any. So,
if you challenge the authority of the IRCTC,
yes.
Then your agreement goes.
No. My challenge to the authority.
Source is also that agreement, your source of this, I mean, enters, yes, supply, whatever.
May I say this, my lord? I am aggrieved by not anything except that the increase in the license fee post-renewal.
Yes.
It is not a case that at the time of renewal, there was no increase in the license fee. It was done, my lord, with 10% increase in the license fee. No doubt about that. I paid, I don't think, my lord, yes. So, which has been shown by Mr. Bhattacharya.
Yes.
So, my first point is, my lord, if it is covered by the catering policies and finally up to CC 60, but there may nowhere, my lord, your lordship would find, my lord, that this power has been conferred on the IRCTC to them. Now, my wrong understanding, with those, my lord, if your lordship recollects those Thika tenancy cases, that if under a wrong impression, but I submit the returns before the Thika controller, the property does not become a Thika property. Similarly, over here, Milord, these are, Milord, as your lordships have called it addition contracts. Either take it or leave it. If at the time of renewal, I was told that you will be charged with retrospective effect whenever we make our sales assessment, then I would have left it. In fact, I
says so, probably.
yes.
Agreement
No,
says so.
Yes, kindly see
pointed out by Mr. Bachar.
Milord, kindly see
93,404 probably.
Milord, the tripartite agreement or Milord, my parent agreement, please have a look to Milord, my master's license agreement, which is at paragraph page 77 and 91. Please have a look to this.
Page 393 and 404.
Yes.
He has referred to.
That is 393, Milord, which my lord is looking
Yes,
at.
yes, Mr. Dotto, 393 is that the
Clause number
renewal,
3.
renewal.
Yes.
Clause number 3, right?
Yes.
3.
Yes.
In case of revision, shall be varied based on pro rata from the date of revision of catering
Yes,
tariff.
this is very important. License fee payable to IRCTC. Where is the power to revise?
Shall be varied.
Yes. In
Based
case
on-
of revision of catering tariff, who will Milord,
That has
revise
to be
it?
read in conjunction with 2. 2 says quoted license fee will be enhanced by 10% such and such as per these clauses.
Yes,
And
that is
3
over.
says yes, that will be from the date of revision of catering tariff,
Yes.
which is quite logical also.
Yes.
Because you receive from that date, you have to pay from that date also.
Yes.
If you have to pay.
But at the most,
At the most, I mean.
at the most to that extent.
Yes.
But Milord, there has to be a power.
Yes, that argument remains.
With the power, Milord, then Milord, we have to go back to Milord those tariff orders or the policies, which again, Milord, required a clause to be incorporated to confer this power. Take an example, Milord, catering policy 2010 did not have clause 17.5.
Yes.
Or say 18.3. Then, Milord, the ordinary law of contract would have applied. Court would have looked into the terms of the contract and Milord decided the rights of the parties, whichever court. Now to Milord, to allow an increase of license fee of 10%, a provision was required to be made under the catering policy. To allow revision on the basis of sales turnover, Milord, a provision was required to be made in clause 18.3 in catering policy. Therefore, what I intend to demonstrate before your lordship is, Milord, in these kind of contracts also, the mere contractual terms will not decide the fate of the parties, nor the contractual terms can, Milord, confer a jurisdiction on the IRCTC. Because my affidavit accepting their conditions is sought to be, Milord, read against me to pin me down. But you must first show to the court that you have the power. So a wrong understanding or a wrong, Milord, concession made in my very respectful submission will not empower them to, Milord, revise the license fee. Yes, yes, Mr. Bhattacharya points out that 23/9/2019 is that letter which is placed before my lord at page 393. This is on 23rd of September.
Yeah.
On 12th, I give the affidavit in terms of that.
Right.
12th of December 2019, Milord, they revised my license fee for another 5 years with the enhanced license fee giving effect to that minimum 10% clause.
Yes.
Now, this one is a subsequent jump based on sales assessment, reassessment, or whatever it is called. Now,
Yes,
this
he pointed out he pointed that out.
Yes.
That you have already paid, but subsequently also this enhancement.
Yes. So, my case is that of lack of power, primary.
Yes.
Shall
Close arguments, sir. Before Mr. Bhattacharya can convince you further. Very well. Arguments are concluded. Judgment is reserved in the matter.
HON'BLE.
Discuss your Guwahati High Court outside the or inside the courtroom even, but not in the front row.
Not to the hearing of the court.
Yes. And Mr. Shah is waiting eagerly for you to finish. Or the other way around. I can't assist from his.
But what I can see is arbitration with food catered by IRC.
Yes, I also apprehend that. I mean, that is one of the possible fallouts.
And your lordship has heard, Milord, what the Honorable Chief Justice of India has said about the arbitrations.
Vice
So
President of
he
India.
has said many things, but which one are you referring?
Old boys club.
Yes.
But those old boys, some of them are very young men. That's all I can say.
Yes, I won't comment on that. I'm still the young boys club, so I dare not.
Item number 2.
Yes, please. Yes.
This is that matter, my lord. Now I think, my lord, they have released the coal. The consignments have now have been left. My lord.
Due to your
Due to filing of the
diligent
report.
efforts, I mean, both of you.
No, just filing of the report. But this is a problem which is
Every
occurring
time it seems.
every time. My lord.
But can you preempt that, Mr.? I was wondering the.
No, because I have given material in the writ petition
Yes.
to say that there was in effect a detention. My learned friend, they said that they have given the document now.
Yes.
I had no choice. If your lordship reads para 13 and 14 of my writ petition.
Miss Banerjee was there.
Yes,
She
yes.
was.
May not.
No, no, I
I
understand.
am just trying to explain to you.
I understand. Yes.
The paragraph 13 and 14 says
Huh.
Alipurduar district I crossed.
Huh.
Initial writ petitions were relating to Alipurduar district.
Right.
Now, because of the court's order, they are now allowing the passage.
Yes, yes.
Now, once it has crossed, your lordship will see my just pleading, not it's maybe a bit academic
No.
for my matter. I have specifically said paragraph 12, after issuance of the documents evident in the purchase of coal, obtaining requisite documents, carrying such and such, commenced its journey on November 24 from Nagaland towards destination. Consignment smoothly traveled to parts of Assam upon due verification. Accorded safe passage. Para 13, coal consignment reached Pakrudi gate near Naka Kuch Bihar.
Yes.
Paragraph 13, your lordship will say, reached Kuch Bihar, however.
Academic discussions now.
Because
this
the
is
goods have
happening
been
every
passed.
time, Mrs.
Yes, my lord.
Every time it's happening that he has a point there.
Maybe I am benefiting.
No, I understand.
But I can't come every time. So my cause of action was the refusal, because I have said the police officials at the checkpost refused to allow entry of the coal consignment, informed the driver to wait at the border of Alipurduar district until they obtain instruction from higher official. In subsequently, police official the called on a petitioner to visit the output with relevant according driver again presented all documents. And without assigning any reason, under such compelling, vehicle is still stranded at Alipurduar, approximately 300 meters from the checkpost at Kuch Bihar. Paragraph 13, page 11. Now, my lord, I have also annexed. Kindly see page 45. The GPRS showing that on that date, I am at the Alipurduar border.
Anyway, Mrs. Chen, since it has been.
Just only
In any event, nothing that my learned friend is saying is admitted as per the instructions I have received. So,
yes.
my lord, let this.
Only what thing I find that, my lord, a time-bound verification should be done. That should be in place as per the SOP. And why I say this, my lord, your lordship kindly sees one document only.
That can be done only in a proper challenge. I mean, here now in this matter,
No,
it's already a deadwood matter.
No, your lordship only sees this. The Nagaland people have informed the SP on 24th that this is the truck with this transit challan. And today, my lord, I have received this communication. The IC has communicated to Nagaland again. Verification regarding the transit pass.
So another litigation is coming up.
No. Now, the Nagaland person has also informed that I have already informed you about the veracity on 24th. You are asking me on 1st December. So, my lord, this I am only one observation from your lordship that unnecessary detention should
My
not
lord,
be. When an
my
SOP
lord, when
is
it has
already-
been done, my lord will recall on the last occasion, my lord, they had not even presented the papers. Once they presented
if
it, they
my
were
learned
allowed
friend-
to pass.
If my learned friend insists, then they should file an affidavit.
Learned counsel for the petitioner submits on instruction that in the meantime, the truck of the petitioner has been released from the concerned checkpost
at Kuch Bihar.
Puts up next para. Hence, the cause of action of the present writ petition has become infructuous, rendering further discussion on the issues academic. it is submitted by learned counsel for the state that the respondents oppose the allegations made in the writ petition. Accordingly, it is since no affidavits are required to be directed, it is deemed that none of the allegations made in the writ petition are admitted. Push-up WPO 1807 of 2023 is accordingly disposed of as infractuous.
My lord.
But a line of from your lordship that they must henceforth they must process the documents in a time bound.
And that would involve so many. I mean, that would be a conclusion. Required to be preceded by.
My lord, not only a confusion.
Context of this.
For those who are trying to really smuggle, it will become a.
That cannot be a general right.
No,
Your truck may also commit some legal violation later on.
That is what I'm saying. They may verify. I'm not.
That is the law.
That
is like saying if the law is not followed, only then you can catch vehicles. Otherwise, you cannot.
But the
that is a non-starter.
That is the problem.
No.
My lord.
Item number 3.
P. Yes.
My lord, before my lord, I could have the matter listed before your lordships.
Yes.
Certain steps have been taken for which, my lord, I have been compelled to file a supplementary affidavit. My lord, here, my lord, is a borrower before your lordship who had an initial limit, my lord. I'm not showing your lordship any papers. I'm just giving your lordship the gist first. Here is a borrower, my lord, who had, my lord, a cash credit limit of 7.5 crores. My lord, with the passage of time, we brought it down, my lord, to about 2.5 crores. After we brought it down from 2 to 2.5 crores, we said we want to sell some properties and repay you. At that juncture, they said, no, you have certain penalty on penalty, which is impermissible under the law, penalty on unauthorized debits, all that. So altogether, your bill is in excess almost 4 crores. There, my lord, the dispute began. Now, my lord, when this dispute began, although, my lord, my limit, I have brought it down, and till today, the limit has not been altered, 7.5 crores. Although, my lord, according to me, my lord, that limit has come down to 2 crores, and according to them, it has come down to less than 4 crores. My lord, they recall the loan. And having recalled the loan, they, my lord, say you are NPA. So, my lord, the writ petition was filed by me challenging the NPA. Because, my lord, obviously, my lord, the 13(4) steps have not yet been taken. So, I can't, my lord, make an application under Section 17 to the Debt Recovery Tribunal. So, my lord, at the juncture, when, my lord, they issued the 13(2) notice on me, said I am NPA, I, my lord, entered into further dialogue with them. I could not make headway. I've come and filed the writ.
In the meantime, they've taken out Section 13(4).
In this meantime, my lord, they've taken out, my lord, the day on which I served them, they read the paper, they returned it to me. I tried to serve them, my lord, by email. They blocked my email. This is a new one, which I have not seen before. They blocked my email. And thereafter, my lord, they, my lord, gave me the possession letter. But, my lord, the, my lord, interesting thing is, my lord, I don't, normally banks are eager to accept money. My lord, I have made an offer to them that according to me, 1 crore 95 lakhs is due to you. I am paying the entire money. Even then, my lord, the proceeding, my lord, for, my lord, the possession notice, my lord, has been given. My lord, this, my lord, is, my lord, the crux of the matter. Now, my lord, if I may just, my lord, show to your lordship, my lord, just a few pages. My lord, if your lordship, my lord, will kindly have, my lord, first the sanction letter, my lord, at page 32. This is, my lord, of 2016, at page 32. Kindly see, my lord, 10th February 2016, my lord, my limit was 7 crore 50 lakhs. My lord, thereafter, my lord, there was another sanction letter in the year 2021, which your lordship, my lord, will find at page 39. So 2021 also, your lordship finds, my lord, that, my lord, the limit is at page 39. It continues to be, my lord, 7.5 crores. Now, my lord, kindly straight away have the 13(2) notice, which is at page 112. My lord, here also, my lord, your lordship will see 13(2) notice. Kindly see at the bottom, my lord, the table
Yes.
at page 112, limit is 750. Outstanding amount is 372. That means, my lord, I am far below the limit. My lord, an account becomes irregular or out of order or NPA when I exceed the limit and it remains exceeded for a period of more than 90 days. So here, my lord, your lordship will ex facie see that, my lord, 7.5 crores is the limit. 3.72, my lord, is their demand. And, my lord, your lordship will see they have declared me NPA. My lord, if your lordship comes to, my lord, the next page, page 13, the date of NPA. My lord, they declare me as NPA, my lord, as your lordship will find from the next page, my lord, paragraph 3, on 30th June 2023. This is the third paragraph at page 113.
Yes, yes.
So, my lord, your lordship will see I am declared NPA at a point in time when my limit is far below, my lord, almost half of, my lord, that of my sanction limit.
Before this date, it had never exceeded.
My lord, it had never exceeded. I'll show your lordship, my lord, the statement of accounts. My lord, I had brought the limit down, my lord. I'll show your lordship, my lord, the letters which I've been writing for the last 2.5 years. That, look here, give me the proper computation. I want to sell some properties, repay your debt. And, my lord, I'll show you.
If the NPA is stayed or set aside, then the premise of the 13.4 goes.
It
32,
goes.
13.4.
My lord, today, my lord, my simple, my lord, prayer before your lordship is, my lord, this 1 crore 95, and I'll show your lordship 1 crore 95, it will be according to them also. 1 crore 95, my lord, your lordship will give me some time, I will put it in, my lord, within 3 weeks or so, whatever. But, my lord, in the meantime, my lord, they can't, my lord, proceed, my lord, by way of, my lord, taking possession of my property. My lord, I'll just indicate to your lordship, I'll just show your lordship, my lord, one or two
Has
more.
been on a very high footing, Mr. Shah, because of the several judgments regarding 13.4, High Court not interfering and all.
My lord, I'll show to your lordship, my lord, perhaps now, my lord.
There are certain circumstances you are right, because after this writ petition was filed on the date of the notice, these things are there.
My lord, my first submission is
subject to hearing everything. Yes.
My first submission is that, my lord, at the point of time when I filed the writ petition, there was no 13.4 step. There was no possession notice.
True.
And therefore, my lord, there is no impediment to the writ being entertained. My lord, I will, my lord, of course, my lord, point out to your lordship also the fact that, my lord, the bank in question, my lord, is Axis Bank. Axis Bank.
Yes.
Is Axis Bank. The Reserve Bank of India, my lord, I had made a complaint to. They have also ignored my complaint. My lord, on that point as to whether my writ is maintainable or not, I have to definitely satisfy your lordship. My lord, primarily I'm telling your lordship that, my lord, and I'll show your lordship, my lord, from my supplementary affidavit, that, my lord, kindly take it from me, as on the date of filing of the writ petition, there was no 13.4 step. There was no possession notice. Now, my lord, kindly have, my lord, the bank's letter.
Yes.
My lord, kindly have two letters, my lord, one at page 110 and one at page 111. I have already showed your lordship the 13.2 notice, my lord, which is 112. But kindly, my lord, take, my lord, two letters before that. Kindly first, my lord, take, my lord, 110. My lord, this is my letter to them. Further to our email of 27th June. So, my lord, I have been writing to them regularly, and I am going to annexed all these letters also. Further to our email of 27th June, 28th June, we regret that you have till date not reversed the penal interest and charges debited in the account. Consequently, we are unable to remit the outstanding dues in full and final settlement so as to enable you to treat the matter as closed. So, my lord, I have been wanting to, my lord, make payment. I have been saying that, my lord, you are not entitled to charge me penal interest on interest. And therefore, my lord, I have complained that you are not, my lord, letting me settle the account. Then, my lord, since nothing has been heard, we have at our end undertaken the exercise and find that between so-and-so to so-and-so you have debited. Now, my lord, is the list of all the wrong and improper debits that they have made. This letter, my lord, is unreplied to. So I have taken, my lord, the trouble to, my lord, specifically point out all, my lord, the penal interest and unauthorized debits made. Now, my lord, kindly have the next page, page 111. My lord, this is, my lord, of my letter of 30th August. The previous letter, my lord, which I showed to your lordship at 110, was of July. Nothing moves. Again, my lord, I am writing to him in August, 30th August. Mr. Vivekananda, your attention is invited to our email of 5th July, requesting reversal of 1 crore 18 lakhs and offering 254 in settlement. My lord, this is actually should not be in settlement. His settlement, my lord, is perhaps conveys a wrong impression. This is what the bank is entitled to receive. Regretfully, response to our offer was as follows. Please note that the account is already turned NPA and the account will be managed by a separate recovery team. That's, my lord, the response. Since we have, my complaint is that you have wrongly classified me as NPA, and his response is, since I've already classified you, the recovery team will now deal with it. The respective teams will contact you for further this thing. Since we have been awaiting your team for resolution as assured by you, unfortunately, though we are ready and willing to make payments since 5th July, despite expiry of 54 days, nobody has contacted us. Then, my lord, kindly skip over the next paragraph, the paragraph after that. Significantly, you on the one hand are continuing to retain charge on immovable property presently valued at more than 15 crores and are not considering our grievances and resolving the matter, which would help us to unlock the value and explore other avenues for raising funds, so and so. Then, my lord, the penultimate paragraph. In the above matter, we finally approached you to reverse 1 crore 18 lakhs and accept 254 in final settlement, failing which we shall have no other alternative. Now, my lord, even thereafter, we have, my lord, made payment, my lord, of a further sum of about 54 lakhs and brought it down to 195. My lord, that letter I'll show to your lordship. Where is that letter? No, that is there. That is there. I've seen it myself. My lord, I'll just show your lordship, my lord, the relevant letter. So, my lord, my lord, if I may, my lord, just indicate a few page numbers. Or, my lord, may I, my lord, start by showing your lordship one more page and thereafter I indicate the page numbers. Kindly have page 87. This is, my lord, the recall notice. Yes. Kindly see, my lord. This is a March 2023. Facility is 1.80. Outstanding is, my lord, 399. 399, my lord, and next page, page 88. Under these circumstances, we, Axis Bank, hereby call upon you, being the borrower, to pay the outstanding 399, so and so, along with further interest. And then the last paragraph, if you, in case you fail to comply, my lord, will be constrained to invoke guarantees to recover the overdue amount from the promoter's guarantors. So, my lord, the message that is being conveyed perhaps is that, my lord, once I have made the mistake, my lord, of availing of a loan, I cannot, my lord, get out of the clutches. Now, my lord, as the question as to whether, my lord, this penal interest can be claimed by them, my lord, I am, my lord, armed with, my lord, Central Bank Ravindra, which says, my lord, that interest on interest, my lord, on our penal interest, my lord, cannot be charged. But, my lord, these are, my lord, this 1 crore, my lord, I'll tell you, lordship, the entire dispute is about 1 crore 18 lakhs. Now, my lord, whether, my lord, they can recover this 1 crore 18 lakhs or not, this, my lord, has to be adjudicated. And the adjudication, they will have to, my lord, make this claim in an OA application that will have to be gone into by court, adjudicated only then, my lord, they can, my lord, ask for it. They cannot, my lord, I can understand, my lord, a 13-2 notice being given, and, my lord, I've replied to the 13-2 notice. My lord, I've said, my lord, that you can't charge penal interest. I've told them, my lord, that I am ready and willing to make payment of the balance amount. My lord, kindly, my lord, for a moment, my lord, take my, where is the reply to 1302?
Page 124.
Yes, that is the one I'm looking for, I think. Yes. My lord, kindly, my lord, now take my reply to the 13.2 notice, which is at page 124. And my lord, kindly, my lord, kindly, my lord, permit me to also take your lordship, my lord, straight away, my lord, to page 125, penultimate paragraph at 125. My lord, I have even quoted, my lord, Central Bank of India versus Ravindra. I have given, my lord, the citation. I said, in terms of this judgment of the Supreme Court, you cannot charge me this penal interest. Thereafter, my lord, if your lordship kindly turns, my lord, 2 pages over and comes to 127, my lord, kindly see the chart at 127. This is why I say, my lord, my present due, my lord, is, my lord, your lordship has seen the 13.2 notice, my lord, they claim 399. Then, my lord, we are saying that this, my lord, 1 crore 89, my lord, was, my lord, this 19 lakhs, 29 lakhs, 63 lakhs, 41 lakhs, my lord, these are all interest on interest. So, my lord, I am saying that my liability is 247. Then, my lord, 2 paragraphs after the chart. Out of that, my lord, I have again repaid, my lord, 54.55. And therefore, my lord, my contention in my reply to the 13.2 notice is that, my lord, I am liable now only to pay him 192, which, my lord, I have been repeatedly offering to do, and which, my lord, he says that since we've already declared you to be NPA, you have to make payment of the entire due. Now, my lord, whether I will make payment of the entire due or not, my lord, your lordship, my lord, will resolve it here and now. Send me to a OA, do it here, my lord, in the jurisdiction. My lord, I don't have, my lord, any problem with that. But, my lord, I cannot, my lord, my lord, I am a borrower who wants to pay. I have shown my bona fide by paying, my lord, the entire loan. I have been, my lord, prying myself horse, my lord, that I want to repay the entire amount. Even when the dispute is going, I paid further 54 lakhs of rupees. Now, my lord, kindly see, my lord, the manner in which they now treat me. My lord, kindly permit me, my lord, to hand up the supplementary affidavit, my lord, which where is the notice? The supplementary affidavit, my lord, kindly, my lord, kindly, my lord, take my pleadings at paragraph 3, or paragraph 2, 3, 30th November, Mr. Suraj Mondal, representative of the petitioner's advocate, went, my lord, to serve. He met the security guard who asked him to go to 4th floor, meet Mr. Amitabh Mukhopadhyay. My lord, Mr. Amitabh Mukhopadhyay, my lord, inquired about the purpose of his visit. He said what was the purpose of his visit. Then, my lord, Mr. Mukhopadhyay made him wait for 40 minutes. Thereafter was sent to, my lord, meet Shreya Dasgupta on the 3rd floor. Shreya Dasgupta, my lord, took a look at the letter. After going through the same, refused to accept on the ground that it is more than 530. Then, my lord, I came back. My lord, we immediately, my lord, paragraph 4, by an email of November 30, 2023, my lord, at 7:42 from the email address of so-and-so. Kindly see, my lord, sent, my lord, to Shreya Dasgupta. My lord, this is, my lord, the novelty in this matter. My lord, here your lordship will see, Shreya Dasgupta responded by an email dated 30th November at 8 p.m. denying the contents. Then, my lord, at 8:37, Ramendu, my lord, again forwards the writ petition. And that has been blocked. It comes back, my lord, with the endorsement, which your lordship will find, my lord. My lord, the last 3 lines at page 4. Custom mail flow rule created by administrator at Axis Bank has blocked your message. Message size is greater than the permitted limit. My lord, your lordship will see this writ petition, my lord. It's small writ petition, my lord. Not even many annexures. Thereafter, my lord, your lordship will see. Immediately thereafter, my lord, the 13-4 notice, my lord, is issued. Where is the 13-4 notice? My lord, the last page, my lord, is the 13-4 notice. It is, my lord, dated 1st December 2023. Where, my lord, they, my lord, set the 13-4 machinery, my lord, in motion. So, my lord, your lordship will find, my lord, from this affidavit also, my lord, this, my lord, I don't know, my lord, normally, my lord, one does not, my lord, find this sort of a situation because, my lord, but, my lord, this is, my lord, one of those things, my lord, where, my lord, your lordship will kindly see, my lord, that, my lord, I want to pay, I am ready to pay, I have the money. Even today, my lord, I am, my lord, making a statement before your lordship, my lord, that I would want to pay within whatever time your lordship allows me. My lord, I've taken instructions, my lord. My prayer is, my lord, for about 3 weeks, but, my lord, I'll abide by whatever, my lord, your lordship says. But, my lord, at this juncture, my lord, to, my lord, persist with the, my lord, with the 13-2 notice, and, my lord, brand me as an NPA, send, my lord, my name to, my lord, the SABYL, my lord, brand me to be a defaulter, and then, my lord, take possession of my property. My lord, now they have taken symbolic possession of my property. Yeah, my lord, thereafter, my lord, they will, my lord, proceed, my lord, before the
yes, what do you say?
The first, the hurdle of maintainability has to be crossed, your lordship. Even if, as on the date of filing of this writ petition, which was filed on 30th November, there was no 13-4 notice. But still, this writ petition should not be entertained, your lordship, because 13-2 is the very basis on which the further steps under 13-4 are being taken. And moreover, even the Honorable Supreme Court in the judgment of Naveen Matthew, the similar case, even the proposed steps, against the proposed steps, writ petition under Article 226, the Honorable Court should not entertain this financial dispute, your lordship.
Cite that, please.
I'm citing, I'm handing over.
Very good. Just make your point.
Yes,
Yes,
your lordship.
yes.
Secondly, your lordship, the disputed question of facts are involved here. What is, as per the petitioner, 1 crore and 87 lakhs is due. As per the bank, 3 crore 72 lakhs is due. The disputed question of facts cannot be resolved in writ jurisdiction, your lordship, because it needs appreciation of statements of account, other evidences, what were the terms and conditions for sanction. That I most humbly submit, it cannot be done in the writ jurisdiction, your lordship. Moreover, there are authorities which has, there at the debt recovery tribunal as well as banking ombudsman, though they have approached for namesake, but has not given proper opportunity, means proper time to the banking ombudsman to resolve, to entertain their alleged grievance. The complaint to the ombudsman is made only on 24th November, and within 6 days, this writ petition has been filed. So this itself is premature, your lordship. And this, if I may say so, that this complaint was basically only made in order to make RBI as a party and in order to raise a grievance that my complaint was not entertained. However, the primary idea of this making complaint was that so that a writ petition can be made to entertain here, your lordship. The primary relief which has been sought for is ultimately cancellation of 13-2 notice, your lordship, which under writ petition, I most humbly submit that cannot be granted such relief, your lordship. So if I may cite this judgment of Naveen Matthew, lordship, 2023's judgment, I'm just citing the last 2 paragraphs. Paragraph number
2023 SEC online.
Yes, your lordship. 2023 SEC online 435.
Yes.
The second last page, your lordship. This is the subparagraph 21. It is cited from another judgment, that is Travancore versus Matthew Casey. That has judgment been quoted. Similar situation arose here also, your lordship. Applying the law laid down by this court in State Bank of Travancore versus Matthew Casey, such and such, to the fact
on hand, we are of the opinion that filing of writ petition by the borrowers before the High Court under Article 226 of the Constitution of India is an abuse of process of the court. The writ petitions have been filed against the proposed action to be taken under Section 13(4), Your Lordship.
As a NPA declaration, can the DRT go into?
Yes, Your Lordship. Can go into, can adjudicate, because it requires appreciation of statements of account. If they are claiming that I have wrongfully classified, my account was
Because it
payment
leads
was
to
being
the
neglected.
13(4) action ultimately.
Yes, Your Lordship. So that everything DRT is empowered to adjudicate under Section 17, Your Lordship.
Why did you take this action? I mean, the date on which the notice was sought to be served on you, you issued the 13(4) to frustrate this proceeding.
No, Your Lordship. If I join issue here, Your Lordship, because this 13(4) action is not taken in one day. This is just a coincidence that on 30th November they filed a writ petition, because this needs approval and this takes a process. 13(2) was way back 11 September, Your Lordship. It cannot happen that at the evening 5:30 they are going to serve a writ petition and on the next morning the bank goes and affix a 13(4) notice. It does not happen, Your Lordship. It takes minimum a week's time so that the approval is taken from the senior management at every step. So this was already proposed, Your Lordship. It is a just coincidence that on the 1st December it was affixed and on 30th November, a day before the writ petition is filed, Your Lordship. So this judgment ultimately, Your Lordship, the Honorable Court in the final paragraph has held that the court should be quite diligent while entertaining this sort of financial disputes under Article 226. The reliefs not to take possession, when here also the outstanding is more than 3 crore as per bank. So granting an order of injunction that bank should not proceed with the further action, Your Lordship, this should not be done. This has been clarified by the Honorable Apex Court. So this writ petition is also premature because RBI no time frame, no time has been given to the Reserve Bank, to the Ombudsman, to entertain the complaint or to pass a decision, Your Lordship. At least sufficient opportunity was to be given so that the Ombudsman can entertain the complaint and pass their decision, Your Lordship. That has also not been done, and this should not be entertained in view of clear in view of the clear judgments of the Honorable Apex Court, Your Lordship. Moreover, the property which is subject matter of this dispute, Your Lordship, is situated within the jurisdiction of DRT 3, which is regularly functioning, Your Lordship. So this is also not a case that there is no non-functioning of DRT, Your Lordship. So this writ petition should not be entertained, Your Lordship, because disputed question of facts cannot be decided here.
Yes, Mr.
Only one small thing.
Yes.
Normally we still fall back upon Whirlpool. I am sure your Lordship has considered Maharashtra chess. May I just এটা তোমায় দিয়ে দিই আমি 2020 volume 13 SCC 285. Kindly have paragraph 13. I think this is indicative of the new thought process of the Supreme Court with regard to alternative remedy. Kindly have paragraph 11 at 292. Article 226 of the Constitution confers on the High Court the power to issue writs and consequently the jurisdiction to entertain actions for issuance of writs. The text of Article 226 provides that a High Court may issue writs for enforcement of fundamental rights in Part 3 of the Constitution or for any other purpose. This is emphasized. A citizen may seek out the writ jurisdiction of the High Court not only in cases where her fundamental rights may be infringed, but a much wider array of situations. Lord Coke, commenting on the use of writs by the courts in England, stated, "The Court of King's Bench hath not only the authority to correct errors in judicial proceedings, but other errors and misdemeanors. Tending to breach peace, oppression of subjects, or facing faction, controversy, debate, or any other manner of misgovernance, so that no wrong or injury of public or private can be done. But this shall all be reformed by punishment in due course of law." Then, if your Lordship will have 13 or 14. 13. The role of the High Court under the Constitution is crucial to ensuring the rule of law. throughout its territorial jurisdiction. In order to achieve these transcendental goals, the powers of the High Court under writ jurisdiction are necessarily broad. They are conferred in aid of justice. This court has repeatedly held that no limitation can be placed on the powers of the High Court in exercise of its writ jurisdiction. In Venkateshwaran, a constitution bench of this court has held that the nature of powers exercised by the High Court under this writ jurisdiction is inherently dependent on the threat to the rule of law arising in the case before it. Then, my lord, paragraph 14, or my lord, just my lord, after my lord, the paraphrase portion. The power of the High Court in exercise of writ jurisdiction cannot be circumscribed by strict legal principles so as to hobble the High Court in fulfilling its mandate to uphold the rule of law. While the powers of the High Court may exercise under its jurisdiction are not subject to strict principles, two clear principles emerge with respect to when a High Court's jurisdiction may be engaged. First, the decision of the High Court to entertain or not entertain a particular action under its jurisdiction is fundamentally discretionary. Secondly, limitations placed on the court's decision to exercise or refuse to exercise its writ jurisdiction are self-imposed. It is well-settled principle that the writ jurisdiction of the High Court cannot be completely excluded by a statute. If the High Court is tasked with being the final recourse to upholding the rule of law within its territorial jurisdiction, it must necessarily have the power to examine in any case before it and make a determination as to whether or not the writ jurisdiction is engaged. Judicial review under Article 226 is an intrinsic feature of the basic structure of the Constitution. So, my lord, that is, my lord, my reaction, my lord, to my learned friends, my lord, question.
I'll put this on hold. I'll pass my orders. I've heard you on interim orders only.
Yes, yes.
If I hold it not to be maintainable, then I'll reject it maybe. But otherwise, it is only for the question of interim orders. I'll pass my orders day after tomorrow at 3.
I'm grateful. Tomorrow I'm in a difficulty, my lord, in any event. My lord, the other matter, my lord, may be called on tomorrow. I'll try to join virtually, my lord, in case, my lord.
Yes, yes.
I'll pray for a small accommodation.
I'll put it day after tomorrow for passing orders.
Yes. I'm grateful.
Heard learned counsel for the parties on the question of issuance of ad interim orders pushed up. The matter be placed at the top of the list on at the top of the list on December 6, 2023 for passing orders.
Great.
Naveen Matthew is the recent one on this part.
Right. I'll look into all. These are ultimately what we make of it.
Affidavit
of service filed today be kept on record. Affidavit of service and supplementary affidavit filed today be kept on record.
Great.
Yeah, okay.